we hope the students, you don't only vote on SRC, you also vote on mainstream. As we're going to local government elections on the 4th of November, you can help us deal with the issues of traffic here in Western Cape by voting correctly. I will not tell you what is correctly, but I'm sure you know what will be correctly in this instance. Good morning, members who are Deputy Minister Dube Ncube, who's online, and members who are also joining us online. I saw Honorable Ngubane, I saw Honorable Zondo. I'm trying to see who else. Yeah, those are the members who are here. We do have apologies. Deputy Minister Gondwe sent an apology. She won't join us today. And I hope wherever she is, she's not calling for the dissolution of CITAS and NSFAS. We're hoping that she won't do that, because she will literally be saying to the president who appointed her that she does not agree with the appointment, because the president appoints you, minister, to go and deal with the issues that he has outlined in the SONA. And then if you go there and say you don't agree with those things, you are literally saying to the president must relieve you of your duties. It's a matter that will ventilate with her. We don't think that was indeed proper to do. We do have apologies of members who come from small constituencies like Honorable Christians, whose flights from Cape Town, the only ones. So they will have to leave early, around 2-ish, or lunchtime-ish, and Honorable Khabo as well would leave earlier. Honorable Governor as well. Honorable Msezana as well. So the whole committee is leaving around. Oh, I knew Honorable Lonzo will not want to leave. So yes, so members, those are the apologies. I think, we have Tandi Prof. Lewin, who will arrive slightly late. She's also affected by the Cape Town traffic. And that is why when we say people must register to vote and vote correctly, this is what we talk about. This is what we want to address, Dr. Christians. So members, today we are... So members, today we are meeting to get a briefing from the ministry on the decision that would have taken on the 4th of May to place the National Student Financial Aid Scheme under administration in terms of Section 17 of the Act. You'll remember that this is a meeting that we're supposed to have on the 19th of May, and we could not have it because I had to postpone the meeting on the basis that we did not have a presentation. And Honorable Lonzi went on media and said I postponed the meeting on WhatsApp, which was not true. But we are here. The minister did indicate that time that he is willing to come and present, and we are happy, Minister, that indeed you are here. That meeting that we had on the 20th of May had said that I must get a legal advice on how we will ventilate on the issues, noting that after we're taking a decision to call the meeting and bring the former board members, there was a court matter, there was a court issue that was rolled, and I'm told it's sitting next week. So I had written to legal to get a legal opinion on how we can navigate around these issues without necessarily ventilating on issues that will be ventilated in court. So online, we do have our legal Fatima Ibrahim, who's online, who's going to take us through the legal advice that they've given on how we can navigate around without necessarily venturing into issues that will be ventilated in the courts. So we will give her before we start, but we're now going to give everybody an opportunity to introduce themselves. So when you introduce yourself, you know, members, you'll say your full names, your designation, and the institution that you represent. So I will start, and then I'll start with Dr. Arens, MMP, Anele. Then we'll start this side, Matsepo, with you, and then we'll go this way, and then end here with the minister. My name is Tebo Kholitsie. I'm a member of Parliament, a member of this portfolio committee, and I am the chairperson of this portfolio committee.
Good morning, Chair, members, Minister, DG, and everyone in the House. Agnetha Aronson, and I'm the researcher for this committee.
Good morning, Chairperson, members, Minister. I'm the Content Advisor for the Portfolio Committee on Higher Education. Mamparo Mudiba.
Good morning, Chair. Good morning, everyone. My name is Anele Kabingis, and I'm the Committee Secretary. Thank you.
Good morning, Honorable Chairperson. Good morning, Minister, members, and colleagues from DHET. My name is Matsepo Sidat, and I'm the spokesperson to the Minister of Higher Education and Training.
Good morning, Chairperson. Good morning, Deputy Minister, DG, honorable members, and colleagues of DHET. My name is Sipoga Zicele from the Office of the Deputy Minister, and I'm Admin Assist in the PLO unit. Deputy Minister Dr. Dube Ncube.
Good morning, Chair. Good morning, honorable members. Good morning, Minister, senior officials of government. My name is David Mohlame, Parliamentary Liaison Officer in the Office of the DG.
Good morning to everyone. My name is Linanda Beni. I'm coming from CPUT.
Good morning, everyone. My name is Awetu Mkolwana, a CPUT journalism student.
Good morning, everyone. My name is Yongama Georgia. I come from CPUT. I am a second-year student journalism.
Good morning, everyone. My name is Sifo Makuhle, a second-year journalism student from CPUT.
Abra Barbia, SABC News.
Good morning, everyone. I'm Andisa, multimedia journalist from Media 24 Netwerk. So it would be nice, Minister, if you also answer in Afrikaans.
Morning, everyone. Nasipi from Newsroom Africa.
Morning, everyone. Morning, Minister. Siyabonga Koni from Daily Maverick.
Good morning, everybody. My name is Sinead Payne. I'm a journalist with News 24.
I'm standing in for ECOMS.
Good morning, Chairperson, Minister, and members of the committee. My name is Richard Ramashia. I'm a former member of the dissolved NSFAS board.
Good morning, Chair. Good morning, Minister, members. My name is Dr. Joanna Maputa. I'm a former board member of NSFAS.
Greetings, Chair. Greetings, Minister. Greetings, DG. Greetings, honorable members, journalists, and everyone who's here. My name is Sianda Mngadi. I'm the former board member of NSFAS. Thank you.
Morning, Chair. Morning, everyone. I am Tando Xolo Potoman. I'm a committee assistant.
Good morning, Chair, Minister, members, everybody here. I'm Tanya Kleinans, Executive Secretary to Honourable Letsie.
Angibingelele kuwe sihlalo umphathiswa nabo bonke abasivakashele. Igama lami ngumnqobo kaMsezana. Ngiyilunga lale portfolio committee, ngilunga leParliament elithunyelwe umkhonto wesizwe party. Ngibuye ngiserve njengo deputy chair or unopposed in this committee. Ngiyabonga.
No, thank you very much. Good morning, everyone. Let me also appreciate the presence of the administration led by the minister. My name is Khaulatli. The surname is still Khabo, Honorable Manamela. I'm a member of this portfolio committee. Thank you very much.
Good morning, colleagues. Dalmain Christians, member of the portfolio committee.
Good morning, Chair, Minister. My name is Sihlelonzi, member of the committee.
Ngibulisa wena sihlalo malungu committee abekekileyo mphathiswa ne department yakho igama lami ndinguyanga wakwagovana ndilunga le committee.
Good morning, everyone. My name is Ashley Koike, the first Souls, and I am a full member of this committee. Thank you.
Ke a leboha modulasetulo ko dumedisa ko hlomphe tulo sa hao le ditulo tsohle tsa ditho tsa parlamente. Mmoho le wena minister le batho ba lefapha, lebitso la ka ke Karabo Lerato Gagau. Ke setho sa parlamente le setho se feletseng sa komiti ena ya ke tsa molao. Ke a leboha.
Age modulasetulo maloko a committee ka leina ke nna Sedukalno Tshepolo ke leloko la committee ya education.
Ngubane.
Good morning, Chair. Morning, colleagues. Morning, Minister and DG and all the officials from the department. My name is Sihle Ngubane. I'm the member of this portfolio committee.
Morning, Chair. Morning, Minister, DG, honorable members and colleagues. I'm Fundiswa Sotenjwa, Acting Chief Director, University Education Branch, Department of Higher Education.
Advocate, could no, there's a bad DG will help you. Yeah.
Good morning, Chair. Good morning, Minister, DG, and members of the committee. My name is Ndomzi Zodwa Kuta. I'm the Chief Director responsible for legal at the Department of Higher Education and Training. Thank you.
Mphathishlalo hloniphekileyo. Ngiyakubingelela. Ngihloniphe bonke abahlonishwa namalungu ekomiti lezemfundo ephakeme. Ngibingelele umhlonishwa uminister nabo bonke abaphelezele uminister kwithimba le Department of Higher Education and Training. Ngonkosinathi wabasishi ngumqondisi jikelele. Thank you.
Thank you, Chairperson, members. My name is Bhuti Manamela, Minister of Higher Education and Training.
Well, thank you very much. I think everybody has introduced themselves. Deputy Minister Dube Ngube, if you can please introduce yourself.
Good morning, Chairperson, and good morning to the Minister and all other honourable members. My name is Dobsa Dube Ngube, Deputy Minister of Higher Education and Training.
No, thank you, Deputy. I think you must go see the doctor. Go see the doctor. We did get an indication that you will join us online because you are not feeling well. Please go see the doctor. Fatima? Oh, hold on before Fatima. Honorable Maimela? Okay, if you can just mute Deputy Minister. Deputy Minister, if you can mute. We know the tonsils are not nice. Honorable Maimela.
Thank you very much, Chairperson, and good morning to yourself and the collective members of the Portfolio Committee. And we do wish the Deputy Minister speedy recovery. My name is Joy Maimela. I am an alternative member of this Portfolio Committee. And, okay, I wanted to say the contesting Deputy Chair, but I'll leave that. Thanks.
No, thank you, Honorable Maimela. I know that you are on study leave, and that is why you are not here. I was going to say your apology that you are on study leave, but we are very happy that during your break in studying, you've managed to join the committee. Honorable Zondo.
Thanks, Chair. Greetings to you, Chairperson. Greetings to honourable members of the committee. Minister, Deputy Minister Mkhawami, Abengona Lulami Mkhawami. Colleagues, my name is Sanele Zondo, a member of this portfolio committee. I know, Chair, when I'm holding a position, I make it look like it's easy to be in that position, so everyone feels that he can do it, you know. So that's why I'm not surprised. But thank you very much. Thank you very much, Chair.
Yes. Members, we are attending to the sound on virtual. It's a bit low. We've asked technical to help us. But Honorable Zondo was saying, as the deputy chair makes that position look easy. That is why everybody wants to be called a deputy chair. To those who did not hear. Fatima?
Good morning, Chairperson. It's Fatima Ibrahim from Parliamentary Legal Services. Chair, should I proceed just to give a brief overview of our opinion?
I will let you know. We're just allowing people to introduce themselves
So
first.
introduce themselves. All right. Thank you, Chair.
Yes. Jason?
Good morning, Chairperson. It's Jason Felix here from Unit 24 and Network 24.
Who else? Lavan? Lavan Gopal.
Greetings, Chairperson.
Yes. You can go ahead. You have muted yourself again.
Greetings, Chairperson. Greetings, Minister, all the members of the committee, and all present. My name is Lavendran Gopal. I'm a member of the dissolved board. Thank you.
Lucanyo. Okay. I don't know who Lucanyo is. Portia. Yeah.
Good morning, Chairperson and the committee members and the Minister. I am Portia Loilane, a member of the dissolved board. I would have loved to be there, but I've got a very bad flu. Thank
Okay.
you.
Okay, get well. Spokazi.
Good morning, Chair, honorable members, Minister, DG, and colleagues. My name is Poa Zigana. I'm the ANC caucus researcher. Thank you.
The sound was a bit low, but she said she's the ANC caucus researcher. And Honorable Ngubane, this one, we're not asking them to give us money. You know your problems there. Siputu.
Good morning, Chair, Minister, honorable members, the DG and colleagues. My name is Siputu Mampani from University Education Branch. Thank you.
Spiwe Kumalo.
Good morning, Chair, Minister, DG, honorable members. I'm Spiwe Kumalo, former NSFAS board member. Thanks, Chair.
Mnigeni.
Good morning, Chairperson and colleagues. Minister, Deputy Minister, my name is Mligeni Pagati in the Office of the Deputy Minister. Thank you very much.
Okay. I think we've got everybody. I don't see anybody who have not called. Yes, so as I said, members, we are meeting here to get a briefing from the minister about the decision he took on the 4th of May to place National Student Financial Aid Scheme under administration. So we will, like I said earlier on, I have asked for a legal advice. So we are going to give to Fatima, hola, this side. Former board members, if you can just sit here, because when members ask you a question, at least you must not be behind them. If you can just enter here, there's about 4 seats here in the middle. So before I give you, Minister, I'm going to give to Fatima to take us through the legal advice that they've shared with us. Fatima.
Thank you, Chairperson, and good morning to yourself, the Honourable Minister, and all other members and staff present. Chair, I won't be too long. In brief, the legal question was whether Rule 89 of the National Assembly rules, which give effect to the common law principle of sub judice, is applicable to the interaction that's going to be taking place today. For the benefit of those that are not aware, in a Rule 89 provides that no member may reflect upon the merits of any matter on which a judicial decision in a court of law is pending. And sub judice, it's really just a Latin phrase meaning under judicial consideration. And it denotes that a matter that is being considered by a court or judge and restricts public comment then that which may be prejudicial to the administration of justice. So in effect, the effect of Rule 89 is that it was ordinarily understood to amount to a prohibition against members from making reference to any matter before the courts. And the rule, when it was drafted initially, was intended to promote the respect of the judiciary, adherence to the doctrine of separation of powers. But of course, since 1994, we now understand that the Constitution is superior, and therefore any law, any rule has to be interpreted with regard to the Constitution. And Section 42(3) of the Constitution provides that the National Assembly is a national forum for public consideration of issues, and it does this by passing legislation and by scrutinizing and overseeing executive action. So that scrutinizing and overseeing executive action, that is in essence the oversight responsibilities of the committee. It is what the committee intends to do today. There has been some case law, not specifically related to Parliament necessarily in the context of a committee and a meeting as is taking place today, but we do have case law on how to interpret the principle of sub judice. As I mentioned, it's also a common law principle, so it wouldn't just apply in the parliamentary context. And the leading case that we have is a case called Media Television versus the Director of Public Prosecutions. And in that case, it concerned a documentary that was being aired in respect of a criminal case that was still pending before the courts. And there the courts made it clear that you would need to show prejudice, and that prejudice must be demonstrable and substantial. So you can't merely say that because there's a rule, you are exempt from speaking about a matter, the media is exempt from reporting about a matter. So conjecture or speculation on its own that prejudice might occur will not be enough. And in that case, the court then allowed that documentary to be aired. In the parliamentary setting, we had a matter in the Public Protector versus the Speaker of the National Assembly in 2022, where again the court had occasion to consider that sub judice principle, where an argument was made by the Public Protector that the Section 194 inquiry could not be considering her conduct because there were other court processes unfolding at that time. And there the court found that the sub judice rule was not applicable because it would have stifled the ability of the National Assembly to hold the Public Protector to account. And that was also confirmed in another case between the DA versus the Public Protector, where the Constitutional Court then confirmed that earlier decision by the Western Cape High Court. So in short, a rule cannot relieve the committee from its obligation to conduct oversight, because oversight is a constitutional obligation. So the committee must continue its oversight. However, it needs to be done in a matter where you're not going to prejudice the proceedings that are happening in the court space. So there is a way in which the meeting can be managed where members can certainly ask questions, get clarity from the minister, try to understand what the rationale was for the minister's decision, the process that unfolded, the opportunities given to the board to respond, the practical steps taken, and so on, but to try to refrain from reflecting on the merits of that. So in other words, from reflecting on whether that conduct was permissible or impermissible, if the members would want to make remarks on those sorts of things, I would just ask him to please bear in mind that you don't want to compromise the court proceedings in any way, but in no way should that be interpreted as meaning that you cannot ask the hard questions. Now, reflections are really your personal attitude towards the matter and your personal views on the matter. And as far as possible, members should try to refrain from airing those and sticking rather to the facts and trying to unpack the procedural aspects of the matter and how it unfolded. Chair, I hope that gives some assistance. It does require the chairperson to closely manage the meeting, and we're obviously available to give further advice as the meeting unfolds. Thank you, Chair.
Well, thank you very much, Fatima. I hope members heard everything, but I hope they heard your last point good, that it will require the chairperson to closely monitor that we don't, I'll give you Honorable Khabo, that we don't, No, that was a good one, DG. There's no comeback. I won't even attempt. Slow, ne? There's no sound. Yeah, maybe let's take a 5 minutes break while we allow technical. I'll give you Honorable Khaba. I noted your hand. When we come back. Yeah? Let's start, colleagues. Honorable Khabo, check if that mic is working.
Hello, yes.
Yeah. No, thank you very much. We had problems of mics who were not working. So I was saying legal had given us the guideline members so that we know we can ask questions on anything except to determine whether the decision was right or wrong, because that is what is in the court. That is what the legal says. Before the mics went off, Honorable Khabo, you had your hand up. Let's hear.
No, thank you very much, Chairperson. I'm just worried. My request is simple, that we allow the legal advisor probably 5 minutes to make a presentation. I'm worried that during a presentation, we could not capture her, in particular relating to her advice. I only captured the last part where she says that the chairperson must make sure that the meeting is correctly managed. Now, I would not want to rely on that because we've got a rich history on and around the interpretation of the law. So I would not want to fall into that trap. If you would allow us, Chairperson, with all due respect, just 5 minutes. Thank you very much.
So you are requesting, well, the last part that you had is the most important part. that that you must allow the guidance of the chair. But on a serious note, you are asking that we ask Fatima to go through. Okay, Fatima.
Thank you, Chairperson. So, in short, the sub judice rule does not prevent members from considering a matter. What it does mean is that you would need to show that there's a demonstrable and substantial risk that a prejudice will occur if the meeting continues. I don't think from the information that we have, and Chair, I must mention that we have not been provided with a copy of the court papers in this matter in terms of the review of that decision of the minister, but it does not appear that in and of its own there would be any substantial risk and prejudice that would occur if the meeting continues. That being said, obviously, members must bear in mind, one, they have a constitutional obligation to ensure that they conduct oversight, and that is first and foremost. But in the manner in which that oversight is conducted, we're just asking that members apply their minds and just be a little bit careful in terms of personal reflections on the state of affairs and what has happened to date. So there's nothing wrong with members asking questions and engaging in the process that was followed, what informed the minister's decision, what sort of information the minister would have had available at the time of making the decision, the responses from the board at the time, if they were given an opportunity to respond, and so on. But rather just to refrain where possible from personal reflections on whether that sufficed or their views on how that process unfolded, if that makes sense, Chair.
Indeed, it makes perfect sense, Fatima. Thank you very much. Minister, we are going to give you to lead your presentation. If you can take us through, Minister.
Thank you very much, Chairperson, for the opportunity to present to the Portfolio Committee and, of course, to the South Africans, the situation at the NSFAS and the stabilization measures that we have introduced on the 4th of May through the appointment of the administrator. there is a presentation that we'll be flighting through, which was presented to the portfolio committee members. I must indicate, I think from the word go, that although there has been a lot of work that has been done by the department in support of and in building up to the decision of the 4th of May, but because ultimately the decision was my decision, I thought that it's prudent that I lead the department's presentation on this matter. The presentation will include an executive summary which frames the decision that I've taken. It also frames the legality of the decision and also the fragility of the institution itself and what I refer to as the cumulative failures, but also our responsibility to stabilization and duty to stabilization of the NSFAS. And then we touch on why the NSFAS as an institution is important, but we also present the background in terms of what has been happening at the NSFAS and our consistent engagement with the institution over time. And in addition, we present the chronology of some of the things that have been happening since I assumed office as Minister of Higher Education. And then we present the legal framework, some of the issues relating to what I refer to in the presentation as the board's defects, which is the substantive board which was appointed on the 20th of February, which I found, the situation which I found when I got into office. And then we also present the legal framework, section 17A to D, looking into the law itself and the status of the board and also what's the best interest and why we've done this, the question of student protection, and then we conclude with what the stabilization plan is and what are the accountability measures and the next step. If you go to the next slide, so when I got into office, chairperson and members, I was confronted with a pile of complaints from especially some organizations within the student movement, but over and above that, was also presented with a legal opinion on the composition of the NSFAS board. The board was appointed in February 2025, and the legal opinion which we sought and received, and over and above that, some of the complaints which included their own legal take on the matter, concluded that the board's composition did not comply with Section 5 of the NSFAS Act. 3 student nominated seats were not filled, but also the finance minister's nominee was not appointed. And one of the provisions which the legal advice emphasized was the criterion which referred to a master's degree, which did not appear in the Act. But also student representatives were added in what the legal opinion referred to as an unlawful co-option process. On the basis of this, as I'll show later, we then had a discussion with the former board around this, and I think I'll speak more around the chronology around those circumstances. But what needs to be said there was that we approached the Pretoria High Court to apply for a self-review, and that application is still pending. Now, the second element is the institutional fragility. There was a comprehensive report that was done by GTEC, which was a rapid diagnostic report which revealed an organization whose operational scale had expanded while institutional resilience had declined. So in 2019, when NSFAS transitioned from a hybrid, meaning grant and loan system, into a purely grant system, we did not reorganize the institution to meet the new expectation. And I think, as honorable members are aware, that there was a process for amendments of the NSFAS Act, which we are seized with as the department and ministry. But that GTEC diagnostic also went further to speak about fragmented manual processes. It spoke about the high vacancy rates within the institution. It noted the poor systems integration, and that basically means that the integration with Home Affairs, with SARS, was almost impossible, which meant that some students who were not qualifying for funding were excluded, but those some students who qualified, those who did not qualify in some instances, and I think we'll show some of the numbers, were included, but some who did qualify were not included in the funding of students, and this was because you need SARS data to be able to determine whether someone meets the 350,000 threshold. And so, this has proved, and that's why you've had, in some instances, I think it gave rise to the concept of defunding of students, because later on, through various forms of verification, the NSFAS then established that some students who qualified did not, qualify. But included over and above the poor systems integration was the decommissioning of Phoenix, which was a legitimate act, but which completely decapacitated NSFAS capacity to collect, loans, but also to administer loans. I think in 2024, former Minister Nzimande announced a 3.2 billion rands worth of funds whose intention was to intervene with regards to the missing middle. So the incapacity of the NSFAS, and I think we've seen the numbers, were only just about, I think, not more than 2,000 students, were granted loans. And even in those instances, those loans were granted through the institution as opposed to an NSFAS-led process. And then Orion, which is the system that NSFAS was using, was functioning without a calculator, which meant that it basically compromised the systems in terms of whether students do qualify, or not, and also a determination, of the eligibility and so on and so forth. And then there was a 46 billion historical loan book, and I need to explain this because immediately after the introduction of the fee-free higher education in 2019, in many instances when NSFAS, I think from there on, when NSFAS would almost on a yearly basis come back to, to the department and to Treasury to get more money, some of the resources which we used to close the gap were resources which were the resultant of the repayment of loans, historical loans. So there were also issues around the historical loan book, which I had consistently raised with, both the board and the administration, and that 46 billion is likely to be, as per the AG, impaired. And what this means is that even though we know who owes the NSFAS and all of that, we're likely to lose, that money. So the recommendations essentially from GTEC was that we need to stabilize the institution, we need to modernize, and then reform. And these for me were quite worrying factors. And I remember in one of the meetings which we had, quite a long meeting which we had with the executives, around the outcomes of that meeting and some of the actions that needed to be taken. Then there is the AGSA's disclaimer audit, of the 2024-2025 financial year, and which identified 9 material irregularities, and what this means, I mean, the disclaimer audit essentially means that the AG says, look, we can't even look at these books. And I know that the NSFAS, the former NSFAS board had indicated to me that this didn't happen in their period, in a period wherein they served as the board, but they were appointed in February 2024, 2 months before the conclusion of that financial year. 2025, yes, 2 months before the conclusion of that financial period. But also, they also had responsibility to act on those material irregularities, even if they didn't happen. But I also think, I mean, imagine, Honorable Msezana, if our president, when asked certain difficult questions around why we don't have houses and all of that, and then they say, no, that's because of the former president, Jacob Zuma. Because we have to take responsibility. So it's a continuum. As an institution, as a board, or as a person who holds office, it's a going concern or something like that. And yes, there may have been those issues, but I think the board itself had a role to play in ensuring that we correct those those material irregularities. In fact, the reports that I have been receiving through the department and contained in the board's own report was that for instance, forensic has not been working for the whole year, which was essentially their response. When we had a meeting with the AG together with the chair and the executive of the board, sometime I think in March, and when we pressed around what is the plan, has anything been done to ensure that we address those material irregularities, nothing came much out of that, and that's why subsequent to that meeting I issued the board with a set of directives that they had to attend to with with specific deadline. But also the AG found that there were issues around data analytics, which were also identified by GTEC. And as I said, so what the AG established was that when they triangulated information with various other data sources, they then established that, for instance, there were 822 deceased students who were funded, and about 14,169 students who were above the income threshold, and then there were also issues of unresolved appeals. Then cybersecurity breach, which I also raised with the executives and the board chairperson. Now, we had a responsibility, I think, given all of these things, meaning the question of the composition of the board itself, which I had already indicated that I'd approached the court for self-review, the GTEC recommendations, which suggested that we need to stabilize the NSFAS, then modernize it, and then introduce some reforms. And then those cumulative failures, I think I need to also emphasize that beyond the AGSA's issues, there were also successive board resignations. I think a week after I've gotten into office, the deputy chairperson of the board resigned. Following that, the chairperson together with 3 other members, and then in May. So in a period of 6 months, we had the substantive deputy chairperson, Sibia, the substantive chairperson, Standa, resigning. We also had other 5 members of the board, including the person I'd appointed as an interim chairperson subsequent to the resignation of Dr. Standa. and then essentially the functioning of the board, you know, in my view, was not was not in a way that I believe would give us the stabilization of the you know, of the NSFAS. So the stabilization then had to depend on administration under Section 17A, which was a statutory response to protect students and also public funds. I think we'll know that we're concluding the financial year, some reports and statements had to be submitted, you know, for audit and so on and so forth. So this is a very fragile period, you know, which could have inadvertently, in my view, affected the proper functioning of the National Student Financial Aid Scheme. I avoided, you know, I acted in order to avoid unlawful institutional drift and also to ensure that no students' prospects are prejudiced by governance challenges or any form of financial or administrative paralysis. So the law provides that I can make that intervention in terms of Section 17A 2D of the NSFAS Act, which I believe is a mechanism that this Parliament has created if the executive authority feels that you know, this needs to be done. And I must indicate that this was not a political fight with the board, but it was a legal governance intervention which was intended to protect the NSFAS and students. Now, we know the constitutional mandate, the right to further education, which the state must make progressively available and accessible through reasonable measures. You know, and I think the country out there, you know, NSFAS touches almost every second household in the country. So when there are things reported in the you know, in the media, particularly the poor and working class students, you know, I mean, most of the historically disadvantaged institutions have a significant proportion of their students being funded by NSFAS. And so when, you know, there are these type of issues that are, you know, reported in the media around the challenges that, you know, they, you know, can persistently, I mean, have or are persistently in the NSFAS. So it raises some concerns as to, you know, will we have this institution, you know, surviving? In fact, although I had said when I assumed office that I'm not a minister for the NSFAS, I strongly believe that stabilization of the NSFAS as an institution will help us stabilize the sector as a whole, because it affects 800,000 or so students, has funded so many of those students. You know, it disburses in or around 50 billion rands, you know, and with a loan book of you know, of 98% about to be you know, impaired or have been impaired. So the NSFAS is important, and I think the concern is justified, and I think it's our responsibility beyond personalities, you know, beyond you know, political influence or political interest. I think it's important that we all, you know, get mobilized towards the stabilization of the NSFAS. The things that have been happening over the years, you know, where we had successive administrations, where we also had, you know, successive boards, you know, require us to soberly reflect on its state and also indicate what is it that, you know, needs to be done. Now, those are some of the numbers as it relates to the audit and governance findings by the AG, the 9 material irregularities, the question of the deceased students and the AGSA data analytics, but also those 14,000 students who were found to be above the threshold by matching you know, data with the UIF and so on and so forth. And then I think an emphasis on the question of you know, of the disclaimer itself, and so these are the interconnected challenges that I believe the you know, the NSFAS had faced. Now, there is, so there's a suggestion that, I think made everywhere, that I woke up one morning on the 4th of May and decided that I'm going to appoint an administrator. But there were things that, there were activities that happened before the date of the, of the 4th of May. And, and those things, include not just the composition of the board, but they also include interactions with the board. Immediately after the then chairperson, substantive chairperson, Dr. Stander, resigned, I convened the board, and by the way, there were concerns that were raised, and I think the portfolio committee itself had invited Dr. Stander to come and appear. But some of the issues that were raised, which I also presented before the board to respond to, that Dr. Stander had raised, also raised some concern, which led to heightened oversight. So even after I had appointed an interim chairperson, there were also a series of meetings. I looked at the number of times that I had an engagement with either the NSFAS board or the executive management of the board since I was appointed, more than 20 times, when we met to discuss either this or that issue relating to the board. The board itself in the financial year met 28 times. So this was, the board's meeting of the NSFAS since they were appointed in February 20, met 28 times. And so, so there was a time wherein, we had to heighten oversight over the NSFAS, engaging them, probing them, but also, supporting them, going with them to engage with Treasury around the 13.5 billion rand, despite some of the challenges which were glaring, which I had also raised with them, in writing, issues around data integrity, concerns by Treasury, and so on and so forth. But all of those discussions yielded, results. But the point which I'm trying to emphasize is that the engagements and interventions, with the NSFAS and the NSFAS board, were quite consistent and heightened oversight. And one of the points which has been raised has been the fact that I think when we appeared, DG, here in Parliament earlier in the year, when we're giving the report on the NSFAS, we said that, in terms of tuition, in terms of allowances, and so on and so forth, that, comparatively speaking, the NSFAS has done very well, Honorable Cezanne, and I think you've also mentioned the point during our debate in Parliament. Now, of course, the board played a role, but it wasn't exclusively the role of the board. And in fact, it had to do with the operations in the board. In December, when I probed around readiness for the academic year 2026, I realized that we will need to give more support to the administration. And that's why, one of the last letters I wrote to the NSFAS was sometime in December, because we're seized with preparing for the academic year 2026, with a response sometime in January, but from late January into and until the end of the academic year, I met with the NSFAS at least a minimum of once a week, sometimes twice, sometimes thrice, and we had, a war room that we'd established in order to deal with, some of the challenges. And I must say that the administrators at the NSFAS and the workers, the staff at the NSFAS, for having participated in that war room was a huge contribution. But we had to provide them with the support, because I personally was quite worried, and I think we need to commend them for that work. But we then show there, cumulatively and progressively, how the situation basically escalated, to the 4th of May. And what I also want to, I think, flag there is the fact that in March, as I said, issued directives to the NSFAS board to act on that based on the issues raised by the AGSA. But I also, because one of the major concerns raised by GTEC, concerns raised by the AG, and so on and so forth, was the issue around the vacancies, especially at a senior level. And so that's why I think in between then, instructed the board to ensure that by the 31st of May, and this was when they were asking me to do a further extension of the acting CEO's contract. So when they asked me for that, I indicated that I'll only extend the contract for up to the 31st of May, and that this will be the last extension that we make, and that they should ensure that they appoint the CEO, a substantive CEO, by the 31st of May. And sometime in April, the interim chairperson indicated to me that he was quite concerned that some of the board members want to go ahead with the appointment of the CEO without having concluded the processes building up to the reports that the board need to consider. And on the basis of that, I agreed, but also some of the board members themselves were asking our stakeholder person in my office that they would like to meet with me. And on the basis of that, we had a meeting I convened a meeting with the board on the 13th of April. And in that meeting, I asked them for a report in terms of the process towards the appointment of the CEO, as the interim chairperson had indicated some concerns. And based on the report that they presented to me, I then indicated to them that that they shouldn't rush the process and conclude the process without having followed all the the processes internally, and that I had actually given them the deadline, and that there is no pressure. In my view, there was sufficient time to meet the deadline that I'd imposed on them, and so they shouldn't, they need not rush the process and even jump some of the some of the processes that they are required, which included, I think, the finalization of the report in their Human Resource Development Committee. Then, subsequent to that, I then received resignations from the interim chairperson and the deputy chairperson. I'll talk a bit about that, and I think I've already emphasized some of the points earlier on this. And then on the 4th of May, after having consulted with the members of the board and listened to their views, I then took a decision to appoint an administrator. So where are we now? There are two matters, one in the Pretoria High Court, which is looking at the self-review hearing, which is, I think, now already scheduled, and then the other in the, I think, Gauteng High Court Division, I'm not sure the name of the court, where the former board members are challenging my decision to appoint an administrator and therefore, dissolve the board. I've already spoken a bit around the, the legal framework, but just to emphasize that at the time the board was dissolved, there were only 7 members of the 18 that are required by the Act, and I think it was also worrying that a chairperson was substantively appointed, a deputy chairperson who was substantively appointed, and also an interim chairperson whom I appointed had resigned in a short space of time. This is in about 6 months, and not only the 3 of them, 4 other members had also resigned, and I think this was quite concerning for me that we are having this situation. So it's not just only ordinary members, but we also didn't have a Minister of Finance. And maybe as a point of emphasis, Chairperson, even with the directives that I had given to to the board itself, the board in its composition should include specific expertise, and I think in this regard, financial expertise is one of the most important element. And I think there was a letter which the interim chairperson of the board wrote to me in February, asking that I fill in the vacancies. But I could not do that because I'd already approached the court for self-review of that decision. So it would have meant that I'm extending an irregularity of the board, and in any way that process itself would have required a fresher process of nomination. And I think some would ask as to why did we not immediately dissolve the board when we got the legal advice in October. The points which I made at the time in November, I think, the points which I made at the time, on legal advice when I met with the board, was that at the time, it would have been, in my view, and having just assumed office, it would have been, in my view, a bit disruptive to dissolve the board, but we're also dependent on what is referred to as the eau de Kral principle, which means that an unlawful administrative act cannot simply be treated as a nullity by executive preference. So I wouldn't just prefer the board itself to be nullified, and that board remained capable of producing legal consequences until properly set aside by a court of law. So my reliance was on the court of law itself. And of course, when I met with the board in November to have a discussion on this, the understanding that I was given leaving that meeting was that the facts are common, in terms of the process with regards to the appointment of the board, and that we should endeavor to conclude the self-review process as speedily as possible. And I hope that those 2 cases are treated differently. So those are some of the points in terms of why we believed and had approached the court on the defects of the board. Now, with regards to administration, the statutory mechanism provides 3 alternative routes to administration. And I must emphasize, Chairperson and members, that the section is disjunctive, meaning that, is disjunctive, meaning that it's alternative and that it's not necessarily conjunctive. And I'll speak a bit about this. But what it essentially means is that any one route is sufficient, of the routes that are available towards the committee. The route A, which was the audit or committee report, an audit of financial records with regards to that part, which is, we believe that it was squarely met given the AGSA's disclaimer. And then the second route, which is any other circumstance, I believe that the board itself, with successive resignation, has led to governance collapse. And then, of course, the board requests such an appointment of an administrator. The board did not request the appointment of an administrator. They did when I wrote to them and asked them to tell me what we should do now. They did say to me that there are various alternatives which I then considered safe of administration. And so what are the automatic effects of that decision? It means that the board is dissolved from the date of the administrator's appointment, and that there is no separate dissolution decision. It is automatic, it is statutory, and that it should be regarded as such. And also that it was done in the best interest, because this, as the law requires, that I may only act if the appointment is in the interest of the NSFAS and of higher education in an open and democratic society. And I believe that I had acted in that regard. So as we stand today, and as I said, of the statutory requirement of 18 members, 12 of those appointed substantively, one, appointed, co-opted by the board through the the then minister's intervention, and another one co-opted by the board. Of all of those, only 7 board members were remaining after the resignations. Now, with regards to continuity, I need to then say, Chairperson, here that the person that I appointed as administrator is Professor Matebula, who is currently who was at the time the head of the Tshwane University of Technology Business School, and who was also the chairperson of the MDDA, appointed by the president, but has also served in various boards, in the last 7 to 10 years. I know that issues that, there has been some issues raised with regards to, Prof. Matebula's, competence and whether he's of a sound mind and all of that. I think that based on his qualifications, but also based on his experience, I believe that he is the right person to help us stabilize, to work in stabilizing the the NSFAS as an institution. Now, continuity measures, it's important to emphasize that disbursements continue. Student funding are operating without any interruption. The schedules are being met. The staff at the NSFAS continue to work to perform their professional responsibilities under the administration. But also, I think, as honorable members are aware, the administrator himself, together with the NSFAS executives, came to to the Parliamentary Portfolio Committee. Also measures have been taken to protect student accommodation, students being potentially being evicted and so on. But also that I must say that the administration is not a permanent intervention. It's a temporary intervention that the law provides for. So we've also made it expressly clear that there is a potential for earlier termination upon the appointment of the board if we believe that the administrator has been able to meet the the requirements, the stabilization measures at the NSFAS. and that the maximum required is 24 months and extended. But the practical aim is to have the shortest time possible for this administration. In the broader sense, we want I expect the administrator to, look at, issues around student accommodation. There has been some, challenges there. Issues around ICT. I think the board had, for some time, I think there was a deadline of September where the board had to meet the deadline for the approval of an ICT strategy. That hasn't been done. Put in place, risk policies and measures which haven't been there, which is something that the AG has flagged. But also deal with what the GTEC recommendation said, which is stabilize, modernize, and then reform. So we're quite looking forward into dealing with all of this. And then there are also legal issues, policy issues, but at the center of it, working together with the department, help us drive a sustainable student funding model. And then there are all of those things. But I think what's important for now is that there hasn't been any disruptions. There has been some concerns, one or two here and there, that were raised around, the protection of the students who are expecting allowances and so on. I think NMU is one of those institutions, a couple of those. And these are not the result of, the administration. And I think the NSFAS has been able to respond to, some of those issues. In terms of stabilization, as I said, operational continuity, but it's also important that we have consequence management, meaning that, we have to have people responsible for certain actions, and then deal with, issues around appeals, deal with, the TVET college closeout report, and I think one or two other universities, deal with audit remediation, the remedial action plan from the AGs, but also deal with issues around data analytics, our integration with SARS, and our integration with Home Affairs. What this means is, one, those who are able to repay their loans, this thing of data integration, those who are able to repay their loans would then be able to do so, which means we have a bit more money in the kitty to to cover any potential shortfalls, and therefore an investment into the country. But it also means that we will not fund people who do not qualify based on the existing criteria. It also means that we will not fund, dead or ghost students. So the question of systems integration, and it's not only just with SARS and Home Affairs. It's also with institutions, TVETs, universities, and so on and so forth. And then the ICT digitalization, to accelerate the approval and implementation of that strategy. We're expecting quarterly reports with and through the DG to the minister, but we're also expecting that they will look internally, of course, first for existing capacity, and where there is a need, source external, capacity. We're expecting an initial stabilization plan to be submitted, and hopefully at the next available time that the committee has. So where to? I think we, are looking at the in the immediate. There's a court hearing, as I said, on the 2nd of June, and I must emphasize that I will respect the court's order, whatever it is, and also there is the self-review hearing, which we expect that would happen by the 31 July, and I think some people will ask, why did we not wait for that? So that process itself, has been lying dormant until we then appointed the administrator. So it's now active because we've received the response from the board, from the former board members, or heads of argument, or it's the court language is a bit, So there's that process, and then there's also, first quarterly reports that we'll be expecting, and also a stabilization plan, PFMA submissions to also be done. The administrator has also already started engaging with stakeholders, meeting with the AG, the SIU, meeting with student bodies, with university vice chancellors, with some in the TVETs. So some of those engagements with the stakeholders is happening. In the long term and targeting 2027, a sustainable student funding model, but also systems in place for the missing middle. This announcement we've made in 2024, and I think it has to be one of the priorities for the administrator. And then the loan book recovery, we still believe that should also be done. And then TVET equity. I was listening, Honorable Chairperson, to Honorable Lonzi, who was waxing lyrical a few days ago about funding TVETs for free. And in fact, this, we agree with you. We considered that, and I think if you look at the HEHA report, it actually expressly had instructed us to do that, and I think it's. I think so. Yeah, of course. No. We fully agree with that, and I must say that it's one of the things which we also considered for this financial year, but because of systems challenges and so on, we had to put it on the side. But we think it's a priority. Equity with between TVET college students and university students, and I think in a much more progressive but accelerated way. And then reconstitution of the board. So as I said, administration is not permanent. And then transition to governance, from administration to ordinary governance. I know we hold a lot of views about what ultimately should happen to the NSFAS. The chair mentioned the deputy minister's speech at the budget vote. NSFAS should shut down. There has also been some discussions. I think the commander-in-chief of the EFF also said something similar. We should just send the money to to universities, and all of that. And what we've said, Chairperson, is that in our discussion, so when we agree on what a sustainable funding model for the NSFAS is, what we also need to then agree is, okay, so this is how we're going to sustainably fund students. What model or mechanism is required? And I think it's fortunate that this discussion is also happening as we're looking at the NSFAS Act. And then, so as I said, then transition to governance, whatever it transitions into, and then a full implementation of the ICT digitalization. I believe that our country has the necessary and available resources and capacity, both within the state and outside of the state, to have proper digital system operating in the NSFAS. We cannot have a situation where in 50+ billion rand is managed on spreadsheets, on on Excel, and so on and so forth. So this should be the standard we believe we should be measured in. This body exists for the more than 800,000 students who in 2026 alone depend on tuition, accommodation, food, and the daily means to study. And if we fail to do this, then we would have failed, those number of students. And this is the standard which we believe any decision about the NSFAS must be measured against. Thank you very much, Chairperson.
No, thank you very much, Minister. So, members, I'm going to note you. I've done a list here for you guys. No need to raise your hands. You know the rules. You direct your question either to the minister or former board members, and they will respond. So your participation, board members, will be in answering questions, and I will take into account members' time when you respond, because you did not do a presentation. So we'll take that into consideration. So we're 12 members, we're many. So we'll give you 15 minutes each. We will take into consideration when the board members answer that they might want to say more, and I'll take that into consideration on your time. Let's not forget the advice from from legal about expressing our views. Let's just establish the facts, and then we'll take it from there. So my list, members, I'll start with you, Musezane. I'll come with you, Lonzi. Then I'll go to you, Khabo. Then I'll give you Ntate Ngubane. Then I'll come to you, Low. Then I'll give Dr. Christians. Then I will give. Then I'll give Younger Governor. I will give Honorable Khachau. I will give Honorable Souls. I will give Honorable Zondo online and Honorable Maymela online. So that will be the format. So Honorable Musazana, I'm trying to start my watch, my clock at 15 minutes and 0 seconds. I would advise that members, you also open your own, because when your time ends, you think my watch ran fast. So I want you to do the same. Sorry, so that we're on the same page. Honorable Musazana.
No, I'm going to ask Advocate. Yeah, Advocate Kuta for now. Just one question, then Chair, probably you'll pause my time until the minister comes back. Maybe just on the.
Let's do this. Let's wait for the minister.
Okay.
We had agreed on 15 minutes. I heard Honorable Khachau, you're asking about the time. It's 15. Oh, and I did say that I'll take into consideration when you ask the board members, because they did not do a presentation. I agree, you know your numbers. So it's Honorable Msazana.
Can I ask a question?
Yes, what's wrong? Joyful?
No. Sorry, Chair. I will switch on my camera, just not now. I just wanted to ask, in light of what you just said now, so that I'm clarified. So the status of the former board members in the meeting is that where we want to ask them a question, we can ask them a question. Is that what you? Because I just want to get that clarity here.
Yes.
Okay, Chair.
Thank you. So the numbers are Honorable Cesar, Honorable Lonzi, Honorable Khabo, Honorable Ngubane, Honorable Low, Honorable Christians, Honorable Governor, Honorable Khachau, Honorable Souls, Honorable Zondo, and Honorable Maimel. So that is the how we're going to. Honorable Cesar, let's start.
No, thank you very much, Chair. Thank you, Minister, for the presentation, Baba. Maybe where I'm going to start, because the time is very limited, Minister. I don't know why. Minister, maybe let me start here. There are two previous administrators at NSFAS before the board that you just dissolved now. There was Mr. Randall Corraleson and Mr. Sitembis of Freeman Nomvalo. The last administrator, Mr. Nomvalo, left the institution without providing a closeout report. That is as far as we know as things stand. We also are aware that he earned a very fat salary there, but did not produce a closeout report. It is also alleged that currently Mr. Nomvalo is now an advisor to one of your other administrators in the SITAs, which is something probably that you might want to confirm. Why is it that do you believe now that an administrator will stabilize the entity when two previous administrators of the very same department have failed dismally to do so?
Okay.
If you could just firstly confirm if what I'm saying is true, that we do not have a closeout report of the former administrator. In fact, even the audit opinion you are speaking about, the disclaimer, is attributed to that very same administrator in the 2024-2025 audit outcome. And that now he's still in the department as an advisor to one of your other administrators in the SITAs. Then you can comment if you think that now an administrator will do the work that the other two have failed.
Okay, all right. Thank you, Honorable Cesar. The first administration was appointed during some instability within NSFAS, and you want me to confirm? Well, I don't have the closeout report. Then Minister also didn't have the closeout report from the then administrator of the NSFAS, but I'll if I may talk to that just now, which is part of, I think, responding to the overall question that you're asking. And that administration, which took place, Randall Carlson, from 2019 to 2020, was basically to stabilize the student-centered model. I think that's when.
Sorry, Minister, could you just not get into the detail? But fundamentally, you said that NSFAS is fragmented, therefore it requires stability through administration. So I was just highlighting that the two have failed to do that, because if they had not failed, you would have not have taken the decision now to put them under administration again. Then I mentioned in particular Mr. Nomvalo Freeman, because he did not submit a closeout report, which means that he was hired and paid, and you do not know what work he did there, because he has a disclaimer. This disclaimer that you are very sound about is attributed to his administration.
Okay, so your question is it's three parts, and if I may respond to it, I mean, you are fundamentally asking me what is going to be the difference with this administration. Yes. Now, so firstly, administration comes in, when whoever is the executive authority believes that there is a need for such an intervention, meaning that the board that exists at the time, and I think Parliament foresaw this when they included the administration clause in the thing. So when a board is unable to, oversee a stabilized institution, so it's not just the administration itself, but it's also the substantive boards. So cumulatively we'd had, since 2019, we had a board that was dissolved, an administration up to 21, and then a board that was put in place, which was then also dissolved. And I think, the issues are, popular. And then Nomvalo was then appointed for a period of 2 years. Of that period, when I came into office, I was made to understand that, there was a dispute between the department and Mr. Nomvalo around the legality of his termination and issues around payments, an issue which is separate, which, I wouldn't want to, explore its details as is now. But yes, I think it's confirmed. I'm aware of the fact that he is working in one of the institutions as an advisor to the administrator at the construction sector.
No, thanks, Minister. I think if I had more time, I'd spend some time there, but because I have many other questions, maybe I'll come back if I still get time. Advocate Kuta, am I saying it right? Yeah. So, can we speak about the legality matter here? The Minister wrote a letter to the board in January indicating that because the matter is before the court, he's precluded from taking administrative action on the board now. So I just want to understand, legally, is the minister correct to dissolve a board when it's before the court on self-review or whatever application that is there in the court currently?
Thank you. Can you hear me? Thank you so much for your question, Mr. Msezan. The question that you are asking is tricky in that the self-review application is different from the administration process. These are two separate legal processes. The self-review process is a process that is initiated by the minister himself. He is taking himself to court to say, can the court make a pronouncement on the appointment of the board? And the second one, which is the administration, is a process that is under another section of the Act, which is 17A, and it is preceded by other processes, which include the directive that Minister sent on the 26th of March, as per Section 4A of the NSFAS Act. So these are two separate processes.
Was the self-review not opposed by the board?
I don't know what you mean by opposed, because if you look at their papers, they do not oppose. They almost agree with everything that is in the minister's affidavit, except one area where they say they should still be kept as a board because they are able to do good work if they are given an opportunity. Thank you.
Thanks, Advocate. I'm not sure which board member might assist us. The minister in his presentation asserted that after having presented the audit outcome of 2024-2025 that is attributed to the former administrator, that nothing was done by the board. I'm going to just, get a sense of understanding from that. what have you done after you had learned that there's this audit outcome presented to you by the minister?
Thank you very much, Honorable Msezane. My name again is Sianda Mngadi. I think it is not true that we have not done anything. So, for example, when the minister issued a directive, we responded comprehensively with a list of a document. For example, we submitted an audit improvement plan, we submitted consequence management plan, we also approved a digital transformation strategy, which we were going to form part of the annual reports that is due recently. We passed a lot of policies in terms of data security, and we were reintegrated back to SARS under this very short period of this board. And we submitted a comprehensive closeout reports. We submitted also a report on monitoring and evaluation of NSFAS accredited student accommodation. We also submitted 2026 application cycle comprehensive appeals reports to the minister. We submitted a board position on the sustainable funding model. All this on the 30th of April, which was in line with the directive of the minister. And the minister, by the way, has never responded to those submissions.
Yeah, no, thank you very much. Minister, could you respond to that, please? Because you did indicate in your presentation, I was listening to you, that the board, you did indicate that you gave him a directive, but you said nothing had been met in that directive. And you had given them deadlines, which you did not say the dates, except the 31st of May, that you said they should have appointed a CEO at the time. Then you mentioned that they were, or you were suggesting that they were rushing the processes, and there were other committees such as the HR committee that had not done their work and presented the board with a report. In fact, maybe before you get in, the HR committee that the minister refers to, that should have done work before it came to the board in as far as the CEO's appointment is concerned. Was there a report that was already presented to the board to consider regarding the appointment of the CEO, asking to the board?
Honorable Msezane, may you please clarify that?
The minister indicated that there is prior committees built up to the appointment of the CEO by the board. So I'm asking if there was a report that was presented to yourselves by the HR committee to consider, or the work that should be done first, which probably is interviews, shortlisting, whatever is done by the other committee. Was it presented to the board for consideration for the appointment of the CEO?
Dr. Maputa will take that on.
Thank you, Honorable Member. Yes, so prior to the board considering the appointment of the CEO, the HR Audit Committee said, and after deliberations, they recommended a candidate. So that was after the deliberations and the work, the process of the panel concluded. So it was presented to the HR Audit Committee. The HR Audit Committee deliberated and then recommended to the board. Thank you.
Thank you very much. So, Minister, the board has at least given us a picture of what is different from what you presented, because you indicated that looking holistically at the work that was being done by the board, you resolved to seeing administration as the resolution to their problems. They've presented what you have not touched on, the work that they would have done. I want you to respond to what the board is saying in terms of that, but also do tell me what you meant when you said they were rushing the process and there would have been work that should have been done by other committees that was not done regarding the appointment of the CEO, because they indicate that all due processes were done, build up to them, then dealing with the process of the appointment of the CEO.
Yeah. Well, thank you very much. I think firstly we must note that the report that is being referred to was sent to me on the I think on the 30th of April, which was the report which was sent as a result of me having asked the board members as to, what are we going to do? We have people having resigned, and so on and so forth. But secondly, what I referred to was that there's an AG's report, not my report. There's an AG's report with, with materiality, and which the board had the responsibility to act on. And subsequent to that age, which they haven't, by March this year, 2026, which referred to the 2024-2025 audit report. So what I'm referring to when I say no action had been taken by the board, I'm referring to the AG's own, which then resulted in me issuing the directive to the board on the 27th of March. And even then, so if we want to get into that report which they gave me on the 30th of March, we can, which at that point, my discussion with the board was, what do we do? You've got all these resignations, what do we do? But if we look into that report which they say they gave to, which the honorable, the former board member is saying, Mr. Mgadi is saying they gave to me, it was process. It was basically reports, around what is going to be done. It was, how we're going to have strategies. For instance, the ICT strategy that they are referring to, they were supposed to have adopted, the board was supposed to have approved it in September 2025. So 7-8 months later, that had not been done until such time that I issued the the directive. But I think importantly, Honorable Msezana, what I want to indicate is that the very same report had indicated, for instance, that supply chain management had not been working. They'd indicated that EXCO had not been functional. Financial committees had not been functional. So even if I considered that report, which they gave me on the 30th of April, together with their quarterly report and their business plan as a board, I do not think that it satisfied me enough in order not to proceed with administration. Thank you.
No, thank you very much. This AG report, when was it released? The 24-25 AG's report.
I'll have to check the actual date.
It was discussed with us before being released.
Yeah. So So we yes, we had a discussion with the AG in March. I think we're on 20 on the I think a day or after we issued the directive to the. So we had sight of it as part of our discussion with the AG, I think on the 26th or 27th of March.
This year?
This year, yes.
Okay.
And I think a few days before, or a few weeks before, the NSFAS together with the department had appeared before Parliament on some of those elements of that report.
Yeah. The reason I'm asking
I just
is,
need to, yeah.
In your response, you're saying they had not done anything on the material irregularities of this 24-25 financial year. But if it's released in March, and then in April we then say they've not done anything, I think it might be a bit unfair if that is the case, unless the material irregularities you're talking about a different financial year.
Yeah, we'll have to check that, Chair. But I think importantly, what I also need to emphasize is the fact that, the board as it stood on the 27th of April, when the interim chairperson and and deputy chairperson, and chair of the HR committee resigned. I had no view that the board, as it was constituted at that point, was properly functioning to the extent that they would have been able to deal with all of those issues. And I think an emphasis should be to the fact that the expertise that the board itself required had already been depleted. Yeah.
No, thank you very much. Honorable Lonzi?
No, thank you very much, Chair. I don't even think I'll be long. So there's almost a public suggestion here, Minister, that at the center of the dissolution of the NSFAS board is your wanting to somehow have some interfere in the appointment of the NSFAS CEO. And it wouldn't be the first time we see that. I think over the years, many ministers have shown us, and the courts of South Africa have actually proven many members of parliament to be correct when the executive is overstepping in matters that the Act would squarely place on the fiduciary responsibilities of boards. So whether it's the dissolution of boards to place them under administration so that a minister can gain total control over the entity, whether it's trying to influence the CEO to put in either comrades or friends or whatever, or anything of that sort. So I want to deal with the meeting of 13 April, because I did also send that letter early in the year, if you remember. Now, my first, maybe let me start as questions so that we can have a proper lay of the land of what that meeting looks like. The first question I'll ask to you, Minister, is, was there a formal meeting invite for that meeting?
Yes, the board members were called by my community liaison officer in my office to indicate to them that I'd like to meet with them.
By formal, I mean, was it sent on WhatsApp? Did you call by phone call?
By
or
phone
did you
call.
send?
By phone
So
call.
there's no letter that the...
Just don't go to WhatsApp again. You're going to say I've
I know
cancelled
the
it.
WhatsApp is loud in the house here. So what I'm trying to establish here is that there's no formal letter from your office to either the board, members individually, or even the company secretary, saying that the minister would like to have a meeting with the board on this date and this venue and that time.
The communication that was made to the board members was made telephonically. And I think just to also emphasize the point that the decision to have the meeting was actually taken on the 11th, and I don't think it would have been practicable to use any other form of communication to invite the board members to to the meeting.
No, thanks, Miss. We'll get there. I'm just trying to establish fact. Yeah. So on the 11th of April, you take a decision that you want to meet an entity, essentially. And then that meeting is going to take place on the 13th of April. Your chief of staff, your PA, your advisor, or anyone, no one thinks that it is correct in terms of administrative justice that when a member of the executive wishes to meet a board or an entity, surely a letter should be drafted, a formal letter should be drafted, even if there is a follow-up by phone call that, company secretary, have you seen the letter from the office of the minister? I just want to establish that no such letter exists where the minister is inviting the board members.
No, there's no such a letter that exists, but I think it's important because so there was communication, and the reason, obviously, as I said, was because of the agency that was occasioned by the nature of the meeting.
All right.
I think it would have been impracticable. I think actually, I think the 11th fell on a weekend. Yeah.
Okay, I'll come that in my closing remarks, but I think a formal meeting should have been done through a formal letter and a formal invite. And I don't think it's impractical. I think if your chief of staff is able to pick up a phone and call about 8 or 12 or 6 people one by one, I'm pretty sure he's able to write a letter in 5 minutes saying the minister would like to meet with the board, with board members. But we'll come to that. Was there a written agenda for the meeting? So when you arrived in the meeting with these board members, were they presented with a formal written agenda in terms of what is it that we're going to be discussing in this meeting?
I indicated to them what we are going to discuss in the meeting. It was not written, but it was verbally communicated.
So another verbal communication. Do we have minutes of that particular meeting?
No, we don't have minutes of that particular meeting.
So members of the board are invited by the member of an executive. There's no formal letter to invite them. They're invited by phone call. When they arrive in the meeting, there's no formal written agenda. The minister communicates verbally. And even in the meeting, there's no formal writing or record of minutes of that particular meeting. You may or may not agree with me, Minister, but the courts of South Africa have made it very clear that when a member of the executive is exercising public power, remember when you are meeting this board, you are not meeting them as a comrade. You are not meeting them as friends. You may know them, in your different spaces, but you are meeting them as a minister, a member of the executive. And administrative justice is very clear that when you exercise public power, we ought to have a public record. And by you not having that record, it places us in a constitutional quagmire.
Look, firstly, the fact that it was someone from my office who communicated with the board members, it was not a friend of mine that I met in Eshabeen, shows that this was an engagement with the board and the minister. And secondly, and as I said, that the agency, that was occasioned by the need for the meeting. I didn't hide why I called the board members. I explained to them why I called them to that meeting. And I don't think that there's also a dispute in terms of the existence of that meeting. It took place in an office of our department. It didn't take place in my house or any of the board members' house. It took place at the offices of the.
But you'll agree with me, Minister, that there's no formal record of the meeting, but in terms of the discussions that took place in the meeting. If Parliament wanted to exercise its oversight responsibility given to it by the Constitution to understand decisions that are taken by a member of the executive, maybe remove yourself as an individual from this.
Yeah.
Decisions that are taken by a member of the executive, part of what would need is a record of the discussions that take place in meetings which ultimately lead to decisions that are taken by members. And we don't have a formal record of that meeting.
I must emphasize, Honorable Lonzi, that the intention of that meeting was not to take any decision, either by the board or myself or jointly. The purpose of that meeting was to get a briefing from the board.
So it was a caucus?
No, it was not a caucus. It was an engagement with the board.
But you'll agree with me, Minister, that
I, as Minister,
even in your political party engagements, that where Parliament does not have any oversight, let's say somewhere in the SACP, or I don't know now, ANC, when you have the meetings, there are always minutes in a meeting, Minister. Because even as your own political party, where we may not necessarily have a role to play, but there ought to be a record of the meeting. This is what was discussed in the meeting. Board member A said this, board member A said this. It's only caucuses where you typically wouldn't have minutes. But in a formal meeting, at least I think we can agree that there ought to be minutes.
No. Like I said, the nature of the meeting, the agency that occasioned the meeting itself. In my view, you know, how the engagement also happened, which was me requiring a report from the board. And I must also emphasize that this was not the first time that I've had, I think I've indicated to you that we've had about 20 or more engagement with the NSFAS or its board members and so on and so forth. You know, I doubt any, you know, not every single one of those meetings themselves you know, would have minutes or record, but it is either precisely because I want to have an understanding of what is happening in the institution, you know, or anything of the sort. And this was the nature of that.
Sorry to cut you, Minister. I've just got little time. Yeah.
So, Honorable Sodana's got his hand up. Let's see what is wrong.
No, thanks,
My
Chair.
hand is up, Chair, on the platform. Apologies.
Okay. I don't see it. I'll come to you, Honorable Maimela.
No, thanks, Chair. It's a follow-up on Honorable Lonzi's question, which I think the Minister's response is not satisfying. The Minister confirms that this was a formal meeting, even though it was communicated informally. But Honorable Lonzi is asking on our constitutional obligation to perform oversight. How do we perform oversight when the meeting was not recorded? So we want to know from the Minister. He says now that they are used to having formal meetings without records. I mean, we are very concerned about even that statement itself. But on the particular meeting Honorable Lonzi is referring to, the Minister must confirm that was it lawful or legislative according to how he runs the department of not keeping records of formal meetings, because now we can't scrutinize what was the discussions or the briefing given by the board in that particular meeting.
Okay.
Can I rise on a point of order?
Yeah.
Chair, I would like to call order on the proceedings of the engagements. You have noted a list of people who will make submissions. And Honorable Msizane has been given an opportunity, 15 minutes to present. And it has now become a tendency that when you are given your time to present, you'd waste your time on issues that are less important. And during our presentation, you'd want to disturb our line of thoughts with follow-up questions. And my understanding is that a person who must present a follow-up question is the person who raised the question initially. Now I'm calling a point of order precisely because of these follow-up questions. They are not in any way aligned to the proceedings of the meeting. Thank you very much.
Honorable Maimela.
Thank you very much, Chair. Mine is also a point of order, Chair. Initially, because perhaps I'm hearing backward, and it's a point of order on the assertions or the utterances by Honorable Lonzi. Honorable Chair, where I'm seated, I don't remember and I don't think Honorable Lonzi has been a member of the ANC or a member of the party. As a result, a reference or an inference on how the ANC conducts their meeting, if we record meetings, how we call our meetings, would actually be out of order for him to make that inference. And I don't think it's in order. I think Honorable Lonzi should not make inference on how the ANC calls meetings. In fact, he should actually make inferences on how they call meetings and how they conduct their own meetings in the party that he belongs to. So I understand his question, but he must not make inferences to the ANC on this question. Thanks, Chair.
No, thank you. Honorable Ngubane.
Yeah, Chair, I would like to as well call an order on Oler Khabo. We've been doing this thing in all the meetings where we do follow-ups. And it has been happening for all previous meetings. So it can't be that on this meeting, when one member has a follow-up, now there is an objection on a follow-up first. And second, Chair, I'm requesting that there be a one chair in this meeting who will correct those follow-up. And there's no two chairs in this meeting. So please, Chair, if there's many chairs, we need to know now people who will correct other members while they're asking their follow-up. You have all the powers, Chair, and the intellectual to see if this follow-up is a correct follow-up or this follow-up is a wrong follow-up. Your judgment is very much sufficient. And I'm asking you that be the only chair that we know, and we don't have other chair that just come out on this very important meeting. Thank you, Chair.
Honorable Low.
Thanks, Chair. I think we must be very consistent as members. We have raised concerns last week in the portfolio committee on time management and how we're going to run the day-to-day run of the meeting. I'm saying all of this because we would have been mindful of the fact that we want to deal with issues that we dealt. We said that we'll deal with 15 minutes after, members will get follow-ups after, so that we're able to have members to interact accordingly and have our face to move in that way, because we've made determination when I made submission to say these intervals, as we interact each other time and again, they will end up making us to be all over the place and haphazard, and we must be able to deal with time management. And I was very coherent when I raised that point, because I knew that we'll have to deal with our questions accordingly and we must be responded accordingly to deal with issues, so that we don't preempt as to what's going to happen. So I want to agree with Honorable Kabo. Well, let's proceed with our questions 15 minutes and take follow-ups after the time when it's enough. It will give us a way to have the meeting, to have the quorum. Thanks.
Okay, no, thank you very much. Members, there's no need to fight amongst ourselves. We just need to agree that there are certain times where we're not going to agree. And if we don't agree, let's try and work as a collective. It's in the best interest of Parliament that we do so. This Mangwapangwapana won't help us. Let's stick to the agenda, which is to hold the executive accountable, as you are empowered by Section 55(2) of the Constitution to do so. So let's stick to that part. Honorable Maimela, I did not correct Honorable Lonzi earlier on when he made an example about us, because my understanding that hold on. No.
It's us, Chair.
No. Who said you must open them? You see, now we're going to have a problem. I gave you chance to speak. I'm responding to what you have raised there. Now hold on, Honorable Govan. I gave you guys to speak here. Now I'm responding to those, and I've just said you're not going to agree with me. I'm not always going to agree with you, but we are going to respect the sittings of Parliament, and you don't want us to exercise the powers that are conferred to us as chairpersons to make sure that our meetings run properly by disrupting us, opening our mics here when we have not been allowed to do so. It's not going to happen, Honorable Msazan. Honorable Maimela, I was responding to you that I did not correct Honorable Lonzi when he made an example about meetings of the NC, because my understanding is that the party he belongs to doesn't call meetings. So they just get told what to do there. That was my understanding. But if they do also, I apologize. So what I'm getting here, colleagues, and you must help us, is that you are saying if somebody is asking questions, there must be no follow-up from other members. If that's what you are saying, let's agree that it will be standard. And even you'll then note your follow-up on a particular matter, and then we'll then take it at a later stage. Is that what you are saying? Honorable Kaka?
You know, Chair, okay, I wanted to say, Chair, I generally as a human being do not like being embarrassed, particularly in front of people, and we're acting like kids that don't know what's happening in our own house in Parliament. The fact that in the middle of such a important conversation, we're disrupting each other on matters of housekeeping is quite frankly embarrassing. It is below the standard of our titles as legislators. Can I request, Chair, that we deal with the agenda, exhaust it, and then all housekeeping matters of ourselves that are troubling ourselves, we'll have them. The modus operandi that has been the order of life must continue unless we want to break and then have a housekeeping meeting on how we want to organize our meetings and then start from scratch. But in the middle of this, it's just weird. I don't like it.
Honorable Maimela?
Thank you, Honorable Chair. No, I've just lowered my hand. I'm persuaded by the member. I've just lowered my hand. Honorable Chair, my only request or my only plea was with you, because although it is an established practice that members can ask follow-up question, it does disrupt a flow of thought on a member that is currently given an opportunity to ask questions. So my plea is to you, my humble plea is to you to say, please do manage us if we are now getting into a level where we are disrupting a level of flow of a member that is accorded the opportunity to ask questions. But I'm persuaded by Honorable Hahau.
Okay. Any takers here? Honorable Lonzi?
I think perhaps then, Chair, a more balanced approach, which also maintains the precedence, is that if a member is on the floor asking questions, and then another member would like to do a follow-up, maybe as the Chair, you can put it to the member who is asking that, would you be happy with Honorable Khabu asking a follow-up? And then if I believe that, no, it's going to disturb me, I can say no. But if I've got no issue with it, I can then say yes. I think that balances both sides of the field. But I won't be distracted, Chair. When you come back to me, I'm very focused.
Any takers? So we've got the view that we must continue, Honorable Khabo, we must continue allowing members to ask if the member on the podium does not have a problem with that. It's a new rule that we are now bringing, because I know that some of you, when we get excited, you'll say that I'm bringing my own rules. So I'm putting it to you deliberately, because you've brought three different views here. And some of you tomorrow will say that the meeting degenerate because of my own doing. And when you know it's yourselves. So I deliberately put it to yourselves because I don't want people getting excited and creating impressions that it's because of me that we have you guys behaving like this. Honorable Lonzi, you still have 6 minutes.
Hey, my time was properly disrupted, Chair. So, but let me quickly finish here on the minister, and then I want to come to the board members. So what we've established here, Minister, is that you communicated a meeting invite to an entity without a formally written letter. There was no written agenda, and there were no written minutes. If I was as a member performing oversight, I wouldn't qualify that to be a meeting, because I hold the strong view that when a member of the executive is exercising public power, we need to have a proper record. I'm not persuaded that it's because of agency, because if the chief of staff has enough time to call individual board members, then he should have time to sit down and write a formal letter, which wouldn't even take 5 minutes, inviting board members to a formal board meeting. A letter that would probably have to be directed to the company secretary. So I've just got one question before I go to the board members. That question is, when that meeting happened, there is also an allegation that you confiscated the cell phones of the board members which were there. The second one is that not all the board members were invited to that meeting. So I just want you to clarify those 2 points. I know you like to give context, Minister, but please, if you can clarify that. Were cell phones of board members taken in that particular meeting? Yes or no? And secondly, according to your knowledge, were all board members invited to that particular board meeting?
Well, this wasn't the first time that we asked members of the board and everyone who participate in that type of a meeting to leave their phones outside. There was nothing untoward. It had happened in a meeting before the board members. And there was no malice intended. It was just intended to protect the board. And I think, on hindsight, it was probably appropriate because I think, firstly, that engagement, which, by the way, may not necessarily have been a statutory engagement, but an important engagement for us, ended up, not just with you as an honourable member or with the courts, it also ended up in the newspapers.
With respect, Minister, I don't want to cut you. The chair is going to be very strict on time.
Yes.
I think you've answered the question of the phones, yeah.
Yeah.
The second question, did you invite all the board members to the meeting?
According to my knowledge, all board members were invited. And the apology that I received was from the interim chairperson, who was traveling abroad, who had agreed that I can meet with the board members in his absence.
Thank you, Minister.
But subsequent to that, I learned that there was one board member who was not invited.
So do you see why it's so problematic to call a board meeting as a member of the executive and not communicate through the formal channels through a company secretary? Because now you have got a meeting as minister that you say is a board meeting, but at the same time you are saying there is a board member that was not invited. But had you communicated this thing formally through a letter, through a company secretary, where there was going to be an agenda, it was going to be the responsibility of the company secretary to ensure that every board member is invited. Because if there are board members who are not invited and board members who are not invited, that's not a board meeting. That's why I insist that it's as good as a caucus. But we'll come back after to make our analysis. I just want to put some questions before the board on the same meeting. I don't know who will take this. There's no record of the meeting. The minister has said that to us. In the meeting, did the minister instruct you to not proceed with the appointment of the CEO of NSFAS?
Yeah, no, thank you very much, Chairperson, and thank you, Honourable Member. I would have loved also to give a bit of a background, if I'm allowed, about circumstances of this meeting. Personally, I received, actually it was I missed a call. I didn't have the number. I returned the call. The gentleman introduced himself as Mandla, working with the minister.
Sorry to stop you. Chair, just a quick one. I remember in the beginning of the meeting you had said you'll allow a leeway. So can you allow this member?
No, I've paused time for them. I did say that when it's them. Yeah.
Thank you, Chair. So.
Yeah, thanks, Chair. And well, I responded to the call, and I got an invitation that we actually were needed to an urgent meeting with the minister, which meeting will take place in Johannesburg, but the details will be sent to me again via a text communication. I indicated then that I'm actually recovering from a surgery. I did not think that it will be practical for me to travel from Polokwane to Johannesburg. But he did indicate to me that the meeting was very important for the minister, and he pleaded that I actually avail myself. I considered. I went to the meeting on the 13th of April in Johannesburg. It is true that on arrival, our cell phones were taken, stored in different white, not brown, envelopes. All of us who came. There was no formal agenda to that meeting. In fact, there was no agenda. The minister took the platform and introduced our colleague, Ms. Mohali, as our deputy chairperson. I've heard the minister repeat it more than twice in this house, referring to Ms. Mohali as a deputy chairperson of the NSFAS board. Personally, I don't know why she's the deputy chairperson, but I know that in terms of the NSFAS Act, the NSFAS board may appoint a deputy chairperson and not the minister. I know we have not designated Ms. Mohale as the deputy chairperson of the NSFAS board. So that deputy chairperson was introduced to us by the minister. Was requested to make a presentation on behalf of all of us as NSFAS board members. The presentation was made. It touched largely on issues within the purview of a committee he belongs to. She belongs to the HR committee. I don't belong in that committee. Some of the details I did not have. It was only after Ms. Mohali spoke that the two colleagues felt they needed to step in, and they corrected some of the things which were said. I could not have corrected them because the report that we were anticipating had not been provided to the board at the time. The second colleague who wanted to speak, and I'm raising this in the context of, was it an interaction with the board? It wasn't. It was an instruction session because Kumalo raised his hand after the two colleagues, and he was told that you are repeating yourself. Then it was my turn to raise a hand. And the purpose of me raising a hand was to indicate that my flight was ready. And that was within 35 minutes. I want leave of absence. And the minister said, no, we're actually about to finish. I would confirm the meeting didn't take more than an hour. It was a very brief meeting. But in that meeting, the minister's concern was really that we are going ahead with the process of appointing the CEO, and he was convinced that there is an instruction that he needed to give to us as members of the board, and that our processes should be paused pending that instruction that he would give us. If I remember well, I'd written my date down. It will be a Friday of the subsequent Friday. It would have been about closer to 2 weeks. I felt, and I think it was a feeling that we shared with colleagues post that engagement, that the minister's interaction with us could not have been a normal lawful interaction between the executive authority and a member of a board of an entity. It is subsequent to that meeting that I wrote to colleagues using the WhatsApp group communication when there was no movement around the issue of the appointment of the CEO, which we had to move because the minister had given us a deadline, which deadline was actually approaching. I wrote in there, I addressed my text to the acting CEO and the chairperson and the colleagues. It was, dear chairperson, acting CEO and colleagues. And I said, I note that there is no movement on this thing of the CEO. And now this was my way of rejecting the instruction of that meeting that we should pause our activities. And I went further to say that I want an arrangement for a meeting so that we can finalize our processes. Chair, there were processes that actually preceded or development that preceded that meeting with and it answers twin questions that you have sent to us. The development that preceded that meeting is that on the 28th of March, that's the day I did my surgery, I missed a call, and that call was from one of the colleagues I know from Limpopo, Mr. Letlogonolo Masoga. Mr. Letlogonolo Masoga is one of the administrators appointed to one of the sitters. I don't remember which of the sitters, if I'm correct. So I think I've got a text because I didn't want to misrepresent what he said. But the essence of it, it says, Mushati, can I please steal 2 of your minutes to brief you about my issues? And I emphasize the following point. I'm just a messenger and due to meet with the principal shortly. I did not respond to this because I was not in a position to take a call on that day, but I did call Mr. Masoga the following day, and he tells me that the minister, that's the minister responsible for higher education and training, was not comfortable with the trajectory we're taking as the board in relation to a candidate that will potentially be appointed as the CEO. He did inform me that there is a very strong candidate, and he gave the credentials of that candidate, who is someone he referred to as a candidate who had been with the National School of Government for some time, and he did indicate that he was a strong candidate. And I said to him, these are the exact words I used. I said, I do not have history of defying leadership. That is what I said. And this was my way of dismissing him because I did not want to venture into discussions around that subject because we had agreed when we started the process of recruiting the CEO that we needed to guard the integrity of that process with everything at our disposal. And it is for that reason that anything that could easily dismiss someone who seeks to interfere would be an immediately available weapon to me. But it was not only Mr. Masoga who called me. It was later, I think on the 7th of April, I received a text from Mrs. Mohali, who was introduced as our deputy chairperson in the board of NSFAS. And she wanted to check if I would be available for a call the next day. I indicated that I was available anytime from 9 o'clock in the morning to take her call. I think around that time of 9 o'clock, she didn't call. She actually texted that she was in council. I understood it to be a council of she serves in one of the ICASA, council of ICASA. I understood it to be a meeting of ICASA. And then, but she did later call around 4 minutes to 4. And that's where she explicitly told me that the minister is of the view that Mr. Wasim Karim is not ready to take up the responsibilities of being a CEO of NSFAS. He repeated almost the same language from Mr. Masoga, that there is a strong candidate who should be considered. My response to her was, actually leadership had already engaged me through Mr. Masoga, so there isn't a need for us to go further with this one. We should be okay because leadership has already engaged me through Mr. Masoga. So that is the context that I needed to give. The issue of the cell phone, I think I've dealt with. It was on the 20th of April, that is, would be almost at 5 o'clock, that's 16:47, that I received a call from Mr. Masoa again. And this call now comes after the HR committee had done its work. That question whether the HR committee did finally do the work, it did the work. The report is available. I'm not sure if members of the committee would want it. A report is done, signed by all persons who needed to sign that report, indicating the process, indicating the panel, indicating the scores, indicating the recommended candidate and everything. We've got a report. So the board has that report. And this time, Mr. Masoga says to me that I got a call from Sis Florence. And this, Sis Florence, was in reference to Mrs. Florence Masebe, who I understand to be the special advisor to the minister. She was also in that meeting of the 13th of April. And he says, Mr. Masoga, that the concern from Sis Flo is that it appears that the HR committee acted outside of the expectations of the minister. And I said that I had not seen the report of the HR committee at that time, and I couldn't comment further. So that speaks to, in my view, what I consider to be the level of interference. But then there was a pushback. This is a pushback that was designed to ensure that ultimately, and I think the pushback comes after all these attempts could not be successful. The pushback to ensure that the meeting of the HR committee is frustrated to a point that the board cannot see it. And this is available. There are exchanges. I think in one of our WhatsApp group, you would find exchanges that are dated 10th April, where Ms. Mohali introduced this thing that suggests that there is no readiness to go to the board because seemingly some of the panelists who are DDGs in the Department of Higher Education were not there. I didn't understand the relevance of those DDGs because their role they were panelists. The panel had done its job. You no longer need panelists now, you need the HR committee. But for some reason, we are told that the absence of these DDGs would make it impractical for the HR committee to finalize its job. And Ms. Mohale emphasized the point. We will not have that board meeting until the HR committee has done it. She's the chairperson of the HR committee, by the way. And we will not have that meeting. And she's supported there by the chairperson of the board. These are the two individuals who then, after finally the HR committee met, who then on the eve of that board meeting sends resignation, and I'll emphasize about resignation. I only saw a resignation, the acting chairperson's resignation, which resignation made reference to Ms. Mohale's resignation. It would appear that the Ms. Mohale, in resigning, somehow forwarded it, but I have requested the company secretary that can we see for the purpose of record Ms. Mohale's resignation. I've not seen it, but I know it was a reference to in the chairperson's resignation. So, Chair, I think that would, in brief, respond to the question that you have asked. Thank you.
So I just want to understand here. So at least now you have established that you were called to a meeting without a formal letter, without effectively a formal invite, right?
That is true.
It was via phone call.
That is true.
And then when you arrived in the meetings, your phones were placed in white envelopes, not brown envelopes.
Not brown, Chair.
Then when you entered the meeting, there was no company secretary to take minutes.
There was no any of the support staff from the office of the NSFAS.
And the minister was there.
The minister was well supported.
How did the minister give you the instruction to not proceed with the appointment of the CEO? Are you able to remember what exactly he said to you?
The closest to the exact word was that you are not supposed to proceed until I give you further instructions, but he then gave us the date. The date, I think it was to be the subsequent Friday.
So what did you understand about further instructions? Like what does it mean by that?
I wouldn't want to invite myself into speculation, but whatever I understood at the level of what our powers are as the board is that the board is empowered to appoint the CEO, and this process of appointing the CEO has got no participation of the minister. The minister comes after the fact. The minister comes when we have made the appointment as the board, requesting him to concur only in relation to the condition of service, and that concurrence is a joint concurrence between him and the minister responsible for the finances of the Republic.
So when you were in that meeting, did you perceive that to be a meeting, or you just perceived it to be a caucus between board members and the minister?
It was a meeting, a strange meeting.
A strange meeting. And then, do you also confirm that not all the board members were invited?
I interacted with Advocate Lavant after the meeting because he was absent. I told him that you were not in the meeting, we're meeting with the minister. He told me that he did not know about the meeting, so he was absent.
So how do you have a board meeting where not all board members are invited? What type of a meeting is that?
I've said, Chair, that it was strange, but remember we were invited on the authority of the minister and as an entity that reports to the minister who represent the shareholders who are the people of the Republic of South Africa. We went there hoping to attend a meeting, only to find when we arrived that it is something that is designed like a meeting, but it looks differently.
And then my last question, Chair, and this is so that we can have a balanced view. And I'll tell you the importance of this question. You must not think that I'm fighting with the board, because we've got many entities that have boards in this sector. And boards have got a fiduciary responsibility to perform their duties. Now, although I can say I sympathize with the strange meeting and arrangement, but I want to believe that if you are a board member who's a professional, who's got a fiduciary responsibility, even if a member of the executive gives you an instruction, if you hold the view that that instruction is strange, is unlawful, is irregular, surely as a board member, you have got a duty to not implement an unlawful instruction.
I agree completely, and that is exactly what we have done. I've mentioned earlier that as soon as I had formulated the view that you are canvassing, I went back to my colleagues that let's proceed with the work that we are tasked to do.
Thank you, Chair.
Yeah. Honorable Khabo. Oh, okay. Before Minister.
Thank you. Thank you very much, Chairperson. I think there has been some statements made by respectfully the board members, and I think it's important that I say a few things. Firstly, just to emphasize that the meeting of the 13th of April was convened by me as a result of my discussion with the interim chairperson. And secondly, that that meeting, although not a statutory meeting of the board, but it was an engagement between myself as the minister with the board. And thirdly, that all the board members were there in a meeting in November where the same thing applied, where we're meeting with the, around the resignation of the then chairperson, Stander, who had resigned, and the same process applied, where we all handed in our phone. This is a practice that happens in order to protect the secrecy of our meeting. There was nothing sinister, and I believe either on the meeting of the 10th or on the meeting, of the 13th, if members of the board had objections about either their phones being taken or about being in a meeting where they believe there is no agenda or that there's something inconsistent about my engagement with the board, that the board members would have actually indicated. I regret the fact that there was one board member who was not invited, and I think we obviously should have handled that properly. But also, I think all the other issues that have been raised, the board members themselves in their application, I'm quite surprised that I'm said to have issued an instruction in that meeting. The instruction that existed to the board, which was in writing, was that the board had to appoint a CEO latest by the 31st of May. Now, the question of what actually happened in that meeting, where I was given a report, I may have made some mistakes around the role of the chairperson of the Human Resource Committee and referring them to as deputy chairperson. But I think importantly, the understanding of that meeting was that the board cannot go ahead and appoint a CEO in their board without having concluded all the processes that was required. And I did emphasize in that meeting that I'm the one who has given them the deadline, and the deadline is only on the 31st of May. And upon conclusion of the entirety of that process, that that the board should furnish me with a report. I did not tell the board to hold the process. What I actually advised the board is that that process needs to be concluded. I cannot comment about the discussions that the former board member has had with the various people that he's referred to. I don't think I'm in a place to do that. But importantly, I have not in any way instructed any of the board members to act in a way that would have undermined their fiduciary responsibility, either in that meeting or in any other meeting that I've had with them, or even outside of the meetings of the board. I've at all times acted in as expected of me as an executive authority, and I maintain that. And obviously, I think as indicated. Beyond what what we say here, I think I've indicated that this matter is also before the courts in terms of its determination. But I stand by my word that I have not in any way sought to interfere with and in fact the report that the former board members are referring to, its details, I became aware of it when they were splashed all over the newspapers the following weekend. Thank you, Honourable Chairperson.
Thank you, Minister. I see the hand of Portia's iPhone.
Yes, Chair. Can I go on?
Yeah, are you in a position to open your video?
Okay, I will do so. I've opened it. Can I go on, Chair?
Yes.
I am one of the former board members, and I would like to support Advocate Ramashia in what he has alluded to so far. Yes, the minister said we should go ahead with the meeting of the HR committee, but before we go to appoint the CEO, we must hold on. He will call us, and then he will have a meeting with us before we can go on for appointing the CEO. So it's true what the advocate is saying. Thank you, Chair.
Okay. Maybe in the interest of time, if we are covered, let's say we are covered, so that we don't repeat.
Just 10 seconds, Chair. I'm not asking a question. I'm saying maybe you will have to assist us on this. We can either discuss it during break or what. Because what we effectively have here is that we have people who are attending Parliament in the form of the minister and the board. And both of them are presenting diametrically opposed versions of what happened. So what we know is that someone is lying, but we may not necessarily know who is lying. So perhaps during break, legal or researchers may have to make us to understand how do we deal with this constitutional problem, because two people are speaking under oath and they're presenting different versions. How do we know who is telling the truth and who is not?
You've made the point, Honorable Khava.
Thank you very much, Chairperson. Let me just go straight to issues. Honorable Minister, I believe that you are aware that as the ANC, we are currently on a serious trajectory of renewal. And as part of our renewal project, we should move beyond tick box or box ticking to actual accountability, where serious actions has been taken. And I'm raising this because we appreciate your ministerial powers that you have exercised in terms of placing the board under administration. But we believe so that as part of playing our oversight, we should be precise in terms of developing an understanding on the process that has been followed. The collapse of NSFAS, in your view, it cannot be looked into it apart from or in isolation from the role of the department, from the DG and the DG's executives. I believe that the department has an oversight role to play on and around NSFAS. And with that being said, we can also, like I said, believe that NSFAS exists in isolation or in an island. Let me start with this question. Can I get clarity from your good self, firstly, Minister? Who is Mandla? Can you give us the name of Mandla with the surname and the position?
Mandla Shabalala is that's the person who called the board members. So that's Mandla Shabalala, who's the community and stakeholder relations manager in the office.
So would I be right to conclude that he was acting under your instruction?
Yes, yes, he was.
Okay, let me just go to the issue that has been raised by the board, by one of the board members. There is an allegation that you had instructed the deputy chair, whose appointment or election is under question as the deputy chair, to speak to board members on your behalf. Have you done that?
No. I didn't instruct anyone to. I've maintained constant communication with the interim chairperson at all material times.
So would it be right to conclude that the deputy chair, Ms. Mohale, was acting outside your instruction?
I did not instruct anyone to act on my behalf as it relates to any of the matters relating to that.
Thank you very much. The second issue, Minister, there is an allegation that one of the administrators that you yourself has appointed as an administration of service sitter has also made the very same call, dropping your name, claiming that you have instructed him to lobby board members to take a particular route in terms of who would be best suitable as a candidate of the CEO. Is it true or not?
Well, like I said, I haven't had any discussion with anybody around the question of the appointment of the CEO of the NSFAS.
Thank you very much, Minister. Let me probably go to the board. I'd like to check with you, was this the first session or meeting you had with the minister where your phones were taken?
This would have been the only, and perhaps also indirectly touching on the comment about possible 20 meetings. Our total meetings with the minister have only been limited to 5 in as far as I'm concerned. And of the 5 meetings, I honestly do not remember my phones being confiscated.
So this is the only meeting where your phones were taken?
I don't want to answer it that way, but I honestly, my colleague wants to answer it directly, but I do not remember my phone being taken.
Advocate, you are the one who have been leading the charge. And you are saying, out of the 5 meetings,
yes,
this is the only meeting, I mean, there's only one meeting where your phones were confiscated. Am I right to conclude that is what you are saying?
You will be right to conclude it as a submission that I'm making.
Okay, fine. Let's then go to the next issue. You raised the issue of the deputy chairperson of the board, Ms. Mohale. And in your submission, you are giving an impression that you never said as a board to elect Ms. Mohale as a deputy chairperson. In fact, that is a responsibility of the board, not of the minister. Did I hear you right?
That is correct.
In that instance, how did it happen that Ms. Mohale became the deputy chairperson of the board?
No, she has never practically been the deputy chairperson of the board. She has only been introduced as such by the minister, both in the meeting of the 13th, but also the minister has made at least twice in this house a reference to Ms. Mohale being the deputy chairperson of the board.
So, would it be safe to conclude that the board has never elected Ms. Mohale, rather Ms. Mohale was imposed to you as a deputy chair, contradicting the legal prescripts that guides the process of electing deputy chair?
Yeah, that would be unfair to say imposed. I think the fairest thing to say is to say the minister has constantly referred to Ms. Mohale as a deputy chairperson. Perhaps he interacted with her as such, but for all practical purposes, Ms. Mohale is not the NSFAS deputy chair or a former chairperson of the NSFAS board. The board has never appointed a deputy chairperson.
No, thank you very much. Let's go to this meeting of the 13th that you said is either informal or formal. We are still confused, but we'll deal with that issue. How did you attend that meeting? Who financed your traveling? Was it the department or you funded your own traveling?
No, NSFAS financed the meeting.
NSFAS financed the meeting?
Yes.
An informal meeting?
At least at this stage, we can agree that it was an informal meeting, but at the time we received an invitation and accepted it, it was supposed to be a normal meeting organized by the minister.
Not a problem. Let me go to the issue of legal. Minister, when were you informed that the board appointment process was made with legal defects?
This was almost as soon as I assumed office. I think the first time I interacted with that information was around August, September.
Okay.
Yeah.
So did that process, was it you who initiated that process of verifying whether the process was legally compliant, or is it a report that you found in your office?
It's so we had a report that was presented to me, but there were also, I think, some complaints, especially from students' organizations, who were complaining that they were not, represented.
So that is a report that you got on your appointment?
Yes.
Okay, fine. Let me go to the legal department. Advocate, can you confirm or deny whether the department, through your good selves as the legal team, has formally cleared the appointment process of the board done by the previous minister? Did you formally clear the board after it was appointed?
Thank you for the question, but I'm confused. What do you mean by clear?
Okay. Did your office issue a formal legal opinion on the state of the board that it passes all legal aspects? My assumption is that before the minister could go out and pronounce any decision, as the legal team, you should be able to advise the minister or department as to whether this matter will hold water if it could be tested legally. Have you had that opportunity?
We were never approached.
Are you saying that the former minister never approached you when finalizing the appointment of the board?
Not as far as I can remember.
DG, can I get your take on the matter? Why is it that we are having a board that cannot pass the legal standing?
Thank you. There were a couple of issues about the previous board, and some of those issues were presented and discussed in this house as well. One of them was that the gazette that was published went beyond the minimum requirements as in the law by adding a master's degree as
DG, we are running out of time. I'm left with 3 minutes here.
Okay.
Was the report, did you give the report a green light, yes or no, on the appointment of the board?
No.
You did not agree with it?
No.
Is there anywhere in writing where you've advised the minister, the previous minister, that actions of appointing the board would be inconsistent with the law?
There were meetings, there were discussions, but it was made to me very clear, and the minister herself indicated that there was no role played by the officials in the decision about the board.
Thank you very much. Can you also provide that in writing, that one? Can we go to the second issue? On the self-reviewal process, I believe that at the center of this problem is the legitimacy of the board that the minister wants to cite. I want to check with you in terms of the advice that you have provided. Is it you have advised the minister to go on a review?
We sought an external legal opinion.
You sought an external legal opinion?
Yes.
So the process of instructing the board to start the process of appointing the CEO, was it done during that time when the matter was before the court?
Yes.
Meaning that the minister has identified certain areas that are inconsistent with the law on how the board was appointed. And the same minister is the one who has instructed the very same board that he has viewed as unlawfully appointed to start the process of the appointment of the CEO.
Can I respond? Remember, in minister's presentation, he referred to the autocral principle. And that autocral principle is, in essence, saying even if the board was unlawfully established, the work that they will be doing in the meantime will only be set aside by a competent court of law. And because the self-review was still in process.
Fine.
That's
my question is,
yeah.
Is it you who advised the minister on that process of self-review? Is it you as a department or what? That's my question to you.
I had said we sought an external legal opinion, and that legal opinion is the one that advised us as a department to advise minister as such.
Let's leave that part of the legal opinion. Minister, let's deal with this issue of the meeting of the 13th. There is an allegation that, in a way, you had called that meeting to instruct the board on who to appoint as a CEO. That is the impression that has been created in the society. And the number of allegations that has been leveled here against you in terms of how you have handled the process. And I would want to ask you a straightforward question in relation to the issue. Has there been an instance where you are instructing the board on who to appoint?
No, I have not instructed the board on who to appoint. And I think if I had instructed the board on who to appoint, or if I had wanted to instruct the board on who to appoint, I would have definitely instructed them on that. I understand where my powers lies. My powers in relation to the appointment of the CEO of the NSFAS only lie in as far as concurrence with the decision of the board. So I know my place.
So according to you, it's fine, Minister. According to you, were you not technically confirming the board that you are questioning or that you have placed the matter before court by appointing additional or by co-opting or agreeing to the co-option of additional members of the board?
No, I didn't agree to the co-option of additional members of the board. And the reason why that wasn't going to be material was because I've already approached the court to review that decision. And I must say also that in the bigger scheme of things, it's not just the appointment of the CEO that the board was responsible for. We're talking about a 60 billion, close to 60 billion rands budget, which we had also, that the board was responsible for. So that continuation was itself, in our view, legal for the board to continue performing its board. I would not have in any way tried to interrupt a process which I had instructed the board to commence with.
The last one, Minister, because I've run out of time. When you were conducting or were initiating this process, where it is dictated that you must consult with the board, have you ever written formal individual letters to every board member? Or that engagement where they believe was not a formal meeting, it was just an informal session? Have you ever written, because clearly there was no formal engagement or consultation, is there any formal letter that you had written to board members in relation to the process?
No, I didn't write any.
Thank you very much, Chair. Thanks, Chair.
No, thank you very much. Honorable Ngubane, you're supposed to come in. Can I please bring in Dr. Christians, because of the matter I spoke about earlier on. And then we'll come after. Dr. Christians?
Thank you very much, Chairperson. Chairperson, Minister, I would just like to get back again to the purpose of the meeting that you held, because it seems that is the bone of contention in the room. So, it was alleged by the board members that they were required to surrender their phones and they were not provided with an agenda and that there were no minutes recorded whatsoever. So I just want to establish, was this an official governance meeting? Was it a consultation meeting? Or was it just an informal engagement?
This was an official engagement between the board and the minister. It did not it was not a statutory board meeting where the board was expected to make a decision. The purpose of the meeting was for me to get to understand the concerns that the interim chairperson had raised with me as it relates to issues around governance and the processes of the appointment of the CEO.
Okay, thank you Minister. So that then leaves us with a very uncomfortable question. And that is, how are we as Parliament then expected to verify between what the board has said and with what you are saying? How are we supposed to verify that in this meeting if there is no valid evidence of that meeting and no minutes after the fact?
Look, I mean, I think on hindsight, and given the fact that, in the intervening period, there has been, official record and communication between myself and the board, an official record including the instruction that I've given to the board, to expedite the process of the appointment of the CEO. And I think subsequent to to that, the various other engagements that we've had with the board. So because that engagement arose as a result of the ongoing engagements that we've had with the board, I didn't think that at the time that it was important, and I agree with you that probably on hindsight, given the fact that there are issues around this meeting. But I think the important thing, Honourable Christensen, is that I haven't heard from the board, even today or on any other day, them saying that I gave them an unlawful instruction in that meeting. And I think for me that's what's primary. Them saying that I sought to, in that meeting, interfere, other than me having said that they need to, conclude all the processes relating to the appointment of the CEO as required by the regulations before taking that decision.
Okay, I think, Minister, it is really very clear that from a governance perspective that we do sit with a fundamental issue that it is not, in this case, or was not good governance practice to deal with a meeting of such importance without a formal agenda, without any minutes, and without placing it on official record. I think we all agree on that. I just want to get to the parliamentary legal services again. So we've heard now competing evidence today regarding instructions that the minister allegedly gave about a CEO appointment. Now, in your opinion, how would you suggest that we as Parliament satisfy ourselves, seeing that there's no official record of this meeting? How do you propose we satisfy ourselves that that meeting actually existed, what transpired in that meeting, and what would be our way forward?
I'm sorry, I thought you were talking about the parliamentary legal. I'm not a parliamentary legal service.
DHET legal?
Yes.
So you wanted to answer?
Yes.
Okay.
I think the papers that were filed would have helped if the member had sight of before we came to this meeting, because that is where a lot of the issues are ventilated. And I'm still trying to remember whether the board members themselves have actually raised this as an issue in their papers. And maybe it would help all of us if we were to wait for the court to make a determination about this matter, because there are conflicting versions of what happened on the day, and the papers that the board has drafted and that minister has drafted, they have to stand and fall by their papers when we approach court. Thank you.
Thank you very much. I think we can get back to parliamentary services later on, Chair.
Okay,
because
maybe
I think
before.
it's- or
Maybe before. Do you mind if Honorable Lonzi has a follow-up?
Okay.
Now, me and Honorable Christians were forces, Chair. No, just when Honorable Christians had put the question to the minister says the board members didn't say that he gave them an unlawful instruction. And I beg to differ, because if I heard the board members correctly, they did actually say in this parliament that the minister gave them an unlawful instruction. So I just wanted us to confirm with the members themselves, because I heard that, and the minister is saying they didn't.
Thanks, Chair. I would like to hear from Parliamentary Legal Services, because I do think that's going to give us as the committee a way forward in this. But I would like to leave that to the end, Chair, because I just have just a few very other important questions to ask. So, Minister, you knew that we've now verified from the questions that you've answered that you knew from the start of your appointment that the board appointment process was unlawful from the outset. So why did the department and its legal unit then, essentially the ministry failed here, as far as I can determine, because they did not identify and correct what you say you now knew from perhaps the inception of your appointment, that you identified these defects in the appointments. So how come that proceeded then after all these months and you knew about the defects in those appointments?
Well, as I said, so as soon as we were legally advised, I then had a consultation with the board. I think it was on the 5th of November, and upon consultation with the board, I then went on to approach the court for a self-review. The various other options in the Act in terms of the dissolution of the board were not applicable in this instance. And I must emphasize this point, that the composition of the board, as we've said, to them and also elsewhere, was not the result of their own fault. They did not appoint themselves. And so the person who appointed them, who on the 20th of February, who in this case is the Minister of Higher Education, was then required to approach the court and ask the court for a declaratory a declaratory order to set aside that, that decision. So that's where the self-review comes in. So action was taken in that regard.
So, Minister, did your legal advice then recommend the administration?
No.
My next question, Minister, is NSFAS has now been placed under administration and no independent investigation was done. And I think to me that is the single most serious flaw. And while I know it does not appear in the NSFAS Act, it does appear in the Higher Education and Training Act. So no independent investigation was done. Why was that not preceded before your decision to place NSFAS under administration?
Well, as I said in my presentation, Honourable Christians, that the provisions for, in terms of Section 17A to D, stipulates the various, conditions within which an administration could be put into place. And safe to say that the review process itself may have led to, either where we are or any other alternative in terms of administration. But I believe that the conditions which were required by the law which is not just investigation, but various other conditions, that those conditions were met, in terms of the, placing the entity under administration.
So, Minister, that brings me then to a question that I deem very important and very serious, because NSFAS has now been placed under administration for the third time. The previous two administrations were not effective. In fact, NSFAS has regressed, as we've seen. So at what point, Minister, are we going to admit, or government itself, are we going to admit that we have now implemented repeated administrations and we are merely treating the symptoms of NSFAS's failure, and we are not fixing the institution itself, the problems that exist within NSFAS? So we are going around in circles. Instead of managing a 50 billion rand, almost 60 billion, as you have indicated, plus institution properly, we are now at the point where NSFAS is under administration for this third time. So I'm asking you, Minister, if something is not working, isn't it time that you think we overhaul and we revamp completely NSFAS? Because something must drastically change, and a third administration is not it. Isn't it time to admit that NSFAS, in its current way and form, has failed, and that we need to rethink policy and rethink the entire system of NSFAS?
Well, I don't agree with you that the previous administrations failed. The first administration under Dr. Randall Carlson did not fail. And then, subsequent to that administration, there was a board that was appointed, and the then minister, Dr. Nzimande, had to institute another administration under Nomvalo, who did not complete his term as an administrator. The board was then appointed in state. So I essentially do not agree that the administrations have failed. But as I also said, that we are having that discussion around a sustainable student funding model, and I think it would be on the basis of that we should then consider what options are available on the table as it relates to the platform to distribute student funding. But for now, I think the current tenure of the administrator's intention is to stabilize the institution, ensure that we modernize it, and in that way we can simultaneously have discussions around what reform measures are in place. And part of the things we will obviously have to consider are the proposals that you're making on what needs to be done. But I don't agree that the previous administrators failed as presented.
Thanks, Minister. Then I think we are going to have to agree to disagree there, because none of the problems were solved. In fact, the problems have increased, and most of NSFAS's problems have arisen because of repeated administration, that repeated dysfunction within NSFAS, with new members coming on board every time. So the problems do not merely exist with the board members. There are legal vulnerabilities. Administrators come and go. We don't get any close-out reports. So those are definitely serious defects in NSFAS. I just want to get to the board members. So we've heard a lot of what you have said, and you've now essentially argued that the administration that the minister has placed you under is unjustified. Am I correct in saying that?
You are correct for many reasons, and at the center of those reasons is the fact that the reference, first, maybe let me start from the minister's attempted consultation. The minister writes to the board, respond to me within 48 hours. This is a list of my concerns. when the minister goes out public to announce administration, none of the issues that we made representations on are part of the reasons that informs his decision. He after the fact, manufactures or engineers new reasons that are not consistent to the reasons that are in the consultation letter.
Advocate, I'm afraid I must disrupt you there because I think that's part of what you are arguing in court. That part, no. You're not arguing the reasons provided by the minister in court.
Maybe Chair, and I'm not sure you'll guide me. As the board, former board members, we also took legal counsel on the question of sub judice. And we understand the limits in terms of which we can stretch ourselves. And we operate within the guidance we got from our lawyers in as far as the concept of sub judice is concerned. And we are convinced that we are not breaching that line.
Yeah, you also listened to our legal when we started.
Yes, Chair.
And that's what we are basing our running our meeting from that advice. And I'm saying, and I understand that you may have more information, like for an example, the advice that you're talking about. But my issue was in court, taking into account what we were advised earlier on. In court, you are not arguing there because, in my view, you enter in the merits of the reasons which you don't agree with, and I'm sure in your court papers you would have raised you would have raised those issues.
See, Chair, I think the horse has bolted. The minister made the reference to section 17, capital letter A, B, and C. And this response we are offering, it is based on 17, capital letter A, B to C. And it is important that we give this response because the minister has spent a lot of time on section 17. And we are saying to Parliament that the minister misdirected himself or had a wrong understanding of what the section requires. And we request time to impress on this point.
Yeah, do you understand my concern?
Yes, I do, Chair.
And my concern is that we were advised here in this meeting, in your presence, on not crossing the line to the merits of the case. And to protect our meeting, I'm asking that don't cross that line to that side.
I understand completely, Chair. I agree with you.
Yes.
And I'll limit myself very briefly.
Sure.
Chair, section 17, capital letter A, both A and B, I'll start with A and B and I'll combine them. Both of them, and it answers the question that the honorable member raised earlier about an investigation report. Actually, A and B requires that report. It is not absent, honorable member, in the NSFAS Act. It is there. It says it should be an AG's report or a report commissioned by the minister for that purpose. That report of the AG does not exist because the minister cannot accept the president saying to him, sometime in 1999, this thing happened in the Department of Education. It causes us embarrassment. As a result, I am removing you as minister. It cannot be fair to say a board of NSFAS should be removed from office because there is an audit report of 2023-2024. So the preliminary requirements are absent. What are those requirements? It is an auditor's report. It is a ministerial investigation report. They are absent. That is what A requires. That is what B requires. And it says, A, these reports should point to financial mismanagement or maladministration. It cannot be maladministration by successive boards that preceded these boards. It can't be. That understanding is far-fetched. It should be a financial mismanagement by a board that is to be placed under administration. And the third reason the minister has considered does not arise because the board of NSFAS has not requested to be placed under administration. I'm saying, Chair, in terms of the applicable law, the law that you have approved, if this parliament wanted to give the minister more power than the powers provided in A, B, and C of Section 17, it would have added D that will probably have read or any other consideration that in the opinion of the minister warrants administration. The lawmakers have not given the minister that power and the minister cannot give himself that power. Thanks, Chair.
Yeah. To the defense of the minister, you may differ that the report is not yours. The AG's report is not yours. That part is granted. But we can't say the report doesn't exist. We do have an AG report which the minister is basing. I agree with you that we may differ, that it does not belong to a financial year. DG, even this door is open. So I just thought I must just clarify that part. But I think the point is well made. And
thanks, Chair.
Yeah, we have 9 seconds, Dr. Christian. Maybe the last question.
Thank you very much, Chair. So you as the board, you've said that you are quite capable of governing NSFAS. And if this is indeed true, can you tell us then why have so many board members resigned from the initial board member, Dr. Stander? Why did they resign? Why leaving the board? Because that has brought the initial instability in NSFAS. And added to that, there were more board resignations. So why the board resignations? Because that caused the initial instability in NSFAS. Can you just explain that to us as an ending?
Very brief, because my colleague wants to take the second part of your question. You don't have to take our word for it when we say that this board has been very effective. You can actually directly reference what the minister says in his own word. He says, when he was addressing the National Assembly on the 24th of January, importantly, NSFAS performance has improved.
24th of February, not January.
Yes, it's February. Yeah. NSFAS performance improved. For the first time, students knew their funding status before the matric result were released, and continuing students knew their status of the previous academic year. The minister continues on the 14th of November, the minister says, it should at this point make it clear that the new NSFAS board has not in itself committed any wrongdoing and has not, to the best of my knowledge, done anything warranting a sanction. And this is important for lawmakers to underline. The minister says this board has not done anything to warrant a sanction. That is his own words. He says later that that this is on the 14th of February. This February, a few weeks ago, the minister says, I admit that the NSFAS board has been working since its appointment in February of 2025. As things presently stand, I am mindful that the board is fulfilling its mandate under the Act. You don't have to take my word for it. That is what the minister says. Before I give it to my colleague, the emphasis on 18 board members versus the remaining 7 is emphasized wrongly. It is actually 13, not 18. Thank you.
Yeah, and there is a coincidence here between the resignation of board members and the threat of self-review. So some board members resigned just in coincidence with that self-review, and some resigned just in coincidence with dissolution, so you can draw the pattern.
Thank you. Honorable Low, maybe let's take you. I'm mindful of we should be going to lunch, but there are members who are going to leave. So maybe let's take Honorable Low.
Thank you, Chairperson. Me Kunta, wa legal. Me?
Kuta.
Okay. Sorry, I want to check, does the legal provide legal opinion only when they are approached, or when do you often provide legal opinions, or how do you operate in the space of your legal unit?
It can both be when we are approached or when we are in a position to provide one. Maybe we are in a meeting and there are legal questions raised. So it can be both.
So in your day-to-day running as a legal person, how do you report? In our as per the Public Administration Act of South Africa, we are required to report quarterly and give opinions on to issues of importance. I'm raising this because of time and again, the department has been found wanting with regard to legal opinions, and the department is finding itself to court, even though sometimes does not need to court. What is your view as legal? Is it that this is disregard of your opinions, or what is the problem? Thanks.
Maybe you'll find this as controversial. I actually like it when we have to be taken to court, because the courts will determine who is right, who is wrong in the interpretation of what the law says. And in this context, when we are approached to provide a legal opinion, we do just that. And when we are not, we will not voluntarily provide a legal opinion when we have not been asked for one.
Okay, it's fine. Let me not go there, Chair. It's gonna take my time. I've got 15 minutes. In my submission, I think we should agree that the legal of the department must look onto the issues, because we can't speak of cost containment, we can't speak of making sure that we run government according to the law in terms of avoiding to go to courts. And the reason there's a unit for legal to be there is to avoid courts, advise, align, consolidate, and mitigate, and make sure that we are going to deal with all of the issues. So we'll get to the issue of legal. Minister, in one of the submissions, as I was listening to the board member, the board is, as per your submission, did the minister hold the NSFAS board responsible for the 2025 audit outcome, even though they were only appointed on mid-February? Because I went to my notes, and the disclaimer of opinion relates to a period when administrator oversaw the affairs of NSFAS and was still waiting for the close-out report of the administrator. Can you clarify the two? Did you take them based on the fact of the audit outcome? And then did you take them based on the fact that the close-out report of the administrator is not yet closed? So we can clarify the contradictions. Thanks.
Well, I mean, I think it's based on several factors, but including, you know, the question of the AGSA's report, and then. So as I said, I mean, the second administrator, Nomvalo, was appointed for a period of 2 years, went on to serve, I think, just under 10 months, if I'm not mistaken. I just have to calculate. And there has been disputes, you know, even before I came into office, around handing over the report and not handing over the report. You know, yeah. So I think that's an issue that's still there. Yeah.
Thanks, Minister. Also onto the board, is it true that you gave directive as per the allegations onto the board with regard to the audit progress outcome for the 30th of April to the 31st of May? Have you ever given a directive to the board on those dates?
No, the only directive that I gave to the board this year was on the
I think 27th of March, which related to actions that needed to be taken from the Auditor General's report. Yeah. So that's the only directive that I've given to the board.
Have you ever received a report from the progress report from the board between the months before that you could have dissolved them?
No, the only time we received anything relating to that directive was when the board also responded to, to my letter of the, I think, 27th or 28th April. That's when the board also added on in that response their report in response to my directives.
Okay, thanks, Minister. I wanted to get that clarity so that we can properly align as to what directive did you give, because earlier we could have spoken about that when you, before that you could have opted to deal with the dissolution of the board. You would have, or before you could have said to them they must appoint a CEO and failure to all allegations that were perpetrated in the House. I want to ask the Minister, from the allegations made by board members and from all of that factors, how true is it that you give directive on the matter of the CEO and we had an interest on the matter of the CEO? Because I'm asking this secondly for you to tell us, because if there's no documentation, we'll rely on you and the board. But I want to give you an opportunity to tell us what was the discussion precisely and what informed you not to have record keeping in a meeting of a board, because it's a meeting of high level with the minister that might have legal implications, like I was speaking about the legal issues, and I was asking, when are they working, when are they advising?
Yeah. So, firstly, I think I have to emphasize that I did not issue any illegal instruction or directive in that meting. I think that emphasis is important. But secondly, that the meeting was necessitated, by my engagement with the interim chairperson, and thus the meeting itself. The meeting was not intended in any way to take any statutory decision as expected in terms of the function of the board. The meeting was intended for me to, to listen to the board members on the issues that the interim chairperson, had raised. I had no intention going into that meeting to instruct the board on who they should appoint, for the position of the CEO. I was just concerned around the differences that, that the interim chairperson, had spoken to in relation to the workings of the board.
Can I go back to legal? Because I'm not a legal person. But in this regard, I don't want to go to the merit of the court. Is it permissible that you can have a meeting with the board with high-level discussions and still not have record keeping, so that you can prove to the meeting, or what is going to happen in terms of conflict that arises like in this particular way, where the board is saying this, the minister is saying this? What becomes your advice in this effect with regard for us to find facts? Because we must find facts, we must conclude, we must align.
Can I refer you back to the judicial determination, because this matter is before court and this forms part of the arguments about the legality of what has happened for the board to be dissolved and an administrator was appointed.
Okay. Msazana wants to allow him. I'll come, Lonzi as well, I don't know. You want to allow them?
Ngiyabonga Sihlalo, and thank you for Honorable Law for granting me opportunity for a follow-up. Minister, for times now, you've been referring to your concern that would have arose from your consultations with the interim chair that you said was overseas at the time of the meeting. And then you said it was a consultative meeting with the board. The board has expressly made it clear that that was an instructive meeting. they didn't interact with yourselves, and there was a person that you said in the meeting is in deputy chair, which they can't confirm because they don't know that person to be a deputy chair, briefed you on their matters without consulting them. So there was a presentation the board members did not know of. So I just want to, it was a follow-up on the first question of Honorable Law on the meeting, the setup of the meeting, before he got to my second question. Maybe if you could just clarify us, why would you have continued with the meeting without the interim chair?
You have asked the question.
And the person, it wasn't consultative as
You
well.
are asking the question for the second time. Minister?
And I think I've also answered the question, Chairperson.
Yeah.
Thanks, no chair. I'm coming. Let me take Ndadem Gadi. Ndadem Gadi, you would have made a presentation about the SARS data that should have an access to the system. And in my understanding, because at least I'm an HR person, before that you can go to a system, you must get approval. How to is it that the person that you have alleged that is given access to SARS that particular way? Can you confirm that thing? Because there's a particular way, a law, a policy that prohibits you to get approval in a certain way to get to SARS. I want to confirm that.
Well, thank you, Honorable Law. When this board arrived at NSFAS, because of its policies and data integrity, it had been kicked outside of SARS. And therefore, it would have enabled an environment where those findings of audits of funding dead people would have been done. So our first priority were to pass data policies, including data management and security policy. That then would have been enabled us to be reintegrated back to SARS. So how we would have then measure that integration is the year that is following, which was starting. So the first phase that this board was seized with is to keep the lights on. And you'll see that even in an unaudited performance, annual performance plan, we are sitting at 64, which is above 50. In more than a decade, we've never seen such performance. And of course, we would have come here on the 31st, AG would have received our annual reports and our financial reports. For the first time, we're on course to submit on time. And until then, this disruption of the board. We were integrated back. And of course, we're exploring, we have a lot of conversations with AG around what the minister would have articulated, what other data sources can we use to get closer to making, I would say, correct funding decisions. Thank you.
Thanks. Minister, what propels me as a matter of concern is that if the closeout report of the former administrator is not out, it becomes quite difficult for one to measure as to the progress of NSFAS. And I don't want to quote on what could have been said in Parliament or in the portfolio committee or into that. And then I want to check for you, what measures are you putting in place to ensure that what measures are you putting to ensure that the report is coming out? And then what measures are going to make sure that we don't have these tupicles? Because I can't enter into the court issues now. I want to know how will you handle the report, because there's a second opinion of the board about its progress, all of its imperatives. Now we're still waiting for the report to be taken out. What becomes a recourse in this particular way to analyze this particular decision of NSFAS in their progress?
Which report are we referring to?
The closeout report of the administrator. Is it out? Is it received?
No, so as I said, that there's a dispute that and there's been some consistent discussion between the NSFAS, the department, and the former administrator around the closeout report of the NSFAS. And the dispute relates to the former administrator, in this case Nomvalo, believing that his contract was terminated earlier than it was supposed to be. And on the basis of that, has not handed over the report, pending what he believes is judicially or fairly, owed to him by the department. So that's why we don't have
that report. But I think the general performance of the NSFAS in that particular period is something that's of public knowledge.
No, very quickly, Chair. The first one is that I think you had already granted my follow-up earlier on, but I think you said you're going to allow them to respond after Honorable Christians on the unlawful instruction, if they still remember it. But the follow-up to Honorable Law is that I think the legal of the department must not be allowed to run away from this question. Honorable Law is not asking about the merits of the case. Honorable Law is asking, can a formal meeting between a minister and the entity of the department take place without a formal invite, without an agenda, without minutes? Let's put NSFAS aside. Let's say it's a CETA, let's say it's NSF. That's what I understood the question to be. So I don't want legal to run away and say, no, let's wait for the court. We're asking you now as a legal person, can that happen? Can a minister sit a meeting with NSF, no agenda, no formal letter invite, no minutes, exercising public power?
No, DG, this one is for the advocate. It's a general question. So just give a general response. Yeah. No, DG is not going to answer this. Advocate.
Thank you, Mr. Lonsi. I would not advise that anyone, including the minister, do what has happened. It is unfortunate that it has happened, but I would advise against it being repeated. Thank you.
They will answer after lunch. We'll remind them the question. They will answer after lunch. Honorable Law.
Thank you, Minister. Lastly,
no, I told the police they will come at lunchtime. Don't worry. No. I told them. I told them that. No. They were saying they want to clamp it. I told them we'll come at lunch. Yeah.
You're not the chairperson.
Honorable Law.
Minister, my last question in all of that, because I would not want to have issues. I want to check what your appointment of an administrator. Did you appoint a fit and a proper person for assessment of Professor Matebula prior for his appointment? And what was the process when you appointed administrator in all of the dubious of NSFAS? Given the fact that you are from the 3 or 2 administration, what was the criteria that you could have taken to look onto the problems and put the person? Thanks, Chair.
Okay. As I've said, that I believe, and that's why I went ahead with the appointment, that Professor Matebula is a fit and proper person. But also importantly, with regards to the person that we're looking for, was someone with a strong background in finance, but also with the understanding of how the system operates. And I think that based on Professor Matebula's profile, he does meet, the kind of person that an NSFAS administrator should be, and also the looking at the scope of the responsibility that he is to undertake. I think that he is, of course, and maybe just to also include, that he's at the Tshwane University of Technology as the head of the business school. He's also served in various, boards and institutions. So I think all of that cumulatively makes him a fit and proper person.
I'm asking this because earlier when he was appointed, he was at the allegation that when he was employed at SARS, there was several investigations that took place, the Commission of Inquiry, the Nugget Commission, and then there were final reports on Professor Matebula. Maybe I'm asking that based on the fact, and did you look onto that, because NSFAS is quite complicated and it's quite having a lot of allegations and stuff. Did you look onto that particular individual to say we're this particular way? And I'm not sure, what were the reports saying, both Nugget and SARS? Did you look onto the reports? Do you have the findings of the report of the particular individual? What did they find about the person? Things?
Yeah. Well, Prof. Masebula did bring to my attention the issues, the report around SARS, and we made inquiries, which included the fact that subsequent to that report, not only was he not, barred from serving in a public or administration office, but he also actually went on to serve in various boards, both in the private and public sector. And also, I think those include the MDDA and so on and so forth. So I don't think that, the reflections made, which also included the fact that he cooperated with that investigation, that ultimately what came out of that report would have disqualified him to serve as NSFAS administrator.
Minister, in paragraph 6, the Nugget Commission criticized Professor Matebula for being willing to investigate SARS employees at the behest of Mr. Moyane without having been given any indication of what they could have done. As per paragraph number 6, in paragraph 12 to 14, the Nugget Commission noted that Professor Matebula signed this support for urgent approval request without properly considering them. It records that he had claimed to have done so in pursuit to threats by Mr. Moyan, which at the ultimate end it has never been reported by Professor Matebula. Those are the allegations that were leveled in the commissions of Nugget. Hence I'm asking, because NSFAS has been accused of HR issues whereby they've been victimization, and NSFAS has financial issues that we could have been dealing with. Hence I was asking about a closer report, and NSFAS will not need someone who's been hanging on the commission if we must deal with that. So I was pulling all of this so that we can be able to look onto, if we look onto the thorough individualistic part of the integrity, and the person who should therefore assume if that person must be an administrator. So already me as an individual, I will have a problem with someone who would have such issues in the commission where we need to have NSFAS to be fixed, and where there's a view in society and the view that's divided that says NSFAS was doing good, we could have just added the numbers as per section 8 of the NSFAS Act and closed the gaps and move in that way. So I'm putting it into these things, and I'm asking myself, how will you deal with such, because there's a report that is quite explicit and telling us what could have happened to the person you've put at the hem of the problem. So at the problems that we are having in terms of our engagement is how we could have put the body to resolution to the courts, and then secondly, the person that you've appointed to look thoroughly to the person, and thirdly, I wanted to know what becomes the procedure and what becomes the criteria to identify the individuals who therefore comes to be administrators. And then, Chair, I'll submit my questions. Thanks.
Okay, I think I did indicate, Professor Matebula's credentials. I also did indicate that I've looked into the issues that you've raised in terms of, of SARS. I think the Commission's report was, if I'm not mistaken, 2018, 2019. I did also look at what Professor Matebula has done since then, the institutions that he's led. I've also looked at whether he has been disbarred from serving in any public office, particularly such a role. And I must also emphasize that, there are rules, regulations that governs the NSFAS, including the NSFAS Act and various other policies. And I think, there would be no hesitation if in any way there is a breach of all those particular And for me, what is important is that, based on his history, particularly in the private and public sector, he is the right person to stabilize the National Student Financial Aid Scheme.
No, thank you very much. It's 1:30. Let's take, DG, you want to say something?
Thank you, Chair. Taking advantage of the fact that we will have a lunch break, I advise that you consult the parliamentary legal colleagues who spoke earlier. Because in as much as we have committed to ensuring that we are alert to the matters being sub judice, but when arguments are made, I think we are treading on a thin line. It's not for me to make a call, but I think consulting with them would assist. Thank you, Chair.
Okay, thank you very much, DG. We will respond after lunch. Let's come back at 2. Let's come back at 2, colleagues.
that the interim or the acting chair had concerns and called for a meeting, this meeting that I myself was not invited to. But I find it somewhat odd that him having called the meeting, he was also not in attendance at this meeting. So I find it very, very curious that a person that calls the meeting to raise concerns doesn't attend the meeting. So I wonder if that was really the agenda. Thank you, Chair.
Just to indicate that my my discussion with the chair was that you know, there are these issues, and I indicated that you know, so because of the agency within which he had raised the issues and the fact that he was going to travel, he did you know, give permission that I can interact with the board in his absence, because what it indicated was that the there was a petition towards him as the chair for the you know, for the board to meet and to ultimately take a decision on the you know, on the question of the CEO, given the fact that I'd formally asked the board to conclude that process, and so because of that agency, which I'd emphasized, you know, we both agreed that you know, the meeting can go ahead. He had already given me his side of the story in terms of why he felt that it was necessary for that engagement to take place. I must also indicate, you know, Chairperson, that I think it's an important emphasis that we, you know, have a responsibility when there are concerns raised, especially by a chairperson of the board, to ensure that we follow through. You know, I think it would have been irresponsible of me, you know, to allow that, you know, what concerned the chair of the board, you know, not to have been attended to, and that's why that process happened. And in any way, you know, the chair would have been available in the subsequent report that you know, the board was to present around how they finalized the process of the appointment of the CEO.
Honorable Govan.
Thank you, Chair. Baptiste, with a yes or no response, I just want to, I wanted to be out there and clear. Did you or did you not interfere with the process of appointing the CEO?
No, I did not interfere with the process of the appointment of the CEO.
Thank you, Patricia. Chair, can you please, the House note that there is an information that is misleading in the House, either from the side of the former board members or from the minister. But all that I wanted to ask about this issue of having reports on the meeting of the 13th of April. But can we further go or move, Minister? The coming to the decision of the administrator, what were the milestones in your head that you wanted to achieve when you came about in appointing the administrator? And in that, can you also please also refer to financial implications or financial package in remuneration of the administrator? Does he have an advisor? If he has advisors, how many are they? And how much is being spent on this? I just want to come to think about it, because we had witnessed that the administrators that can be put in place without their prepared package, and we have problems afterwards. Have you considered the package and how much is it? And also indicate the measurable milestones that you would want to see as an outcome of this administrator.
Thank you very much for that question. I think firstly that the
the issues around the terms and conditions of the administrator, especially remuneration, and the advice are being finalized with Treasury, because we will require concurrence from National Treasury in this regard. And I think that if I think members would appreciate the fact that, in our view, you know, this work had to be done, and that you know, the terms and conditions with regards to that has to be exercised with a lot of caution, you know, and regard for the national fiscus, you know, and so on and so forth, and that you know, I think upon finalization of the terms and conditions of the you know, of the administrator's service, we will brief the portfolio committee on that. And then with regards to and the you know, the advisory, or the team of advisors, remember that, so the administrator, in as much as they are competent in particular areas of expertise, there would be those technical expertise that either exist within the institution itself, but also expertise which they may deem necessary, that they can invite to, you know, to help to advise the administrator, and all of those includes issues around, you know, audit remediation, forensic investigations, you know, issues around public finance, issues around, you know, information communications technology and data, student funding, accommodation, legal services, and risk management. So collectively, either individually within the advisory component, or as part of the capacity that exists in the board, the administrator will have to look into those. And then the stabilization plan, or the key milestone, includes, I think importantly, operational continuity, but also the audit remediation, being responsible for consequence management, and then the data analytics resolution. I should say, Honorable Governor and Chair, that I have consistently and persistently been engaging with the NSFAS around the issue of data integration, not just with you know, with SARS, and my last engagement, you know, and the response that I received from the board, which or management, I need to recall whether it was from the chair or the executive management, that last engagement was quite explicit that the process of data integration has not been, you know, completed, either with SARS, that there were discussions that were taking place, but that process had not been completed. And similarly, you know, with regard to the HATMIS, which is our Higher Education and Training Management Information System, you know, and so on and so forth. So this is one of the milestones for, you know, for the administrator, and then the closeout reports for TVET, the ISU investigations on student accommodation and so on, and also the digitalization strategy of the NSFAS. So those are the key milestones that we've identified.
I'm hearing you very correctly. But I just have one or two more questions. In February this year, we all sent out a message that was very clear to the public that for once in a lifetime, we think NSFAS is actually becoming stable and is responsive to the challenges on the ground. Now in May, we are here. The developments from February till now, what was so hectic that we find ourselves in this situation now? In terms of how we have combined all resolutions that were taking place, in just 2 or 3 sentences, what has brought us into this? Because we all have been sending a message out there that things are stable. And what does this mean to NSFAS beneficiaries in the country? Because where we find no stability, it affects them directly. Because I'm trying to figure out, will the administration have any bad impact on the beneficiaries themselves?
Firstly, and I think that's an important question, this administration can only have a positive impact, to complement the work that the executive and staff at the NSFAS has been doing, and that none of the actions of the administrator is meant to affect student allowances. In fact, it is meant for us to actually, stabilize all of these issues that that I've mentioned. So that's the first. The second thing is that I've indicated that from October last year to I think around the 13th of April, which was the last meeting engagement that I had with the board, I'd cumulatively met with, and I must emphasize this, I know the former board member, Advocate Ramashia, indicated that it was not 20, it was 5. I was very explicit that it's a split between my meeting with the board itself and also my engagement with the administration, meaning the acting CEO and members of the administration. So those 20 engagements were not necessarily with the board itself. That number includes. So all of those were intended to support the board to ensure that we have a proper reopening of the academic year. Also, I must and maybe to use a sport analogy, is that a team can be good today and be bad the next match. So if you look at the statements that I made in February, most conditions, outside of the other issues that I've mentioned, the board itself, its composition, and so on and so forth. In my view, at the time, are what I referred to, which is being, quoted. But in April, the conditions were different. You've had now, again, an interim chairperson who've resigned, together with, the chair of the Human Resource and Organizational Design Committee. So situations can actually change, either in a much longer period of time or in a short space of time. I mean, if you look at the series of resignations that happened, the first one happening, in the first week of August, hardly a month of, being in office. And at the time, I was not even, aware that there were protests around the composition of the board, where the deputy chairperson resigned. And then, I think a few months later, the chairperson then resigned, Dr. Stander, together with 3 or 4 other members. So things do not, I mean, at the time when I went into office, there were 14, I think, not 14, but, a full composite of the board, and in that short space of time, about 7 or so members had already resigned. So a board can be good on a particular day and so forth. And I think it also applies with the self-review, that a board may be appointed not on the basis of the legal prescript, but it does not mean that that board will not effectively function. And like I said, I mean, the board had, in that financial period, about 28 meetings or so. So I think we have to so the one does not necessarily mean the other. If I say that stipends were paid, and so on, of course, to suggest that there were no protests at all, myself, Honorable Lonzi Msezana, yourself, Chair, together with some members of the Portfolio Committee, ourselves were outside of Parliament when there was the question of student accommodation on a weekly basis. In the meetings that I was having with the board, in the war room, those meetings were intended as to stabilize, to stop the fires, to attend to issues in real time when they're supposed to. I think in almost every second meeting, the student leadership would come with a set of issues, and some of them even threatened. So all I'm saying is that it was not exclusively the work of the board, that things work, and I'm not suggesting that they didn't play a role, but I think to fully attribute that to the board, even on tasks which. Exclusively, and just to mechanize. If the board, just a last point, Chair, the board can take proper decisions, and they can have an executive management that doesn't follow those decisions, and so forth. So I think to relate the 2 points, would be quite unfortunate. The reality is, as the situation obtained. And based on my consultation with the former board members, as the reality obtained on the 4th of May, I strongly believed that in order for us to be able to save and stabilize the National Student Financial Aid Scheme, we had to introduce, an administrator. Thank you.
Okay.
Chairperson, just one last question.
Yeah.
Minister, there are allegations of people under your leadership, that is under your management, the administrator of sector, the person in your office, allegedly called the former board members. Where we are seated, would you in the form of responding to the question that we have in our minds, why will these people or these certain members that are alleged to call the former board members speak something that we have not sent them to say what was their, what did they stand to gain for lying? If you stand firm that you did not send them, what are you going to do with them in finding out what we have found out today? Because if you say, Minister, you did not send them to speak anything that was on your behalf, what measures are you going to take in place to correct the lies that have been perpetuated around your name, and also about the integrity of the city that we are sitting in, because that seat belongs to an organization?
Well, yeah, maybe just one comment. I think I'm as much your serving as your Minister, Honorable Governor, as much as I'm serving as Minister for Honorable Lonzi and everybody else here.
And
but
Honorable Ngubani of
Ngubani,
even though there they want
and how I can go on, but I think that the point is that the said people are not here to present their version of the events, and hopefully when they do get an opportunity to do so, they will, and I think those issues will have to be dealt with on the basis of their merits. I don't think I'm placed to make comment now on discussions which are was not made private to. So and I'd like to leave it at that.
Lonzo, does your follow up?
I had a follow up on a question of Govan, but I wanted to also remind you of the earlier thing, because I think you'll forget it, Chair. You don't want to give them, or I must ask.
Do you still remember the question, Advocate? What was the follow-up?
This new one or that one?
That one.
Or that one. No, I was saying when the minister was responding, he says that when he was listening to the discussions here, the board members have not made any claim that he gave them an unlawful instruction. And I said I differ to that because the way I understood them, they were actually saying substantively that the minister gave them an unlawful instruction. So I wanted them to confirm that just for the record, yeah.
No, thanks, Chair. I remember the question. I think the what I understood the minister to be saying, and I agree with the question, what the minister would have said will not be correct. We did say, and we said this, and because I said we have got a different understanding of the principle of sub judice, we said it in our court papers that we understood the meeting to have been an unlawful meeting and unwarranted. We did canvass the idea before today.
Okay.
And then my follow-up on the issue, it was when the minister was talking about the number of board members. So on slide 8, the minister says there by April 2026, board had 7 or 18 members, then says no chair, no deputy chair, no acting chair, and then says had failed to comply with directive and purported to appoint CEO without concurrence. And maybe this question I put it to legal again, because the NSFAS Act says is concurrence on the terms of service. Now, I wonder if the legal of the department would want to explain that important distinction to us. What is your understanding of concurrence of the appointment and concurrence of the terms of service?
Yeah. Advocate Kuta.
Yeah, can I come back to the question? I just need to check what
Okay.
you said. Yeah.
No, it's fine.
Thank you.
Honorable Nguban.
Yeah, thank you very much, Chair. Yeah, to me, I think, Chair, still I can't ascertain the real reasons for the minister to put the NSFAS under administration. I think one of the statements was quoted by, I think, a gentleman, the one for the 24th February, where the minister himself said for the first time NSFAS performance has improved. And then he said for the first time as well, first time entering students knew their funding status before matric results were released. And continuing students knew their status before the end of the previous academic year. And there are many other statements that the minister has said which showed that really now there is an improvement in NSFAS. There are many. The other one is the statement on the portfolio committee on 25 March 2026, and then on the 14th November 2025. And even the gentleman here has confirmed that there is a whole lot of things that they've done which show an improvement in NSFAS. The request again for me is to revisit again the question to say, which is the specific reason that the minister can give us to say, really, these are the reasons because it's holistic reasons that are put on front end. I'm trying to nip at least one that maybe can say, maybe this is the real one. All of them doesn't match up to what I'm getting as a feedback to say, from way back at this juncture, this NSFAS, for the first time, there's been an improvement in NSFAS.
Look, firstly, I think it was probably an error to indicate that this was the first time that students knew, the funding decisions before. It may not necessarily have been all the students, and it may have had its own challenges.
So it was an error on your statement.
And similarly, if you can just allow me to finish. Similarly, with regards to this year, it was not without its own challenges. Now, this does not in any way take the fact that the NSFAS, and it's, well, the NSFAS, firstly, the executive and the administration worked around and being supported by the department and all of us to make sure that it meets that particular milestone, and the role that the board had performed. But it does not take away, the fact that there were all these things that were happening in terms of the board itself, and I think we need to make that distinction. That, and as I said, that an entity can do those, can disburse funds, can make sure that students are paid on time, and so on and so forth. But you may still have the challenges that were raised by by GTech. You may still have challenges raised, by the AG. You may still have the challenges that were, occasioned by the successive resignation of the NSFAS board members themselves. So that's why I said that we need to make a distinction between the two.
But I'm saying, Minister, you mean it was an error on the statement you were saying of praising NSFAS to say...
No, it was not an error to praise NSFAS. So it is important that we, all, and I think that's the sentiment I suppose you share, that comparatively speaking, with previous academic year, the challenges that we normally face in terms of disbursement of allowances and so on and so forth, but also as it relates to protest, that those were relatively lower, comparatively speaking. So it wasn't a mistake to mention that. But I also think that it may have been overzealousness, on our part to suggest that some of the things were only happening for the first time. Some of the systems were, of course, in place, that were in place even in previous years, with regards to allowances, with regards to, and so on and so forth.
Now, that overzealousness, Minister, is noted, yeah. And then here you are, everything is going very well. You're even giving the board instructions to go ahead and appoint the CEO by the 31st of March and many other instructions. This board that was doing very well, turning around NSFAS, and while they are busy doing that, and there's even that panel review that you were still waiting to get its output. And again, with all those, so you chose then to just stop that, to stop those instructions and everything, to say now, if on the probability of scale of reasoning of putting the NSFAS administration, now all that instruction you've given and the review. Now the other item, it says now the NSFAS must be put under administration.
What tanda masita? Even when we're talking about NSFAS, it's a slip of the tongue, but that's okay. That's the other preoccupation which we have. If you may allow me just briefly, just to explain the self-review. So I approached the self-review process in good faith. My intention was not to put blame on the NSFAS board. My intention was to ensure that we set the decision that has been taken to appoint this board, aside, so that we start a new process. And that process could have been anything else. It could have either been, gazetting nominations and so on, or it could have been, an administration process. And this process of the self-review started, officially when I engaged with the board on the 4th of November, but it was a process that had started even much earlier, I think a month or so earlier than that. So it has it's now, I think, having a life of its own, and I think the date of that will be determined. But I think the important distinction that we need to make is that that application was made under different circumstances. Circumstances within which, there was a chair and I think there was about 12 members that were, that were remaining in the board, and we were also legally advised that the only way in which we can, set aside the board is only by approaching the, the court. So it's a different set of circumstances that necessitated this. Now, so we didn't have the resignations, as I said, and a series of other things which I have explained, which led us to, to the decision to appoint the administrator. I think I quite extensively indicated what those reasons were in the board, and I accept that, this would be issues of difference, but I think the facts are there to speak for themselves.
Okay, all right. And then, Minister, coming then to this appointment of the CEO, there is an information that, I don't know whether the board members will confirm that. There was a first advert that went out publicly for the appointment of the CEO. And then there were respondents, right? And then was there another second set of trying to fix the list of the applicant, to correct it or to make it, if there were any other corrections? Or there is a perception that there was an advert, and then I don't know whether it's you, the minister, or the board, and then the applicant, the response was looked at of the candidate that applied, and then someone said the candidate is not gender reflective, there are not enough women. Then they need to go and look at how can they have women. Was that from your instruction or from the board or the HR committee?
I honestly don't remember. I may have to look into that, but my recollection is only that upon the board requesting me to approve the extension of the acting CEO, I then instructed them to further, upon concurring with their decision to have the acting CEO's contract extended. I also, in that same letter, because I was concerned that the acting CEO was acting for more than a year, so I then put the ultimatum that the process for the appointment of the CEO had to be concluded on the 31st. I mean, the rest of the stuff I may, I think recall from memory as to why, there was no appointment. I was mostly concerned with the fact that at that point, when the board was asking me to extend the acting period of the CEO, that there seems to be some tardiness as it relates to the appointment of a substantive CEO.
So there was no sort of like looking at the list of respondents to say, as far as I see, there is no reflective of gender on the list of candidates from your side.
I don't remember. I don't remember seeing a list of candidates. I don't remember. I'm not saying that there wasn't, but I'm saying I don't remember those candidates being presented to me. I have absolutely no recollection of such a thing happening.
Okay, were there two sets of recruitment, one called advertisement and one called headhunting in the process of recruiting the CEO? Can I get, if the board members here can confirm that, if the minister doesn't know that?
Through you, Chair, yes, it is true, Member Ngubani. We did run the first process of recruitment, and then exactly as you are saying to say, we had to go back again through the headhunting process so that we were able to address the gender imperative. It was a resolution of the board that was direct to say it should have a gender balance. The candidates, yes, thank you.
Okay, all right, so that process happened, and on that addressing the gender balance, and then boom, we see Mr. Busani Ngaweni coming in. And again, there's no gender footy there. And then the male are still coming in, but now the process looks legit whereas there's no gender address.
Yes, you are correct, member. Thank you.
So would I be correct then that the second process of headhunting was to slot in Busani Ngawin on the list so that he becomes a candidate that is going to be chosen as the CEO of NSFAS?
Not in as far as the conceptualization of the board was. The board received a report which had recommendations from the HR committee indicating exactly what my colleague says. The intention of the board was to ensure that there is a representation of female candidates in the process. But my colleague has already confirmed what you had asked, and I would agree with you to an extent that you may say that a perception may be sustained in that respect. I agree, but that was not the understanding of the board.
Okay, Chair, this is information at hand.
Hold on.
My hand is up on the platform.
Yeah, hold on. Hold on, Honorable Nguban. Thandi, I'll come to you, Honorable Maime.
Thank you, Chair. I just have a question about my understanding. I'm not sure whether the names of people that are coming up as part of a confidential process. I'm aware that they were in newspaper reports. I'm not aware that this Parliament has discussed what is actually a confidential selection process. The reason I'm asking that is because I was part of that selection process, and I'm not very sure why we are discussing a confidential selection process in this format. I am aware that there has been some allegations, discussions in the media, but I'm just wondering if I'm asking about the legality of that, Chair. Thanks.
Okay, Honorable Maimela.
Thank you very much, Chair. I was coming in on that point, that I was worried that you did not call Honorable Ngubani to be cautious on this matter. As members of the Portfolio Committee, in the presentations that we've received, there is no names that we've received that are on those presentations. And seemingly, Honorable Ngubani then might be using information that we're not privy to, that was not presented in this Portfolio Committee. And I'm worried because if it is information that was presented that somebody else have, I would also want an opportunity to engage with that information. So he mentioned a name, and I don't know where do we get this name from, the presentation, official presentations of the department, or is it that we're discussing this name on the basis of some media presentation as the official of the department has just said? But I'm very worried about doing that, because if we delve into that, there's many other names that we're going to be dropping ourselves who are coming after, and we have been cautious in our preparation of questions not to do that. So, but if you allow Honorable Ngubani to do that, we are also going to delve into that. I was just raising that caution.
Honorable Lonzi.
Chair, I'll allow you to make the ruling on the name of a person, but I think where I want to come in is that it would be incorrect for members or anyone to suggest that Honorable Ngubani is trying to target someone. The way I understood his question was that the department goes to advertise, and then the results come back. And then the results come back and they give a report that we don't have enough female representation. They then say, because we don't have female representation, we are going to go and start a headhunting process. But what becomes questionable about this process is that it does not bring back a female. That's the spirit of his question that I understood it. Maybe on naming of people, I'll leave that to you, Chair. But the spirit of his question is that it seems as though this headhunting policy was, even if the intentions initially were genuine, but the perception that goes out there is that it did not achieve what it intended to achieve. I think I'm just coming into, that's how I understand Honorable Ngubani's question.
I can add, Chair, the reason why I might have added the name if the name need not to be mentioned. I might add the reason, Chair, why I'm asking that. It's because
maybe let's make because an order has been called.
Yeah.
Caution you that don't mention names of people for the credibility of our meetings.
All right.
You might have that information and other members don't have it, and it makes it difficult. So maybe let's not add names of, you can still make a point without
all right.
necessarily going into.
Okay, the point here, Chair, I'm trying to make is the information we've been given of the administrator of services SETA, which the name was given to us here, who said there is an instruction for a specific a name to come up, which gives us this information that somewhere, somehow, the first advert went out, and then as the process goes, it was realized that there is a name that is not in the list, so that name needed to be slotted. A second process was started called headhunting. And when the second process for headhunting was going on, a new name came up, and this new name is the one that we have found ourselves being seated here today, that was purported to be elevated as the one that will be the CEO. That's the information I wanted to bring. Okay, and then coming to the next question, Minister.
Minister wants to make a comment on.
I think just to indicate, because I think Honorable Lonzi said the department advertised, so this is a process which was fully in the hands of the NSFAS, as the department were not involved, and that's why I don't have recollection, and I actually am reminded. I'm benefiting a lot from the report that they're on. So it's not something that I was involved in. I'm not aware of that.
Yeah, okay. No, I think the information, I've got it. It's confirmed that what I'm saying, it did happen, of two processes of recruiting, the one called advertising and the one called headhunting, which a new name came in. So did the minister instruct board members to hold the CEO process for him to conduct political consultation?
No.
There was no instruction of that nature?
No. What I said to the board, to the members who were in the meeting, was that they should conclude the processes. Sorry. They should conclude all the processes that relates to the appointment of the CEO before going ahead to, to appoint the CEO. So I didn't say that they should halt the process. I didn't say
for
that,
political consultation.
No.
No. Okay. Did you advise the board that you need to be briefed on the outcome of the CEO process as they deliberate on the matter as it goes on?
No, so I think the point that the point that need to be understood is that the meeting was because of the concerns that the interim chair had raised around the board members petitioning him to want to have a meeting of the board to finalize the appointment of the CEO, and the interim chairperson's concern was that that meeting may go ahead before the board had concluded all the internal processes, which included, I think, as I had in the meeting I had with the board in the National Humanities offices, was that the HR process, Human Resource Committee, an organizing committee had not completed, and that the board will, go ahead. And I asked the board that upon conclusion of that process, they need to indicate to me and that they are ready to proceed, with the appointment of the CEO. And I think for me the important thing was that all the processes that the board needed to follow before the board meets to decide on who the CEO becomes, should have been, all the boxes should have been ticked.
It's a follow-up.
No, finish first, Mlunguban.
Okay, all right. The minister, there is a perception that you engineered the resignation of the two board members. Will that be correct?
I have not engineered
For the purposes that the board did not do the process the way maybe you wish it to be.
People have been resigning in the NSFAS board. I mean, the chairperson resigned, substantive chairperson resigned, the deputy chairperson resigned, 4 board members resigned, and following that, an interim chairperson of the board resigned. Chair of the HRODC committee resigned. I think if with whatever powers that I can have to suggest through perception or insinuation or innuendo that I may have engineered the resignation. But I also think it brings into question the reputation of the of the board members, all of the board members who served, and I think they themselves have consistently repeated this, that there are people that I hold in high regard, and I think if any of them would feel that I have in some way or another pushed them to either resign and so on, I can just imagine instructing Dr. John Mugwena Maluleka to resign or engineering his resignation. And I think the resignation letters are also there to, to be seen. I deny any involvement in the resignation of any of the board members who have resigned from the board. Of course, I was concerned, about that, and that's why I think it necessitated, whatever action.
Okay. Advocate Kuda, you are ready for us.
Chair, thank you, sir. Thanks for the opportunity. I've checked the Act, Section 9, subsection 3. The board must, with the concurrence of the minister and the Minister of Finance, determine the conditions of service of the executive officer. And I think the question was it coming from you, Mr. Lons? Can you please repeat the question?
The question is,
yeah,
the concurrence issue, is it on the appointment of the CEO or that service level agreement or whatever how they termed it there? Conditions of service.
Yes, thanks, Chair. The Act as it is just refers to the conditions of service. And my interpretation, Chair, would be that why would a must be used for the minister to concur on the conditions of service whilst he was not involved in the actual appointment, and saying, I concur with this particular candidate that you have put forward as the CEO. For me, I took it that the concurrence would have occurred first with the name that is put forward, because the conditions would be linked to the particular CEO that is appointed. It won't be applying to anybody.
And why do you think that part is not covered in the Act?
I'm trying to check the charter, what it says, and unfortunately, I didn't bring the copy of the charter, but the Act is very clear. It's about the conditions of service. But for me, I feel that there is a gap, because there is a must that the minister must, with the Minister of Finance, deal with the issues of the conditions of service. But who are they dealing with here? Because somebody whose name would have been put forward and they would have participated in saying, we agree with this name, and therefore, here are the conditions of service that we will agree with or concur on.
So you agree with us that what we've been singing all along, that the acts that we have got serious gaps in them. So I'm happy you now agree with us, because that's the point we've been saying. Not only the NSFAS Act, the CET Act, the Higher Education Act. So I'm glad you agree with us. But the question was, yes, there's a gap, we agree. So, but the question is, does it speak to the condition of service, or does it speak to the concurrence on the appointment, as it is now? Let's leave the gaps part. The Act. Yes?
The Act does talks to the conditions of service.
Okay. Minister?
Hence,
Yeah.
sorry,
Oh, yeah.
Chair, hence, I was hoping that the board charter would have covered something around the actual appointment or the actual recommendation of the name of the particular candidate. Thanks, Chair.
So you need more time to check the board charter. Okay, how long? Maybe 30 minutes. No, I'll give you now, Minister.
Okay.
You'll check it now, the board charter. Okay, thanks. Minister?
I think just, I don't know if that would be necessary, because in my head, I have no doubt in terms of what is required of me and what is required of the board. The board appoints the CEO, and upon appointment of the CEO, the board seeks concurrence in terms of the conditions of, the terms and conditions of employment. And I've consistently understood this, to be the case throughout.
No, thank you, Minister. I think we're on the same page. You wanted another? Okay.
So I think the minister is helping us a bit, because advocate probably was running away from this question. And the reason this is named is the reason I asked advocate this question, Minister, because if you go to your slide 8, you mention the board not listening to a directive and it's how you write it. Maybe let me go to it so that I don't just paraphrase it. You say there, Minister, that, sorry, Chair, I just want to read it correctly. The minister writes on slide 8 that failed to comply with directive and purported to appoint CEO without concurrence. Now, that's a very problematic statement. Worse when you have explained your duties the way you have explained them. Because you correctly point out that in the NSFAS Act, and this is why I don't take advocates' explanation, the Act is very clear. It's not the job of the department to rewrite the law, it's the job of Parliament. Parliament has given the powers to appoint to the board and given the powers of concurrence of terms of service to the minister and the Minister of Finance. So why would the minister then, in the presentation, say, purported to appoint CEO without concurrence? They don't need the concurrence of the minister to appoint the CEO. It's the board function. They only need the concurrence when it comes to the terms of service. I just wanted to make that point, Chair.
But importantly, the process of appointment does not only end with the decision of the board. The process of appointment and assumption of duty ends when the Minister of Higher Education and the Minister of Finance has concurred. So that line is not inconsistent with with that provision in the slide.
Okay. Yeah. Okay. Dr. Mukadi.
Thank you. I think just for the Member of Parliament's notes that even the current administrator does not have the concurrence of the Minister of Finance, and that's what the Minister would have presented there. So when the appointments take place, it's very important, I think, for the point of discussion. Yeah, assumption of truth. Thank you.
Honorable Khaha, you want concurrence to speak?
Thank you, Chairperson. Chair, let me firstly be clear on this. There are a plethora of reasons available not only to the public, to this House, but to your office, Minister, that justify why you wouldn't want the CEO and the then board to continue doing their job because of a plethora of reasons. That's not my problem. My problem is that your approach was clumsy, Minister. You had one job. Your job was to make an analysis of whether NSFAS in its then composition made sense, was delivering service delivery optimally, whether the leadership was desired, and by desired not by your own political desirability, but desired in that were they able to do their job properly or not, and based on that make an assessment of whether life continues or whether life changes. So that's fine. And the Act says you can put them under administration. Yours is just to have a consultation with the board. And even the Act doesn't say they have to agree. You can just have a consultation. So that for me is not an issue. My issue is that your approach was clumsy. Let's park that. My biggest problem with you, Minister Manamela, is your choice of administrators. So even if I, under any circumstance, want to believe that your intentions for placing NSFAS under administrations were pure, because of your natural choices of administrators, not only for NSFAS, but even for SETAs, that automatically poses doubt in my head of the intentions you have on the basis of your choice of administrators. I'll recap, right? Let's first go to your SETAs administrators. I wrote to you on the 19th of August, 2025, giving a short summary of why the choices of administrators you chose for your construction SETA, local government SETA, and services SETAs were problematic. And you would note that I didn't have a problem with the reasons why you placed those SETAs under administration, because I agree that they are a problem. In fact, they shouldn't exist in their current form. So that is not a secret. But if you want the Republic to believe that your intention is to really fix what is wrong, you need to be able to convince the Republic that the people you are giving the mandate to go fix what is wrong, not only themselves do they have the intention to fix what is wrong, but that they have the capacity to fix what is wrong instead of creating more problems. As you sit, you cannot till date still justify why Upangwane is the administrator of the construction SETA. Beyond his implications through his jobs that he has done with government in the past, including the Mfuleni local municipality, with construction SETA alone, you still cannot give us confidence that that man is the right man to fix what is wrong with construction SETA, because he himself has his own issues, which is the basis why I've laid criminal charges against him. You have Zukile Mvalo, your DG, who's been the boss of Zukile Mvalo for all the years of Zukile Mvalo, cannot justify to you that Zukile Mvalo's performance as DDG of skills development is so impeccable that he has the sole expertise in this country to fix what is wrong with SETAs in the country. You yourself cannot do the same, which is why that is not the reason why you gave that is not part of the reasons you gave the Republic for choosing him as the administrator. He himself is the wrong person to have even tried. He has zero capacity. He had zero capacity to manage his own diary, let alone his ability to whip any SETA into action. So he had absolutely no business being your choice for local government SETA. We'll have another conversation as to why he's even messing up now as administrator. And then you have Ntatele Tlhogonolo Masog, who for some, they could argue that he's an agent of compliance by yourself and nothing else. Not only is he a politician of the ANC known for his track record in Limpopo, in the Limpopo legislature as Speaker and as MEC, but The whole entire Makaro Masina SEZ's problems have his fingerprints all over them, and you know this. You have forensic reports that tell you this. This is information you know and have at your disposal before appointing these people. Now you have another opportunity to say, okay, NSFAS is a problem for the country. NSFAS is a problem for young people. We still have an ICT problem. We still have a disbursement funds problem. We still have a missing middle problem. We still have a student accommodation problem. We still have infrastructure I can list a whole lot of things that are still a problem. I want somebody to fix it. And the first person you think of is somebody that has not been cleared of a report that details flaws of mismanagement as the South African Reserve Bank. I mean, if we didn't have problems with your person of NSFAS, he would still probably be at SARS and living a happy life he would have, even his salary would probably be at 4-point-something million by now. You know his track record is a problem. You also know, Minister Manamela, that not every criminal is behind bars. So you can never say that until there is a court of law that has convicted a person and put them behind bars, we can't assume there's anything wrong, also because the public service and administration has not found anything wrong. You know very well, even including the board that you now wanted to get rid of at NSFAS and its CEO, your office knows that there are people who are there who should have never been there to begin with, which is why you're part of the reason why you're trying to get rid of them is because you have knowledge of things that the PSC can commit to but has not. So sitting here as a member of parliament, I have a problem with you and your intentions. You identify a problem that is clear for anyone to see. In your identification of the problem, you then decide, in your decisions of who comes to fix the problem, you create an even bigger problem. Do you accept, Minister Manamela, that you have failed to show the Republic that your intentions, on the basis of the choices of administrators you choose, are honest?
Thank you very much. Firstly, I think my intentions are very clear. They're about ensuring that correct the issues that you've mentioned, which you believe are the issues that affect the institutions, which we have gone ahead to place under administration. That's the first thing. The second thing is that I think the question of the seaters that are under administration, all of those seaters that you've mentioned, the work of the administrators of those seaters. I think all the three seaters, their administration is being wrapped up. And I think we will need to look at the reports, from that administration of the three seaters, which is the construction services and, local government seater. I still believe, and pending, the reports that I've requested in terms of the terms of these administrators, I still believe that, the decisions that I've took then still remain consistent. As much as you remain consistent with the fact that you had said to me in August, and you're still saying to me now, that I was wrong, and specifically with regards to your letter, which I've asked that the department give me a report specifically in terms of the construction seater and the issues that you've raised. You have said that you have opened a case against one of the administrators, and I suppose the law has to take its course. But what is important for for me in terms of the people that we've identified to stabilize the institutions that you've mentioned? is firstly that they are fit and proper as defined by the different set of pieces of legislation that led to their appointment. And secondly, that their own track record, should speak to it. And I think specifically zooming into the.
I'm going to pause you there, Minister. Minister, there's nothing you are going to say in this meeting today that is going to convince me that the gentlemen you choose and you have chosen as administrators are fit and proper. You can quote any legal clearance of the PSC administration, even the law itself. There's nothing that's going to convince me, particularly because you and I both know, Minister, that just because you have not been caught behind bars and convicted, it doesn't mean you are clean. Yes, you are guilty, you're innocent until proven guilty. But we know, because we even know your own organization, the ANC, has instructed Sisi Tolashe to resign as a member of parliament and as a president of the ANC Women's League. Not because any court of law has found her guilty of anything, but because we know that you don't have to be behind bars to be guilty. Yeah. The President of the Republic of South Africa has fired your predecessor, Nobuhle Ngabane. Not because she's not behind bars. Yes, the Hawks are still busy with the case are open against her. But not because there is any court that said she's guilty, but because the president knew that which we accused her of is guilty. So the bottom line is we are never, and anybody who is a person of the Republic of South Africa knows that not every gangster is behind bars in our neighborhoods. We know who they are. They are our uncles, they are our brothers, our fathers even sometimes. So that's not an argument that you're ever going to win with me today. Yeah. The point I'm making that I want to plead with you here is because actually, for the first time, I agree with you and your things that you are doing. It's this NSFAS is failing. NSFAS in its current form does not work. I agree with you, and which is why the position I've consistently made to you is that you need to, in order to ensure that there is an effective functioning of the dream of funding poor students in this country, is to do what the Minister of Finance has already advised you to do, which is we can save so much money by just giving Treasury the mandate to handle the finances without involving an entity that in its composition is a problem. The only thing missing is your political will, right? But you chose a compromise approach, which politically I understand where you're coming from. We don't sing the same Catership scorebook, it's fine. But I understand your compromise and the situation you are in. But you cannot, under any circumstance, Minister, convince the Republic in all sincerity that the people you are saying must go fix what's wrong have the capacity to fix what's wrong. They are not. They're not the right people. They've never been. And you're making my life difficult as a member of parliament who understands what you're trying to do here with NSFAS. But because your choice of an administrator is compromised, you're making me gaslight myself.
Can I just say something, just briefly, that I'm not saying that. Well, I'm not going to try and win an argument as you suggest. I don't think that that's what I'm trying to do, at least. Secondly, I'm not trying to persuade you to believe what I'm saying. And what I said was that the terms of the administrators that you've referred to, are coming to an end. And I think that there are reports. And I'm saying let's judge them on the basis of those reports. So, and I think the rest of the other points, as you said, that you are not going to be trying to, I think, argue or win an argument with me. That's not what we're trying to do. I think just to try and present the points itself. And also all I'm prepared to say is that we, have given the NSFAS administrator scope and milestone for him to achieve, with consistent assessment, over time. And I think we should give him an opportunity to be able to do his work.
Final question, Minister, on the administrator of NSFAS. The Nugent Commission the reports of those commissions, were they ever set aside in any court of law in the Republic?
Not that I'm aware of.
Okay, so you, as before an executive member of the state, as a member of parliament, knowing fully well that there's a commission that made an assessment of the South African Reserve Bank, and knowing that that commission's findings have never been set aside in any court of law, can you, with all honesty, justify to the Republic that your choice of administrator for NSFAS in the form of Ndate Mathebula is the correct one?
Yeah. Like I said, I mean, subsequent to whatever happened, with the Nugent Commission, which is, an important investigation which resulted into the turnaround of the institution itself, which Prof. Mathebula himself had, per the report, indicated that he'd cooperated with the commission. He has subsequently served not just in private entities, I don't want to name them, but also public entities. He's I think just as he was appointed as administrator, he was also serving as the chair of the MDDA, which is an entity of government appointed by the president. But he's also served, or he was at the time of his appointment, the head of the Tshwane University of Technology Business School.
Ndate, I'm going to pause, Chair. We already know you've told us these things. My conclusion is this.
You've asked me the question, and I think on the basis of that...
No, Minister, the Haralwane.
Yeah. Well,
so
I'm
the
not
point
fighting.
I'm making it
I'm
to
just
you
saying
is
you
you don't need to, you don't
respond to
have
that.
to go back to reiterating his qualifications. We already know. That's not what I was trying to establish. The point, and my prayer was for you to receive it with the sincerity I was giving it to you, to say, you cannot, under any circumstance as minister, want the Republic to have faith in you and your intentions if the physical proof of your actions do not afford the Republic the opportunity to trust you. I certainly do not trust that in your intentions of clearing what is wrong, that you are choosing the right people for the job. And I don't think South Africans trust that either. But my 15 minutes ends here, it's fine. Thank you.
Thank you. Okay. Honorable Souls. Before, Advocate Kuta, did you win with that? I know the minister cleared it, but you did not win with it.
Chairperson. I think it's good.
I was even I was even trying to offer to send you the charter. Honorable Souls.
Thank you, Chair. Honorable Minister, can we have concurrence that when I say thank you, Minister, that's indicative that I'm satisfied with your response, so that I don't appear disrespectful when you, so that I manage my 15 minutes well, please.
Okay, all right.
We have concurrence.
Okay, I hope you'd really be satisfied with my response, and you're not just cutting me. Yeah,
you know,
I know. Thank you. Yeah,
I have integrity on that level.
Of course, you have.
Chair, I'm going to trust you now because I don't have my minutes starting. Okay, Minister. So one of the board members on my right here read earlier a statement purporting that you stated that the board has not done anything wrong that warrants any sanction. Do you agree that you have made such a statement formally?
Yes, that statement was made in our application for self-review before the court. which was made sometime late last year. And I think the statement was repeated, consistent to that submission which was made before the court.
So what's your reason for sanctioning them?
Well, it was a completely different board when that statement was made. It was a board that didn't have some of the resignations that it had had. You know, and I think a few other points which I've consistently mentioned in this meeting. But importantly, it was a different board at the time when that statement was made.
That's very interesting because now, because I hear the statement for the first time, the impression was that it's in reference to the current board. So you are saying it's not?
Oh, no. I'm saying that the current board was in a different form when that statement was made. So they had a substantive chairperson, you know, and so on and so forth. So it was, you know, initially before all of the resignation and before some of the points which I've
All right.
mentioned of.
Thank you, Minister. So are you then saying in its now form, as we said here, they are guilty of wrongdoing and they require sanction?
I think it's important, and I've reiterated this point, that the board, both as individuals and as a collective, because I think you know, we tend to you know, view this as though it is punitive. It's actually not, and that the intention was that you know, with all the integrity, with all the competence, although Honorable How does not agree, and all their you know, expertise you know, combined, that's what the statement was intended for. But it does not take away, Honorable Sauls, it does not take away that certain things, you know, were not there in order for it to be seen collectively, the team to be seen collectively as a board.
I guess what I'm trying to get at is, does that statement apply to the current board as we sit here now?
Well, that's why I went on to you know, to appoint an administrator, because that statement, which was made at that time, you know, to a board that was constituted in that way, did not apply on the day when I took the decision to put.
So now they are guilty of wrongdoing and require sanctioning.
Well, I think those are your.
Well, it's the words that you used for the previous in the opposite. So I'm just trying to establish: do you maintain that for this current form of board or not? The same words that you used, because I'm not using my own words. So it's not strong words from me, it's strong words from you, but just now the opposite. Does it apply to them today or not?
Yeah, the board as it existed or as it was on the 4th of May required me to take action, and action that I took. And on the 4th of May, I didn't use the word wrongdoing and sanction. You know, I said what are the reasons you know, that led to that decision to be taken.
Okay. What specifically, is there anything specifically wrong? Was there anything specifically wrong in the recruitment process and appointing process of the CEO by the board?
Not that I know of. Personally, I wasn't involved in the recruitment and appointment process of the board. Safe to say the concerns raised by the interim chair, that he's worried that the board may go ahead to make an appointment without having concluded their own processes.
Is it true that you gave an audit directive to the board with 2 deadline dates? You want them to deal with the audit issues, and you gave them 2 dates to come back to you with progress. Is that true?
Yes.
Which was those dates?
I think the first date was, if I'm not mistaken, the end of April, and the second date was the end of May. But I stand to be corrected. But I think it was more.
more or less, yes, yes.
Can the board members confirm?
We agree on that.
You have concurrence. You have concurrence. So it's the 30th of April and the 31st of May.
Yeah.
All right. Did they meet the first deadline?
Well, the first deadline, which was on the 30th of April, the board was not constituted in the manner in which, when I issued the instruction or the directive, that the board was, so it was a completely different board, that
Okay,
wrote
Minister.
to me on the 30th. So
Sorry, Minister.
Yeah.
Did they submit
Yeah.
on that deadline as you prescribed on the 30th of April?
Well, on the 30th of April, the 7 members of the board who were remaining wrote to me, presenting to me a response to the deadline, which they had, presented to, which I had asked for on that day.
Did they meet the deadline?
It was present, but in my view, they were not a properly constituted board. So although the correspondence was sent to me on the 30th of April, I do not believe, as I stand here, that they were a properly constituted board.
Well, we're not dealing with how they were constituted.
Well, I think it's important because,
But
although
we
was,
now know
yeah.
that they're 7.
Okay.
You've given them a directive
Yeah.
to deal with. What is important of that question is the fact that you've got 2 reasons why you're putting them under administration, one of which is the audit issue and progress on that. Now I'm asking, you then gave them 2 deadlines. One, 30 April, give me progress on this issue.
Yeah.
That you are having as one of your reasons.
Yeah.
I want to now know, you've given 2 dates. 30th April, did they comply to that deadline?
No, I don't think they complied with that deadline.
So they didn't submit you their progress on the issue by the 30th of April?
Well, a letter was sent to me by the 7 remaining members of the board, talking to the directives that I'd issued to them.
So then they complied, Minister. Then you have the 31st of May, which has not arrived yet. Your number 1 basis for putting them under administration, you give them 2 deadlines. They submit on the first deadline. They are yet to submit progress on that number 1 issue. That date, 31st May, is still to come. You put them under administration as one of those reasons. What is the reason for doing that when the deadline is still coming?
I think the point that I've made, and quite consistently, is that I did not believe that the board, as it remained after those resignations, would have been able to competently meet up with the directives that I've issued to them. And that's why I took the decision that I took.
It still remains that they are complying. There's a deadline due. You put them under administration before that deadline. Your second reason is the composition of the board. Advocate, can the board legally function with 7 members? We've got to go quickly now because Can the board function legally with 7 members?
Yes and no.
Quickly give the yes and no.
I said yes and no.
Yes, but why yes, why no? Quickly.
They have been operating whilst there were 7. And the no part comes from the fact that out of 18 members, there are only 7 of those members that are in existence.
Yes, but with 7 members,
Yeah.
legally can they function?
No.
They don't have quorum according to the Act. How many members should there be in total? 13.
Out of the 13,
Yes, the majority would be 7.
yes.
That means that they have a quorum.
In the context of a quorum, we would be looking at who is represented in the 7.
Yes,
And-
so the ones that's not there is the financial part, too, and then also from the Minister of Finance part. But if you'll have the student, you'll have the governance, so those categories are covered in that 7. So I understand that. The point is, as 7, can the board function? Advocate.
Why I said yes and no was in the context of saying out of the 7, you do not have any financial expertise, you do not have the ministerial appointee from the department, the minister from
Yeah.
finance.
Thanks,
Yes.
thanks, Advocate. I would have read you something that says that that vacant positions does not mean that they shouldn't function. It's actually law. But let's entertain the concept. Out of that 6, how many out of that 6 should be appointed by the minister? The remaining 6. How many should be appointed by the minister in terms of the Act?
Out of the 6, minister would have appointed, can I just check?
Okay, just because of my time, let's do this. The 2 that, Advocate, the 2 that you are referring to, that is still required, which makes you say no, that 2, that finance 2, who must appoint them?
It's the 2 ministers.
So, if the minister does not appoint them, how do you hold the board responsible for something that the minister has to do?
If you recall, Honorable Souls, the minister is before court, and for him to have gone ahead and put in new members, it would mean that he disregard that application that he had lodged in court.
So it's the sub judice issue.
I would imagine so.
Should he then not apply consistency and use sub judice before he puts them under administration?
It would have been considered. However, sub judice, even from the legal opinion that we received, is not restrictive. And I would imagine when there are new facts that appear, you would want to look at those new facts. You cannot ignore them simply because.
So you are saying that the minister, just now you must confirm with me, Advocate, the minister has done the correct thing legally to, on the one hand, not appoint 2 appointees that the minister requires for him to consider the board properly constituted. He refuses to put those 2 members because of the sub judice rule. Then, in the same breath, puts them under administration because those 2 members are not there.
I do not want to speak on behalf of the minister.
We'll go there, but we're dealing with the legal issue. What do you legally... That's not the chair, so ignore that one. That's the... We want to legally, before I go to the ministers, my last, because now my time is up, we need to establish, do you see the inconsistency?
If you believe that there's inconsistency.
No, forget my belief, Advocate. Just based on the law, give us the advice on the law. The minister is correctly using the sub judice rule to say, I will not appoint these two until the self-review is finished. We understand. Then he says, I'm going to put you under administration because these two people are not appointed.
You are referring to two separate, distinct processes.
Explain.
Yes. And the first one of the self-review, it is the minister himself who is taking his decision to court. That with the time remember it's him now, at the time this board was appointed, there were some irregularities and he would want the court to make a determination
I understand that.
on that.
I fully understand that. I fully understand that. He's taking that under self-review. But he's using that as a reason not to appoint the two members needed for the minister to look at the board as properly constituted. These are not two separate issues. They are two separate legal processes, but not the one affects the other. So, okay, Minister, rather because, okay, Minister, as I conclude then, Minister, we've seen that the first reason that you've given for administration, there was 2 deadlines set. You went ahead with administration before the deadline. Your second reason is the constitution of the board. But on the one hand, there are the two members, or seats at least, that the Act empowers you to appoint. You use the sub judice rule, on the one hand, not to appoint them. You then put the board or NSFAS under administration because those 2 members are not there plus the others. They are not properly constituted because of an act on your part that they don't have control over. So to protect your decision, on the one hand, you use sub judice, but they don't have the same protection. You use that as a reason to put them under administration. Do you see that as an inconsistency?
No, I don't see that as an inconsistency. And maybe can I just explain this well? Our time is done, but just I think, Chairperson, with your indulgence. So on the 20th of February, 12 members were appointed to the board. And those were without the National Treasury and also without the 3 student representatives. And the student representatives, 2 student representatives were later co-opted into the board, making the board 14. And remember that I think there's proviso that the board can go up to 18, but also the composition of the board is not just constituencies, it's also based on, on expertise. But the point that I'm trying to say is that, the external legal advice that Advocate Kuta referred to earlier on also implored on us that further actions which were taken, for instance, to co-opt the student members in order to correct the composition of the board at the time, was actually inappropriate or improper. And that's why we approached the court to set aside this decision. Now, based on that, not based on any other thing, based on that, when the board wrote to me asking me that I should, fill up the vacancies, I indicated to them that we have this legal advice which says that I cannot augment the board or fill in vacancies, and so on and so forth, because that matter is before the courts to determine, in terms of its composition. Now, that was a board that, we took to the Pretoria High Court for self-review. Now, the board that I have dissolved on the 4th of May, only had 7 of those 14 members remaining. And it was not just about the composition of the board. I think it had to do with a whole range of other things. Now, the parliamentarians who adopted the NSFAS Act understood that the body itself would require a particular set of expertise and constituencies to constitute the entirety of the board for it to function properly. And as at 4th of May, I did not believe that the board, as it stood on that particular day, fulfilled those legislative requirements. And I think that that's the, I do not believe that there was a contradiction. I believe that we need to separate the two matters. They may seem to both matters be related. I think that they are actually separate.
Okay. Advocate Kuda, how do you determine the quorum of a board meeting of NSFAS?
Chair, I've checked the Act. The Act does not refer to any quorum. And I think it's one of the gaps that we've identified. That's why you are smiling.
So the answer is that the Act is silent. Okay.
Chair?
Yes. Your time had long expired, no?
I'm seeking clarity on what you just said.
No, I'm still making the point that can be true, Advocate Kuta, because actually go to section 13, subsection 3 of the Act. Trying to scroll, my laptop just decided to. I can't scroll, but I wanted to read to you what it says. I don't know why it's doing this. Yeah. Must I tell you what it says, Advocate Kuta? It says, the board may make rules relating to the procedured meetings of the board and its committees, including the quorum of such meetings, and any other matter necessary or expedient for the performance of the functions of the board or its committees. What is your understanding of what this section 13, subsection 3 says?
My understanding, Chair, is that the Act, as it is, does not say what the quorum is. It talks about the board making rules, meaning how much the quorum would be in the rules, not in the Act.
Yes.
Yes.
Now, so in order for you to know what is the quorum, if you say the board does not meet quorum, you will need to know what is the quorum that they set for themselves as a board. Now, the argument is that you are saying, legally, Honorable Souls ask you, legally you are saying this board did not meet the legal scrutiny to be a board. And you said it's because they don't meet quorum. So where did you get this quorum of this board, this particular one, when the Act itself says you should have asked them to give you what was the agreed quorum?
I mean, the board would have given us the rules which determine what their quorum is.
Yes. Because
I
that's what
have-
the Act says. Section
Yes.
13, subsection 3
Yes.
says they will decide
Yes.
what the quorum is. I don't agree with such an act myself because it doesn't make sense in my view. But it's there. It's an act which I've said I don't agree with it. Now this act says there's no rule if you have not gotten it from the board or the board secretary. That says 7 out of 18 does not meet quorum, because now that's an assumption. So you have based your argument on assumption because you don't know the rules. It says they must determine their own rules. And then, so you agree that the assumption that says 7 out of 18 does not meet quorum is based on something outside of what the Act says.
I'm not basing it on outside what the Act says. I accept, Chair, that the rules that the board would be using to determine the quorum, I have not checked them.
Okay.
Let me accept that.
Okay.
So that we don't go further.
Okay, so the assumption that 7 out of 18 did not meet quorum is not true, because you don't know. It might be true, but it's not, you can't verify that you based it on the rules that we're supposed to follow. Let me go quickly to the second one. The charter, the board charter, and I said, as I send you the charter, I have it. So let me tell you what the charter says about the quorum.
Sorry, Chair. You can allow me to come back, or?
On the quorum?
Yeah, you said you want to finish the point.
Yes. You wanted clarity?
Yes.
On my question?
You wanted to finish the point first, yes.
Okay, what is the clarity?
Do we now, for the record, accept from the side of the minister that the board can legally make and function with 7 members?
Can I read what the charter says?
Yeah, no, let's hear. You want to read what, 17.2? Or what do you want
Yes.
to? Yes, let's read that
Oh,
one.
okay.
No, read that one. You want to answer him?
17.2. Yes.
Yeah, you can go there.
A majority of the member present in person or by using any technology will constitute a quorum, provided that at least 3 members of the executive committee, as contemplated in Section 10 of the NSFAS Act, is present. So for me, the 3 members of the executive committee would be the determining factor for the quorum to be legitimate.
And then in the 7 members, there were no 3 executive committee members.
I can still check that.
Yeah, so you see, that's why I was saying, I'll give you just now.
Yeah.
I'm going to give you. That's what I was saying. You can't say there's no quorum when you've not determined these things. You must first determine that this is what the charter says, this is what the Act says. And because if you say there was no quorum, you are making a very definitive statement that there was no quorum. And now that's why I was taking you to 17.2 to tell you that there's 2 determining factors for quorum. And the other one here is that one of EXCO. It says, even if you can be 15 in the meeting, If there's no at least three EXCO members, that meeting does not form quorum. So quorum is not a matter of having, there are determining factors, and that's what you should have done to get from the EXCO, from the board members to say, we are making a determination that you don't pass the test of time as far as you being a legal entity is concerned, or legal structure, because you don't meet the legal issues. So you have said they don't form quorum or meet quorum, and you have not satisfied what the NSFAS Act 13.3 and 17.2 of the Charter suggests or tells you, defines as a determining test for what a quorum is. So that's where the problem is. I think you can see. Now, I'm going to, no, maybe let me give you Honorable Soul so that you ask that particular, the final question before I go to Honorable Zondo and Honorable Mayman on the line.
I think your direction is brilliant, Chair. So maybe I should first allow you to do what you wanted to do with the board members and get that clarity, and then I come, if it's okay with you.
Okay, your time is up. You want to come again?
Just based on the question you've just
Okay.
posed to me, I appreciate your benevolence.
Okay. I don't know what is the meaning of that word, but
We shall get concurrence.
Oh, okay. Dr. Mgadi.
Thank you, Chair. Just for record, 3 board members that are sitting here are also members of EXCO.
In addition, Chair, the issue of a quorum is not something that we took lightly. In fact, as soon as we received the resignations we received, the company secretary was very reluctant as a custodian of processes and the law and an advisor to the board to have the meeting of the board to proceed with 7 members. He advised that the best we could do under circumstances was to get a legal opinion on that, and the board did authorize the company secretary to secure a legal opinion. The legal opinion came indicating that the board is duly correct, and this is an advice we also gave to the minister when he sought representations from us. We did tell the minister that the board is duly correct. Thank you, Chair.
Honorable Souls.
Can the board legally function and execute its duties in terms of the Act by being 7 members?
You're asking who?
The Honorable Minister.
Minister.
Yeah. Well, I think I've responded to that question to indicate that at the time when I wrote to the board, I did not, I was not of the view that the board is functional, or that I think there is actually a particular wording in the Act that speaks to the functionality of the board, and especially in relation to the tasks that was at hand, and I think it was on the basis of that that I went on to take the decision that I took.
Chair, I want to come to Advocate. Advocate? Oh, yes. Now that we've traveled this part of explaining or trying to find what is a quorum, 3 EXCO, Board Charter, NSFAS Act, according to your legal understanding, if after you also do your own reading, which I believe you are doing now, you come to the understanding that we have, that the board had reached, the board was correct according to the Act and the Board Charter. Would you agree that
decisions which are taken by a correct board would actually be both lawful and binding if those decisions were taken before the board was placed under administration.
Yes. Sorry? I'm saying yes.
Honorable Zondo, are you there?
He's not here, Chair. He's not here. We can pass.
Okay. Honorable Maimela.
Thank you very much, Chair. I am here.
Thank you.
I see the acting chair that I'm contesting with is ready or eager for the meeting to be finished.
No,
He's tired now.
there's no acting
Very much
chair.
for the
There's only
opportunity.
one chair. Honorable Maimela, yeah, your network, I wanted to say your network is a bit weak. If it persists, I'll ask you to close the video just so that we improve the bandwidth. But it was hugging a bit, so let's hope that it will hold now.
Okay, thank you very much, Chair. I can hear you properly, but I know it will persist because I'm at Acacia's. Thank you very much, Chair. Chair, for me, there's three bottom lines that I want to get responses on. The first bottom line, Minister, is that as a former beneficiary of NSFAS and for students who are sitting at home now, they want to understand how does this conversation affect them? Will they still receive their funding? Prospective students who are going to be applying in September want to understand if their applications for funding will be considered, if the accommodation of the current students will be paid. So for me, I really want to get an assurance from yourself and the team from NSFAS, given the fact that the GTEC report raises a whole lot of issues. 8,000 deceased students who are on the beneficiary list and they shouldn't be there. Non-qualifying students who are appearing on the beneficiary list as qualifying students and qualifying beneficiaries that are not being approved on the beneficiary list. And that for me is the crux of the issue. I'm extremely worried about that aspect because it speaks to the plight of students at home who are watching us to say, how does all this affect me as a student at home? So I want to get assurance firstly. If these issues that you've raised in the presentation, if there's any plan, firstly from yourself to resolve those issues, then I'll come back to the second bottom line. Thanks.
Thank you very much, Honorable Maimela. I think in terms of that particular bottom line, I think we can confirm that the student allowances will not be affected. So that is the transport and tuition and all of the allowances that are due to students. And secondly, that the process for the applications for the academic year 2027 will also not be affected, that process will have to proceed quite smoothly, and that we will, as we did this year, I think properly prepare for the new academic year with all the lessons that we've learned and all the work that needs to be done. And in fact, that experience for students have to be much better than it has been. And I think that's what we are all aspiring for as the ministry, as the department, but also the administrator and the NSFAS administration, that no one should be affected by this and no one will be affected by this. So that's in terms of the bottom line. I think that's the guarantee that we would like to give. As things stands now, as I appear here, something else can happen next week, and I'll be quoted here as having said this. But I think importantly, students should be confident that none of them will be affected by this, and in fact we're trying to improve the service.
Thank you very much, Honorable Minister. I do want you to then commit that you're going to give us a comprehensive report on how you are resolving these three issues of deceased students on your beneficiary list, unqualifying students, and qualifying students who don't appear. The second bottom line for me, Chair, is that the Minister and the Department must understand that as Parliament, we have a responsibility to ensure that the Executive adheres to the lawful framework established, and that the executive decisions that they take are in a structured, informed, transparent, and accountable manner. And as a result, that's why we're asking these difficult questions. And I want to continue on the line of other members to ask these difficult questions. The first one, Chair, goes to us as members of Parliament. And this question is prompted by the fact that there is an allegation that is made by one of the former board members saying that the other former board members, who is no longer a board member because they resigned, called them and make inferences to the minister, instructing who should be appointed as a CEO. Now, I want to ask the invitation status of former board members. Did we invite former board members who were only dissolved, or did we invite all former board members, inclusive of those who had resigned? Because if Miss Karabo, because that is the specific board member that is mentioned, was here, I would have really wanted to hear her side of the story in terms of the allegations that are made, because they're quite damning. So I just wanted to check, Chair, if we did invite them, and how do we get to a point where we are able to hear the side of the story of this specific board member?
No, thank you very much, Honorable Maimela. Just to remind members that the decision to bring in former board members was taken by yourselves in the committee initially on the 6th and on the 20th when we met. And I asked members who must, when you suggested, and the meeting resolved that we must invite the dissolved members of the board. So the initial invite that went to the dissolved members of the board. And then early yesterday, I then asked Anela to invite the two members who resigned last, just to get a clearer picture of the issues. We did get a response from Karabo Mohale, who indicated that should not be able to participate meaningfully because of the late arrival of the invite to come and participate in the meeting. But that invite that was sent yesterday, it was just me thinking that to get a comprehensive picture, I must invite them. But your meeting of the 6th and the 20th had resolved that we must bring in the dissolved members of the board, which were the people that were invited. Thanks.
Thank you very much, Chair, for that response. I think it suffices, and thank you for your foresight in trying to invite the other members that were not part of the dissolved members, because, of course, the committee wouldn't have anticipated that they would be mentioned in the discussions. As a result, we wouldn't have seen the importance of inviting them. But I think now it is important, and as a committee perhaps we might have to reflect on how do we get Honorable Mohale to utilize the same principle we've utilized with these board members, that they should be here in the same breath with the department, so that they're able to raise their own voice and we can hear their side of the story. So we should also endeavor to hear the side of the story of Honorable Mohale. That's my own point, but I really appreciate your foresight, Chair. And now, Chair, since we've heard about the composition of the board, that actually the Act speaks about 13 and all the other inclusions are actually counted within the 13 in terms of the Act. So the inclusion of the representative from finance, from the department, it's actually within the 13 in terms of the Act. The 4 comes in as a co-option. Now my question is to the department, given that they cite the ordinal rule, Minister, wouldn't it have been prudent that you have your own representation and finance has representations in the board, that when you say it is irregularly appointed, but its decision still stands. So they are going to take decisions on money, they're going to take decisions on students, they're going to take decisions on how students are going to be financed. Wouldn't you want representation, and wouldn't finance feel that it is prudent to have representation in such a board, even though there is a self-declaration matter before the court? I just
I think just to indicate that, you know, by the time we before we approach the court for the self-declaration, I think the representative from the Department of Higher Education was still a member of the board. I hope I'm right about this. And that I'd also had a discussion with the Minister of Finance, you know, for them to fill up that slot, because that slot was not filled up in February on 20th February, when this board was when the board we're talking about was you know, was appointed. So there were you know, intentions of doing that, or of ensuring that the board is properly constituted. But I think the trick becomes the you know, the legal advice that suggests that if we make any addition you know, to the board, so you know, that will actually be acting contrary to the you know, to the matter that we've already approached the court about, which is asking for the court to declare that decision, to set that decision set aside. So that's the quagmire which we faced you know, ourselves in, which is the response which I furnished to the interim chairperson of the board when he you know, requested that we do fill up the vacancy. So it's not something we took lightly, because the operations of the board, and I think you can see consistent with my action, you know, the proper operations of the board, I think you know, for us was important.
Okay, thank you very much, Minister. I think for me, what is important is the fact that you saw it prudent for representation, because if you look at the NSFAS board and the composition, representation is at the center of the board. So the intent of the lawmakers was that students must be represented, you must be represented, and as well as Treasury must be represented. And the fact that you saw it prudent for you to be represented, for me, that's okay. I want to then understand who sought the legal opinion and why. And I want to hear this from the legal team. Who sought the legal opinion and why was the legal opinion sought?
Thank you, ma'am. The legal department was approached by the office of the minister to provide a legal opinion on this matter of the establishment of the board. And we then, through the state attorney, sought an external legal opinion from a senior counsel, as internally we were not in a position to do the legal opinion as quickly as it was expected. So the legal opinion...
Apologies, Chair, because my time is running out. So why, what were the reasons of the minister to seek the legal opinion at the time?
As I said, there were inquiries from especially student organizations who, were aggrieved about the, representation. And I think over and above that, they themselves had sought, legal opinion, which which I was presented with as part of the list of concerns that were raised around the board, and that's why we then asked formally and officially within the department that we get a second opinion on these issues.
Okay, thank you. So the second question I want to know is that, so the excluded bodies, meaning the student part, the student organization or the student representative, because I understand with the department and the finance, was that ever included? Because you alluded earlier that the former minister tried to add, and that was also deemed as irregular. So were students represented in this current board that we're speaking about?
Yes, as a result of the one addition from, as a ministerial decision, and the other one, I think, as a result of the decision of the board, if I'm not mistaken. Yeah.
Okay, I think that's fine. So now let's go to the issues that are actually burning. So I want to understand the insinuation or the allegations here before us seek to link your dissolution of the board. They link that with the appointment of the CEO process. So there seemed to be an established link that you actually dissolved the board because there were disagreements within the board on who should be a CEO, and somehow there is allegations that you also had interest in who must become a CEO. As a result, you tried to influence some members of the board to either resign, to influence the process, and if they couldn't, they should then resign. So I want to hear and I want to establish if this is true, because for me that's very important.
Yeah.
I want to start with an issue that is established here. There is an established fact that there were two advertisement processes where the board firstly said there is no enough representation of female candidates, and as a result we should go out on advertisement as again to get more representations. Were you part or were you informed of these two processes? Were you ever part? I know you answered something towards that point, but I want to make sure I heard you correctly. Were you part of this process, or were you aware of this process? Did you ever influence that process of the board's decision to go to advertisement again?
No, I was not part of the board's decision to re-advertise. I did not issue such an instruction. The only time when I issued an instruction was when the board was asking for my concurrence with regards to the extension of the acting CEO, which was outside of the 12-month period. And so the undertaking from the interim chairperson of the board was that, yes, we will proceed with, the acting CEO, and then we'll also start with the process or, fast track the process of the appointment of the substantive CEO. So I was not involved in any of those. And I was not party to. And I think any other thing is basically innuendo and, suspicion and so on and so forth.
Okay, thank you, Minister. Second one I want to ask on this process. So deal with shortlisting and, of course, interview process, and finally, a recommendation to the board, because the board then must make an appointment. Now my question is, do you know who, or did you know who the board finally who the panel, the candidates which the panel finally recommended to the board? Did you know? And also, did you actually have an idea of the candidates that appeared before the panel for interviews, for example? Because then that will substantiate if you knew why you would have an interest or preference because you would know who appeared before the panel?
Well, I only made aware of all of this when the stories broke in the news. They were all over the Sunday newspapers. One of the weekends. That's when I knew with everyone else as to what were the process. This was never a subject of discussion between myself and the board members. You know, and I never sought to interfere with, you know, with that process.
Okay, Chair, I want to know now from the board members, the former board members. One of the former board members, I think it's Mr. Ramashia, says the meeting was strange or was weird. I'm using now Gen Z's language, weird. And it was instructive. Now, I want to know, because when you say a meeting was instructive, it means there is a set of instructions that were meted out in the meeting of the 13th of April. Now, I want to know the specific instructions that the minister issued to the board on that day, because the meeting was instructive and that was how it was characterized. So we then need to understand the specific instructions that were actually issued by the minister in that meeting. I just know of, I heard when the Mr. Ramashia said there was an issue, an instruction on the acting chair, which was Ms. Mohale. But what were the other instructions? So was that the only instruction in that meeting, or were there other instructions issued by the minister?
I did not get your point about the instruction relating to Ms. Mohale. I'm not sure if it is something that I would have said, but be that as it may be, the specific instruction that I'd made reference to was the instruction not to proceed with the appointment of the chief executive officer until such a time that the minister comes back to us in a period which was rounded up to close 2 weeks. He actually specified a particular Friday. I think I had made note of the particular date, but that is the specific instruction that I've referred to. If you may refresh your question relating to Ms. Mohale, I don't remember any instruction in that regard.
Okay, just to refresh our memory, if I got it wrong, Chair, you'll assist me. I remember the Mr. Ramashia specifically saying that the minister's meeting was instructive because it instructed them to say Ms. Mohale was the acting chair. And Mr. Ramashia even said to us, that was not the responsibility of the minister. So that's the reference I was making. If I got it wrong, I apologize, Chair, but I think the other instruction that I got, because now I have clarity on the other instruction that was given to the to the board, I'm fine with it. But that was if I'm wrong, Chair, please clarify that I'm wrong so that I apologize.
Yeah, no, thank you very much. I'm trying to think of the word that he said. In fact, I think a member here, I can't remember who said, oh, it was Honorable Khabo, who said it means the minister imposed the name of Karabo as the deputy chair, and the advocate there said, no, that's not the case. It's what the minister had said in the meeting and not instructed them that she will be the deputy chair or imposed her. I think that was the response there. So he did, in fact, when it was put to him earlier on, he did indicate that that was not the case.
Okay, thank you very much. Because
yeah, and the
what
minister agrees. The minister says, and he agrees with them. So
finally, we get the concurrence.
Finally, there is an agreement.
Yeah, they got a concurrence at last.
Okay, thank you very much, Chair. The third bottom line for me, Minister, is now how do we move forward from where we are now? And Chair, this also goes to us as a portfolio committee because there is certain facts that we've established out of this engagement with both the former board members and the department. And for me, I would really want us as a portfolio committee to reflect on these facts that we've established and those that require, and that's my proposal to the portfolio committee, that perhaps we need an in-committee reflection on how then do we want to move forward so that we're able to establish what are facts that we established, what is it that we need more information on, and we get that information. But the third for me is this issue, Honorable Minister, is what I asked earlier. Is there a link between your dissolution of the board and the appointment process of the CEO? So finally answer that question, because that's a perception that we all have, that is out there, that there is a link between the timing of the dissolution of the board comes at the time where the board must finalize the process of appointment of CEO. And seemingly there are issues with the names that are flying around and what is out there. So you need to take us into confidence if there is such a link. If it exists, what is the nature of that link? If it doesn't exist, how then do we move from here? Because the board did not finalize the process of appointing a CEO, and you said to us, AG said you must finalize that process.
Yeah, there is no link as I think it's been suggested. The one process was the process of the of the board, and the other process was the process that I, as minister, was responsible for in terms of the proper constitution and functioning of the board. And in no way in any of my decision did I seek to influence that a particular individual should be appointed as the CEO of the of the NSFAS to the board itself or to any of its members. Thank you.
My last intervention, Chair, is that, Minister, I agree with the sentiments of the members on the platform. And I agree with these sentiments on the basis of what the Act intended, the NSFAS Act intended. You know, the Act intended representation of different stakeholders in the board of NSFAS so that all stakeholders can have a voice on how we actually administer the funds of NSFAS. So when you bring an administrator instead of a board, it's one person. So it's one person's thinking, it's one person's discretion. There is less oversight from your side because when there's a board, you've got, as a department, a person there that is safeguarding the interest and the vision of the department, as opposed to when you just have one person as an administrator. And for me, Minister, I really do. Then there is no student's voice. So the administrators themselves, Honorable Khakhawa at some stage said it's a god, you know? So there's no student voice. Students can't say because there's an administrator, but in the board, they then have a voice. They've got a standing. They're able to be represented. For me, that's a serious crisis. It's a serious issue. And for me, I want to then put it to you that it's not a position we wish we could be at as a portfolio committee and yourself also as a department, and that indeed it is very difficult for us to believe that this administration process will actually bear results when the other two administration processes did not. So please give us assurance. But beyond that, Chair, my final submission is that the committee needs to reflect on how then do we move forward in an in-committee sort of way. I will leave it there, Chair. Thank you very much.
I really appreciate Honorable Maimela. You had your hand up.
Sure, if without disrupting the minister, because the point that I raised, okay, the minister says I can go ahead with your permission, Chair. It emanates from a question the member was asked as a question relating to the options that were available for the minister in terms of the legal opinion that the minister referred to. And I think if attention is given to Section F of that legal advice, particularly from paragraph 101 up to 104, you would understand that the legal opinion itself did not preclude the minister from filling the vacancies as it would have been canvassed. In fact, the only thing the legal advice said was that was to raise a difficulty because at the time there was only one vacancy. So when we responded to the minister's self-review application, what we said in our answering affidavit was to lay practical options which would have been available at the face of the minister, and it's in line with what the legal advice would have advised at that time, that co-option is a possibility available for the minister. It was at the time only limited by the fact that there was only one vacancy, but at the time when we exchanged papers and advised the minister, there were sufficient vacancies on the board for the minister to remedy a crisis that would have emanated as a result of improper constitution of the board. Thanks. I wanted to clarify it in the context of the opinion.
Okay, thank you. Oh, Dr. Mkat.
Thank you, Chair. Also, just to clarify, the board subsequently said, after it had seek a legal opinion, whether it is correct and whether it can make decisions. The board sets approved fourth quarter reports, and it then concluded on the matter of the appointment of the CEO. And a letter was sent to the minister. So it is not true that the minister would have found out on the news. We sent, as the board, our appointment of the CEO. We then requested the minister for concurrence. It is then on that Monday, after we would have given that, sent that letter to the minister, that then the dissolvement that we saw on TV arose.
Okay. Honorable Maimela.
No, I wanted to just get clarity on this narrative by the former board members. So they sent a report of the panel to the minister, or was it a report of the board? Because remember, my question was on the panel. Remember, the board, when it said, and the minister was saying, wait, because that's what they said. The minister said, wait on the process. The minister was saying the panel had not concluded. So I want to know if they sent the recommendations of the panel to the minister or the recommendations of the board. Because the board would have said and considered the recommendations of the panel and then send them to the minister. I think that would be the flow. So I just wanted to get clarity on that one.
Thank you. I think what we sent was a board decision that was final to the minister. What we had been sending to the minister is reports updating the minister on the developments of the recruitment process for this last 3 months. So minister would have been aware of what is happening in the recruitment process. And of course, we can show those reports.
Are you answered, Honorable Maimela?
Yes, Chair, I've answered that. So the minister, but I also want the minister to come in. So it's the final recommendation of the board. So whatever they would have sent to the minister would have one name. Because obviously if you speak about the panel will show the names of people they interviewed, the scores and everything. So what the minister received is one name. So I just want to get a reflection from the minister on this question.
Yes, so what the board sent me on the 30th of April was what they said was their decision in terms of the appointment of the CEO, which was one name.
Honorable Lindsay.
Chair, when when Honorable Maimela had asked the minister about the recruitment process, and I just want him to clarify because maybe I misheard him. His response suggested that he actually saw these things in the media, and that he was not aware of this until the final day, which would be 30th April, and that the only thing that he would have been aware of is a complaint from the interim chair of the board. Now, a member of the board is saying they would have been sending reports to the minister, almost giving an update every step of the way about the recruitment process. So those are conflicting versions. But I don't want to suggest anything than to give maybe the minister another opportunity to clarify that point.
So the point to clarify, Minister, is that is it true that you got the regular updates from on the recruitment process that the board was busy with?
Look, I mean, as to the details of the updates, I'll have to I'll have to check what is it that the board has shared with me and what the board hasn't shared with me. But what I said and confirmed was that the recruitment and the appointment of the CEO was a board process. And they may have as well, I think, probably updated me on how far they are since I'd given them a deadline. And in any way, as I indicated, in terms of my discussion with the interim chair, it was around his consent on the entirety of the recruitment process, which resulted in the meeting of the 13th of May. As to the intricacies of who has been shortlisted, who has been interviewed, who is being considered, I considered those fully, the process of the board, and I didn't think that it was important for me to, to be drawn into that particular process.
Yeah, Honorable Nguban.
Chair, with the hearing now that the board member said he heard it on TV that they are now being dissolved, was the Section 17 of a consultation process by the minister with the board of dissolving them canvassed enough of the reasons for the dissolvement? Because I hear they said they saw it on TV. So where that Section 17 complied?
I think I indicated, Honorable Ngubani, in our presentation that, in our view, we did comply with that. We did comply with the entire process.
Honorable Souls.
Chair, I just want to check if the minister believes that he's got the power to revoke the decision of the board of the CEO choice.
Look, you can only revoke, a decision which you have powers to institute. And in this case, if I don't have powers to appoint the CEO, I therefore do not have powers to disappoint the CEO. And as I've repeatedly said, that it is the decision of the board, and that the role of the two ministers of higher education and of finance is concurrence in terms of the terms and condition of their employment.
Let's or closer to the closing of our meeting. A few things that I think we must note, Minister, that for a government ministry, let's convene meetings better moving forward. Let's have when we call our entities, let's document it so that it's able to also protect you tomorrow. That this is what I went to discuss with with the entity, so that doesn't create this narrative that you went to have a secret meeting to give them an illegal opinion or legal instruction, because that comes from these things of us not being able to indicate this was the intention of the meeting. In fact, from what I'm hearing you to be saying is that there was no bad intent in meeting the board that time on the 13th of April. And therefore, because there was nothing that you said to them in the meeting that was, or you're going to say to them that was going to be illegal, we could have even kept their phones in the meeting, because it was a frank engagement with the board to say, listen, I'm receiving challenges, or I'm receiving potential problems that are coming from your chair, that you want to finalize this thing without finalizing, or you want to appoint the CEO without finalizing certain steps in the recruitment process. Corporate governance, King 4, King 5 speaks about you doing this things this way. And I don't think there was a personal, I don't see a bad intention there. But when you have taken people's phones and there's no written agenda, it then creates this thinking from some people that indeed this was what was going to happen. So maybe next time let's convene meetings a bit better there. Secondly, I think this entity called NSFAS is an extremely important entity. We want that entity to perform at its maximum. So it must perform at its maximum potential so that it's able to respond to what government has promised our people. We have promised that we'll take these kids to school, we'll put them in proper accommodation. We promise that we'll give them allowances. This NSFAS should be able to deliver those things, because if it does not, it creates an impression that us as politicians, we go to these institutions, we go to communities, we lobby people to vote for us, we promise them X, Y, and Z, and then we're unable to do so. So what do we do with NSFAS there? Central to it should be, it must be student-centric. It must resolve problems of our people. We don't want a situation where we're unable to pay accommodation providers. And I've said this many times. When you don't pay accommodation providers and they evict these kids, they evict them, let me tell you, they evict them one at night when they know that they will be very vulnerable, and they evict them maybe on Saturday evening or during exam. So they choose a specific time. So when you don't pay, this is what you are subjecting these young students into. Many of them who are females don't have anybody else to give them even 30 rands to call their parents. They will speak to them on WhatsApp. And if their parents come from the township I come from, when there's no electricity, there's no network. So it means WhatsApp does not go through. So there's no, literally you are sending these girls, these young girls who are students, into the hands of vultures who would want to take advantage. I said vultures. I saw an opinion piece of former deputy president of the Youth League last week, He said in Parliament, vultures are circling in. And I decided to use that word. It was purely by mistake, you know. I'm not meaning, you know, there was no intention. There was no malice to use there was no intention, a bad intent to use the language of the minister, at least. So I think I'm sold with your idea, Honorable Maimela, that as the committee, we will need to meet on our own to have a way forward on these issues. But I hope the department now can see what we've been telling you about the acts. This Higher Education Act, this NSFAS Act, the CET Act, the Skills Development Act, they are literally, they are going to create more mess for us. It's something that must be done. And Minister, I think maybe you must nudge them so that we are able to get to the end. We are able to bring these proposals to Parliament so that we can start our own process of dealing with them ourselves. When we say we need changes in these acts, we want to strengthen them so much that you know, we don't create these problems that we see today. Department, honestly speaking, Advocate Kuta, I don't think it's good enough that we make a pronouncement that this board does not meet quorum when we have not established what the Act says about quorum. For me, that's the most basic thing. That is the most basic thing we can't make such mistakes. The Act, I mean, I deal with over 150 entities. But I knew Section 13, subsection 3, when I read the papers of the board, and then I knew that there was going to be an issue about quorum. I went to the Act, and I looked at the Act. What does the Act say about quorum? Section 13, subsection 3 is very clear on what is a quorum according to a NSFAS. It's not like any other quorum, as if you're attending a PGM. It's 50% plus one. No. This quorum is different. It's not. Yeah, it's no attending BGMs. The democratic organizations, they have BGMs to nominate candidates. Others, they are appointed. You know, so democracy works differently this side. So those things, honestly speaking, they can make or break a decision of a minister. And the reason why those who came before us, they would have said a department will need a legal department or a legal section. It's precisely for this thing. When the minister says, this is the decision we are taking, legal should be able to say, Minister, on this one, I think let's rather do it this way. Because the opinion we have is that we'll fall short on this one. And, you know, that's what people who came before us, Advocate, could have thought that we need a legal department for. Here, the assumption or the reason that we have given in the slide as the first, is that route A, your route A, that there was no quorum, Minister. My thinking is that that might not be true because we don't know what is the quorum of NSFAS. What we know from the 17 subsection 2 of the what is called that, the NSFAS, no, not the act, the book, the charter, the NSFAS charter is that at least we know the minimum people who must attend there are 3 EXCO members. And Section 13, subsection 3 indicates, of the Act, indicates that the quorum is set by the board. So the board would have set a quorum. And if you don't know what that quorum is, you will not be able to go out and say there's no quorum. And this quorum, according to the NSFAS, it's achieved in 2 parts. The first part is the EXCO members. The other one is in terms of numbers, which we have not established. While even this meeting, we have not established what was the quorum there. So legal of the department must assist the minister, Advocate Kuta. We should not, and Honorable Souls asked you, are you saying this board then did not have the legal rights to be a board? You said yes and no. Yes, because they are there, but no, because they don't meet quorum. And we know that was not correct. So we will meet sometime maybe next week after one of our meetings. We have a joint meeting next week, Wednesday, with Public Works as a result of the oversight we had in at the beginning of the year about Public Works not giving TVET colleges, CET colleges, and universities these buildings that we're renting from. I mean, we're supposed to be, we say we don't have money to fund education. We've got building, but we want to take money from this education institution. So why even that man? Maybe after that meeting, it's a joint meeting, maybe after that meeting, we'll have our in-committee meeting so that we then decide, we take a resolution on what we have established there. But I think what I've decided to speak about, Minister, these are, for me, the basics that we must all agree that they should not happen again moving forward. You know, the relationship, you can tell, between the minister and the board is not really good. And maybe it's because we had 28 meetings in 1 year between yourselves. So you are meeting too much between the minister and the board. So we must work around these things. I think because there are professionals there. You know, there's 2 doctors and 1 advocate there who came here today. There's other advocates on the line and all of that. And other people, very serious people. You'll remember that the advert said minimum masters. So everybody would have went there, serious professional or academic, and we must try by all means to preserve what people have worked for, the reputation of people. So we don't want this thing that you know, there's this fights, unnecessary fights between the minister and people either in councils or boards of our entities. We must try by all means and find amicable solution. I'm a proponent of peace. I know sometimes I'm not looked at that way. People see something that I don't see in me. They believe that I'm probably this monster, but I'm a very peaceful person. Very peaceful person. So I believe in having cordial, not the peace of chiefs, no, the other one. No. I've got plenty of that, except the one of chiefs. So that's how we're going to close this team, members. Minister, what we want is that you guys are going to court on Tuesday. On Tuesday, the 2nd, 2 June. Yeah, on the 2nd of June. All the best to all of you. Whatever decision, no, Parliament doesn't take sides. Parliament listens to facts. We don't choose. You know, the office of the minister, they want to put me under pressure. They say I must choose. So, well, all the best. We hope that when the court makes a determination on Tuesday, we'll all accept. And then what is important, and this is the message, Minister, that would ask you and your team to communicate, is that this governance situation we find ourselves in will not affect students, will not affect people, the beneficiaries. On the 25th and the 31st, when we're supposed to, when students are supposed to get their allowances, they will get them. If they don't get them at the end on Sunday this week, well, maybe they'll get it today because it's the 29th. But if they don't get it today, then we're going to create a big problem in the society, that these governance problems are the ones that are creating these problems. We are extremely worried about that 2024, 2025 ages report, because it says almost 15,000 people had defrauded the state. That's what it says. More than 15,000. They may have not worked alone. They may have worked with some people inside NSFAS. But more than almost 15,000 people defrauded the state. And not only that, they closed doors for about 15,000 poor people who deserved to get funding, and they did not get last year. It also says there's more than 822 deceased people who are receiving funding. As we speak, they are receiving, we don't know whether it's full funding or it's only allowances, which is a big problem. These are in millions of rands, hundreds of millions of rands, DGC. It's a lot of money that we should be giving it to deserving students. I know there were comments being said here about people coming with their views on what must happen to NSFAS. The president during SONA did indicate, even 2 weeks back when he answered the question of Honorable Khabo, that we're expected to submit a comprehensive student funding model so that it can be approved, DG. That funding model, comprehensive funding, is extremely important. We have commissioned a number of reports. Earlier on, Minister, you were responding to Honorable Lonzi, and you made a mistake. You said it's a higher commission. It's actually the Prof. Balim report that speaks about cutting NSFAS at TVET colleges. It's Prof. Balim's report that speaks about that. So we do have these reports that we have commissioned, DG, but we're not implementing them. And it creates a problem. You see, for me, if we had decided to say, NSFAS, TVET has got 200 and something thousand students this year. Probably, I don't know how many last year, but we say we start with this one. So maybe let's try and implement part of this, the Balim report. And I can tell you, would be far by now. My view I know that some people advise me not to say this thing, but my view is that, Minister, we might be dealing with organized criminal networks. They're stealing money from NSFAS. Very serious. Because let me tell you, if a person dies, the banks have got, you know, at the bank, you know, almost when they verify you, you put your fingerprint. They've got this biometric system that is linked to the Home Affairs that confirms if a person is alive or dead. So when we lose money from NSFAS and it goes into a bank account of somebody who's deceased, you must know that thing doesn't happen by mistake. Banks in South Africa with their technology are way too ahead. I made an example the other day, Minister, that when I went to Botswana for SADC education protocol in March this year, the SADC wanted to give me SNT. No, SNT. And when they wanted to send me SNT, my bank, because it was in US dollars and it was coming from Namibia, my bank closed it. And I thought, no. You know, Honorable Lonzi, tomorrow I'm going to a funeral. Ne? And in my township, when I go to a funeral, they like giving me guns to shoot. So I don't know whether I'll be like your president if they give me a gun. You know. But so banks are like that. Banks knows. They've got these defense mechanisms to protect both themselves and yourself. So these people, when I say they are organized, it's because there's no way money can go into 800 people's accounts and the bank doesn't know. And if these people are deceased. Actually, you might find that this NSFAS money actually goes into one account. But the bank wants to know the source of your income. So the banks would have said, this money, where does it come from? And there they will see it says NSFAS. They've got other clients who are NSFAS who are getting 1.7 per month. Why is this one getting 170,000? The banks will naturally ask. But because they are organized, they might be working with somebody who every month their job is to turn off that red button when it comes on this account. And when we say, Minister, we must fix NSFAS, these are certain things that we must go and look at. We want to understand, how does this thing happen? Let's do let's bring in a serious security cluster in this country to go look at these things. Because it's a worrying factor, this thing there. And it might be done intentionally to collapse it. Because this NSFAS, by the way, has produced more than 5.5 million graduates who ordinarily will not have seen the doors of learning and culture, let alone to graduate. So this NSFAS has produced almost 6 million poor people from villages, far-flung areas, and townships. It might be, this might be one of the success stories of this government. And therefore, it might be, people might be wanting to finish it. Because why would you want, if you are against the progression of certain class, why would you want a vehicle that produces so many poor graduates? So we have to deal with those things, so Minister. We need to attend to them. We might need to look at, security cluster, looking at that particular issue itself with proper accounting people to look at this thing. So I want to thank you, members, for you wanted something, Honorable Lonzi?
Before you close, Chair, I thought you will come back to us to do the
Okay.
usual quick round. No, just quick things. I think, Chair, maybe we'll process them through Anele because they are important information that we said we want the board to submit based on the submissions that they're making as well as the department. Because we also, because some allegations were made here about Florence, who called the board members and said that minister wants to appoint this CEO and that. And then there were some text messages and calls, and also I think we need the members, the board members, to submit all of those details. And then the last point, I want to check with the other board members who are present in the meeting, because I agree with Honorable Joy that we may need to sit, and you've also agreed, thanks, Chair. We're going to need to sit a meeting of our own to understand how do we get to the bottom of truth in a recordless meeting. And by that, part of that would be to try and contrast the different versions. So I wanted to then check with the other board members who have not spoken, so that we don't make an assumption that the one board member who has said that the minister gave them an unlawful instruction not to proceed with the appointment and automatically assume that all the board members who are present in the meeting agree with that. So I wanted, as a parting shot from my side, if we can go through very quickly to each of the board members to confirm if they align with this version. And then that's it, Chair, and then I'll be happy. I'll send my questions to Anel.
Okay.
Just a smaller clarity, Chair. The reference that was made to Ms. Florence Masebe, it's actually not the person who called. Her name was dropped or was mentioned in the conversation. I just want to clarify it that at no point did I receive a call from Ms. Masebe.
Yeah, there was a name dropping issue. No, I'm told somebody also, Minister, somebody was also name dropping my name and yours, so this issue of name dropping is it's common. But they agree that because if they did not agree, they would have said no. But you agree with the version that
Yes, no, yeah, we've agreed, and we've submitted also the affidavits to that effect for a court case.
Yeah.
Thank you.
they all of, including you.
Yes, Chair.
Yeah.
We do
and
agree.
There's Advocate Lavan. He also agreed with that version.
To all present, correct. I also agree to that version. Thank you.
Okay. No, thanks. Honorable Maimela.
Thank you, Chair. I think.
Sorry, Honorable Maimela. Portia's iPhone.
Chair, I did earlier on agreed with what Advocate Ramaswamy had said.
Okay. No, thank you. Just wanted for Honorable Lonzi's record keeping to hear you guys say it. So everybody has agreed to that effect. Honorable Maimel, I'm sorry I had to cut you short there.
No problem, Chair. I think in addition to a discussion or a reflection on how we move forward from this meeting, I think we might also like to use that meeting, as Honorable Karabo had said earlier, to discuss how we conduct our question and responses or engagement sessions, so that we don't do the same thing we did to you earlier, where we wanted to different things and how we approach the session. So I think we might also want to add that. But Chair, I also want to request that as we request the written responses, we might want to write to the people who have mentioned, especially the board members, the former board members. I'm not worried about the other person that was mentioned. I'm worried about the person who was directly a part of the process. The other board member to say these were the allegations. We'll go on record to say exactly what was said and get a response, a written response, their written response, even if they don't appear, so that when we do have that engagement, we've got a full picture. Lastly, I know that Honorable Advocate Ramesh, I've been saying Mr. Apologies, Advocate. Advocate Ramashia said something about Mr. Masocha, and it was so. I just want that what he mentioned. If he said it's a WhatsApp text, and it says something about Mukoni, and I wanted to get clarity. So that I can write a written question on that message. If you can just the exact words that were used in that thing, so that I can write a question. So for written responses on that question, on that message.
I think he might have said Moshabi, I don't know. Advocate.
Chairperson, it's actually none of the two. The text reads Moshate.
So you are from the royal space.
You're just being generous and elevating me.
Okay. You heard that, Honorable Maimela, right?
But the message in all, I just the message, because it was a short message. If you can indulge me, Chair.
What I said in relation to Mr. Masoa is, on the 28th of March, I missed a call from him around 12:55. I text back, leadership, I saw the call. I'm a bit under the weather. May I please call you back tomorrow? He responds, Moshate, can I please steal your 2 minutes to brief you briefly about my issues? I'm just a messenger and due to meet the principal shortly. Thanks, this was at 17:59. I didn't interact, and then the last time he came back was on the 20th of April, 8. Do you have a moment? If you have got a moment, kindly bounce back. Thanks. Show leadership, I will later. Then I called him for a call that lasted 3 minutes at 17:52.
Okay. No, it's fine. Moshate, we appreciate. Honorable Msezane.
No, thanks, Chair. Maybe, Chair, from my side, it would be for us to get a written response from the Minister or from legal Advocate Uta regarding the legality of a minister calling a meeting, a formal meeting without any records. Would want a response, a written response from her as a legal person, but also from the minister having strict guidance in terms of legislation, or if that's how they conduct their formal meetings. The concern really, Chair, is about how do we then account for the legal, for the public funds that are used in these meetings if they are not recorded. So it was mentioned by the minister that they do conduct such meetings where they don't have records. So it's very concerning. So would want to really get a response in writing in terms of that. Thank you very much, Chair.
Yeah, no, it's fine. We, like I said, on Wednesday we'll have our in-committee meeting where we will develop a number of questions. Well, firstly, we'll agree on how we are, what will be our view on what happened here. And then the number of questions that we'll agree on in that meeting, the in-committee meeting next week, Wednesday, we'll then write to the department and the ministry to respond. So there's no need for them to respond now. We will take that decision as a committee on our own, and then we will then write to yourself. So want to thank you. I know some of you are rushing for your flights. Want to thank you for coming. Board members, those who are here physically, we really appreciate. You know, time away from family. I know, you know, Taramashaya from Limpopo, you'll say, you want, NSFAS doesn't want to leave you, you know. It brings you to Cape Town. So yeah, want to thank you, travel safe. I know you are away from your families. Media people were there, who were here today. Thank you very much, we really appreciate. And I hope that you, when members were speaking, you got their best angle. You know, we covered their best angle. Yeah. You are following these things. Members, DG, thank you very much. You are pleasantly quiet today, DG. At least you did not tell me about 40 years. That's where the pleasantly comes from. You know, when you tell me about your 40 years experience, you know, and then, but I knew that today we are going to have a good meeting with you when at the beginning you said I must speak to the mic.
Yeah.
Yes.
No, I think you forgot on behalf of the committee, to thank the minister for not sending us to Google and Encyclopedia to know and understand what concurrence means. So we want to thank you for that, Minister.
No, the meeting stand adjourned. Thank you very much.
Long live the chair. Bye-bye.